Good morning, Judge Mulasehi.
Good morning, Chief Justice.
How are you this morning?
I could be better.
And is the reason why you are not better with us? Are we the reason?
In a sense, yes.
Well, that doesn't tell me you are happy to see us.
No. It's the greatest pleasure and a privilege to come before you. It's one of those few privileges.
No, thank you. Let me begin by welcoming you on behalf of all the commissioners and thanking you for availing yourself for this interview for the position of Deputy Judge President of the Labour Appeal Court and Labour Court. I will ask you some questions and commissioners will ask you questions, and the questions will really be aimed at establishing how you fare when we look at your record and track record, as well as the selection criteria that this body has adopted for the selection of judges. We may be robust in our questions, but nobody intends to treat you with disrespect or to humiliate you in any way. All the questions will be aimed at assisting us to make a proper assessment of your candidature. You do understand that?
I do, Chief Justice.
Yes. Is it the fourth time that you appear before the JSC?
It should be the third time, first Labour Court, High Court, and this time. Oh, no, this is the fourth time.
Yeah, okay. All right. Do you hold the following degrees? BA Law from the University of Lesotho, obtained in 1983, LLB, University of Wits, 1986, LLM, University of Georgetown, USA, 1990.
Yes.
Yes. Your LLM, was it a dissertation LLM or was it a mini dissertation and some courses?
It was courses and mini dissertation.
Okay. What was your mini dissertation on?
It was on...
If you can still remember.
I can very well.
Yes.
It was on the law of strike relating to replacement of strikers.
Yes. Okay. Now, you have been very involved in labor disputes. I know that you were involved in IMSA, is that all right? Is that correct?
That's correct, Chief Justice.
As a mediator. And an arbitrator as well. I know the mediator part, but I don't know about the arbitrator.
No, I also was involved quite in arbitration.
In arbitration,
yeah.
Yes. And that was in the 80s? Or early 90s?
Early 90s.
Okay. Now, you did do articles, didn't you?
Yes, I did.
Yes. And did you get admitted as an attorney?
No, I didn't.
You didn't?
Yes.
Okay. But you involved yourself in basically labor dispute resolution processes and organizations.
Yes, and I did a stint as a lecturer, both as a research official at the Center for Applied Legal Studies.
Yes.
And I lectured also at the Vista University.
Yes. And at a certain stage, you were appointed as the National Director of the CCMA, is that correct?
That's correct.
When was that? Which year was it?
It should be 2001.
Yes, and you held that position until when?
I held that position for 3 years.
Yes. Well, was that the term or was that short of the term?
It was short of the term. The initial contract was for 5 years.
Yes. And what happened that you didn't finish the 5 years?
Chief Justice, I've always been a process man. And one of the discussions we had with CCMA right from the beginning was, am I going to be involved in process or am I going to be involved in administration only? The chairman of the board was very firm on that point from beginning to end. And as time went on, I felt...
And what was his position or her position?
I beg your pardon?
What was his or her position on what should happen, whether it should process or management or...
It was the chairman of the board of the CCMA and the board itself, in fact. They felt that there were lots of problems at the CCMA at the time. And their view was, if the director gets involved in processes, arbitrations, and mediation, you're going to lose focus on the administrative job. And I think for the 3 years, I did what I could do best, which particularly was to ensure that we get a clean record, we stabilize the organization.
Yes.
And once that was done, I felt I've done what I meant to come to do, and it was time for me to go back into my practice.
So when you say you are a process man, are you talking about doing mediations and arbitrations?
Doing mediation and arbitrations, and also that time I did a fair amount of commissions of inquiries in various sectors. One of them being in the hospitals in Gauteng, a number of hospitals. I also did commissions of inquiries in the mining sector, in Phokeng in particular, the conflict between the Sotho-speaking people and the Tswana people in the area, and I did also commissions of inquiry, particularly for NUM in the Velcom area.
Now, sometimes people use commission of inquiry loosely. The normal sense in which the term is used is statutory commissions of inquiry, such as a commission established by the president. And I think in terms of our constitution, premiers are also able to establish provincial commissions of inquiry. But I'm not aware of anybody else who has the power to do that. So when you talk about commissions of inquiry, are you talking about those types of inquiries, or are you simply talking about a body that is put together even in the private sector to say, can you inquire or investigate the following issue and give us a report?
I don't think there were statutory appointments, but the hospital one, I was appointed by the MEC for Health. And I did a commission of inquiry into the violence in the Katlehong, Katharas area. And there again, I was appointed by the MEC for police, but I don't think it was statutory. I think it was the usual general appointment into investigations.
Yes, okay, all right. Now, because you have been nominated for a leadership position in the Labor Appeal Court and Labor Court, I think it is important to look at what the challenges were in the CCMA when you were appointed as National Director, and how successful you were in addressing them during your 3-year term. Would you like to deal with that?
Yes, I could, Chief Justice. Well, very briefly, one of the challenges that CCMA faced at the time was stability within the organization. There was tensions and conflict between management and staff, more particularly the union that was then representative of the commissioners. The other issue that fueled tensions in particular was the time frame within which arbitration awards were supposed to be issued. In terms of the Act, it provided for 14 days. And when I joined, the number of delayed awards was very high. And that was one of the tasks that was given to me by the board. And as I said earlier on, the issue of accounting and finances, management, administration in general, were those issues that I had to deal with. And very briefly, in terms of dealing with the delayed awards and the commissioners' ability to perform what they were supposed to perform, we had put in place several training programs that I think assisted quite a lot, because after that we saw a literally drop down in the issue of delayed awards.
Okay. And then you were appointed as a judge in the labor court. That was during my time.
Yes,
Is that
indeed.
right?
Yes, indeed.
Was that in 2007?
It was April 2007. I started acting in December
Yes.
2006.
Yes.
But I had acted also earlier in 2001, I think, for one term.
Yes. Okay, all right. You obviously enjoyed your acting stints because you later availed yourself and you were appointed.
Yes, I did indeed.
Yes. And were you initially appointed for a 10-year term?
In the labor court, yes,
In
I
the labor
was.
court.
Yes.
Yes. And did you finish that term of 10 years or not before you went to the High Court?
I think I may have finished it, or I was about to finish it. If there was time, it would have been a few months before I finished it.
Yes.
But then, yes, and then I did indeed apply to the High Court.
So by the time you were appointed to the High Court, you had extensive experience as a judge of the labor court,
Yes, indeed.
having served for about 10 years.
Yes, indeed.
Yes. And do you remember when you were appointed to the High Court?
The High Court I acted in 2016. I think I may have been appointed either towards the end of that year or 2017.
Okay. So that's where you have been for most of the past, 5-7 years?
I think
No,
I'm now
5
going.
years.
I think I'm going just above 6 years.
Yes.
Yes.
Yes. And during this period of 6 years, how much labor work have you done, or are you rusted?
In terms of sitting at the court, no, I didn't do any labor cases. I haven't done any labor matters.
Yes, but obviously you have been accumulating other experiences in the High Court.
Yes, indeed.
Yes, and how did you find the High Court, having not practiced as an attorney or advocate initially, but having spent quite some time in labor dispute resolution organizations and processes, and having sat in the labor court for about 10 years?
Well, initially I was very doubtful of the decision to go to the High Court. I was very scared. But I was influenced particularly by J.P. Mlambo to say you would rather have a broader understanding of the law. And but I got in there and I hit the ground running. Very soon I got thrown into cases, and for that matter I was sent to Pretoria, which is got a very heavy load and quite technical cases most of the time.
In the High Court, have you sat in have done criminal trials
I have done criminal trials.
and criminal appeals?
I have done criminal appeals.
Obviously, motion court and civil appeals.
I've sat extensively in motion courts.
Yes, but of course you were used to motion court from the labor court. It's just that it was labor, but otherwise you were used to it.
Yes, indeed.
Yeah, and you have now made yourself available for the position of Deputy Judge President.
Yes.
Have you acted or served as an acting judge of appeal in the labor appeal court?
I have recently just sat in the Labour Appeal Court in the past term. But before that, no, I had not sat in the Labour Appeal Court.
Yes. Oh, okay. Now, would you like to share with the Commission what challenges you know to exist in the Labour Court and Labour Appeal Court at the moment, and give us an idea what you think should be done to address those challenges?
Yes. Well, the first key issue in as far as the Labour Court is concerned and the challenges there relates to facilities. We occupy 5th and 6th floor. We should be occupying another floor because the space is limited. We have 5 courts, which often it so happens that sometimes you find that cases allocated do not accommodate the number of judges that are supposed to sit, and judges have to sometimes wait for one judge to finish in one court to be available for that court. So one of the biggest challenge is the issue of facilities, which I've started working on with the JP and the office administration. We're hopeful that we will secure another floor to increase the number of courses, the number of courts, and the number of offices. I mean, if you look at the office where the registrar operates now, you would not be pleased. It's just a small little corner, very congested. The other issue that faces the Labour Court is the backlog. We have a huge backlog. And when I joined in, we had a discussion with JP and other judges and said, how are we going to deal with this? The one area I immediately identified was the pre-enrollment cases, which before they reach the final stage of reaching a judge, has to first be assessed, determined, and the judge certified, and all those processes. And we then entered into discussions with SASLO, which, quite to my surprise and happiness, but was that they immediately offered to come and help with pro bono. Initially, the project was meant to invite 2 practitioners a day, but they ended up giving us 4, sometimes even 5. And that project, we had intended it to take for about a month and a half. We finished that process in 3 weeks, complete. And then the next stage was then for a judge to then receive those files and then look at the files and see whether they are indeed ready for to be certified. I took a decision taking into account another point that I will talk to, which is the issue of delayed judgments. That I'd rather make my time available, and with the agreement with the JP, I then allocated major part of my time to actually working on those files. And that included also in Durban, where we had the same problem. I went in there also and I said, I will do. The time will be done, the process will be done by me. As we speak now, in Johannesburg, we've done almost 500 files, and I have left with about 150, 200 files for me to finalize in terms of certification. And that process has moved on quite smoothly. And the one value to that, which pleases me, is that when parties don't know what's happening to their matter because they're locked into not being allocated, you get complaints. And so once we had started notifying parties that we now have enrolled your matter, though very long ahead, which is next year, we suddenly see a drop in the complaints, which to me suggests that once somebody knows what's happening in their case, it tends to comfort them. It may not satisfy them, but it tends to give them some confidence that something is happening in their matter. Now, one of the other things that creates a logjam in terms of cases moving forward it's interlocutories that get filed. There was a huge number in the interlocutory. We had a discussion and we were actually approached by the Johannesburg Bar Association, and we had a meeting with them, judges and the JP, and they offered to assist us with the pro bono work. And thanks to the minister, also agreed and approved the appointment. The program has been going on now for the last month, 2 months. I can also indicate that in as far as that backlog is concerned, we almost at the top of the back of that problem. In fact, we are now even looking at using some of the pro bono judges to do for us reviews that we think needs, because often people would also request expedited dates. So we're also looking at using that. The other issue is the issue of judges. We have 13 judges. They're far, far below what the requirements and the needs of the service provision is concerned. In terms of staffing, I would say that there are certain shortages that we need. We've looked at that, and I think we've made certain proposals to the OCJ and the provincial management. And the other thing that has happened in, as I say, with all the backlog problems, is we've received very positive support from the profession, both in terms of the attorneys and the bars. We've had a meeting with the Johannesburg Bar. We've had a meeting with the Pretoria Bar. We also have now received an offer for support, also assistance from the KZN Bar. Yes, those are things that I think I've had to look at. The challenge that now faces us, when I thought we really going to be putting more in terms of trying to address these problems, is the issue of cost cutting. We've received instructions as to how we should go about it. I don't think it's a train smash. We are committed, and I personally would work hard to ensure that the cost-cutting measures are implemented, but at the same time, that they do not totally undermine the service provision that people would want. If I am successful, one of the areas that I would want to look at is firstly ensuring that I work very closely with the profession. I would want the court to work very closely with the bar councils, with the LSC, BLA, DLA, SSLA, that we can then move, particularly in the context of the cost-cutting measures. Yes.
Now, the position of Deputy Judge President of the Labour Appeal Court and Labour Court means that if you are appointed, you are number 2 in the Labour Appeal Court and Labour Court, and there are huge responsibilities on that leadership, leaving aside the issues of administration. But looking at the development of labor law and creating the labor law jurisprudence for this country, because most of the jurisprudence of our labor law has got to be developed by the Labor Court and Labor Appeal Court. Therefore, it's important that somebody who gets into that position is somebody who is alive to various issues of labor law. You agree?
Yes, indeed.
And can play a meaningful role in leading in the development of our labor law.
Absolutely.
You agree?
Absolutely.
Yes. Now, do you want to share with the commissioners what the challenges are in terms of the jurisdiction in relation to labor matters between the Labor Court and the High Court? That's a topic that has been controversial in a long time. I just want you to show that you are alive to different schools of thought and views. So if you are appointed, you are aware of what the issues are. Do you want to share with the commissioners your views on that?
Absolutely, Chief Justice. I'm quite alive and aware, and I think the jurisprudence to some extent has now been fairly settled in a sense, and that started with the Chirwa matter, where an employee of the Transnet brought an unfair dismissal before the High Court, and it went backwards and forwards. But the decision was that once she had elected to formulate her relief in the form of an unfair dismissal, that would fall under the jurisdiction of the Labor Court. But there's a general principle. The basic principle is that the jurisdiction relating to labor matters fall squarely into the jurisdiction of the labor courts, both the labor court and the labor appeal court. In as far as civil matters are concerned that are labor related, those matters would be covered by the Basic Conditions of Employment Act, Section 77. That's the section that gives the Labor Court concurrent jurisdiction with the High Court.
Yes, what I wanted you to do is to say, those who believe that this type of labor matters should be, can be dealt with by the High Court, this is their argument. And those who say it should be the Labor Court exclusively, these are their arguments, those schools of thought. Basically, in relation to when you talk about public servants who would say this is administrative action or raise other constitutional issues and say, therefore, the High Court has got jurisdiction, and others say, but no, in essence, this is a labor matter. That's the kind of thing I was wishing you to reflect on.
Yes, I'm not sure whether I follow the question, but if I may try, as I understand, in as far as public servants are concerned, the issue that may arise is whether the conduct of the employer in terminating or doing anything related to labor would fall under PAJA or would fall under the Labor Relations Act. And there are a number of cases where employees in the public service would institute their cases in the High Court under the auspices of saying it is an administrative action taken by the employer and therefore it must be dealt with at that particular level. The issue of whether the case would be covered by the jurisdiction of the High Court, as I said, it's largely the question of the formulation of the relief that an employee would be seeking. If he seeks a relief in terms of unfair dismissal, then that has to fall into the jurisdiction of the Labor Court. If he seeks it as a civil contractual basis, then it will have to fall into he's got a choice. He can either bring it under Section 77 or she can bring it under the contractual law.
And there have also been a lot of controversy about the application or applicability of prescription act in labor matters. There have been different views. Do you want to share with the commissioners what the latest position is on that? The application of the prescription act
Yes.
to, for example, unfair dismissals. You remember the Prescription Act would say you must institute your action against the other party within a certain period, like 3 years. If you fail to do so, you forfeit your right to pursue an action. And then in the Labor Relations Act, there would be other time frames saying you must refer your unfair dismissal dispute to the CCMA within 90 days, or is it 30 days? And then after that, if it's not resolved, you must refer it to the to arbitration in the CCMA or bargaining council or to the labor court within a certain period of time. And then there's the question of these two streams, the Prescription Act setting a certain period this side, the LRA setting other time frames. You might follow the time frames in the LRA, but for some time you stop taking further steps, and the 3 years lapses. That's what I'm talking about. Are you familiar with the various arguments in regard to that?
I am aware, but I would say I haven't read the very latest in terms of that. But my recollection, firstly, let me deal with the labor relation time frames. In as far as that is concerned, the time frame prescribed under the Labor Relations Act, if you fail to comply, you can always bring an application for condonation. Whereas on the prescription side, once the 3-year period has dawned, that would be the end of your case. But in as far as I have read, and the one judgment that I read was a judgment in the High Court by Judge Windale, and it was brought in terms of, it related to an unfair, and beg your pardon, it related to a dismissal. But they brought it in, a prescription point was raised in that contractual relief which was sought. Now, in the labor court, the debate started with the case which was dealt with by Judge Rapken Naika. All of us used to follow the approach that said prescription is prescription even within the labor court. All what you need to look at is, well, firstly, the debate was whether an unfair dismissal is a debt or a dispute arising or referred by the CCMA is a debt or not. And the agreed, or the approach adopted by most of the judges in the labor court was that indeed it is a debt, and therefore when you calculate the 3-year period, you've got to calculate it from the time that the debt arose to the period of the 3 years. Judge Rapken Naika then brought in and said, well, you've got to look at the context of the Labor Relations Act. And I think she said that that could never have been the intention that unfair dismissals would prescribe. That's as far as I can take it, Chief Justice.
No, that's fine. When you get a chance, do look at some judgments in the Constitutional Court on the issue.
Okay.
At this stage, I'm going to allow the Judge President of the Labor Appeal Court and Labor Court the opportunity to put questions to you. Judge President.
Thank you, Chief Justice. I think you've covered most of the issues, but I have a few questions for you, Judge. First, I see there was 2 omissions in your particulars of employment. You forgot to write in there that you were a judge in the labor court for 10 years. A glaring omission.
Yes.
And the other was that you did, in fact, act as a DJP before this stint. You have acted before.
Yes, I did in 2019, I think it
That's
was.
right, yeah.
Yes.
And then you were asked to stay on, but something happened and you couldn't stay on, I think.
Yes,
remember
I had a personal commitment.
That's right, yeah. Now, there is a clause here, not a clause. You've said something that your appointment might cause some kind of embarrassment and you would want to address that. I think let's get that out of the way. Everyone's anxious to know what is that. And if it is what I think it is, I don't know if it's an embarrassment at all, but please address that.
Yes.
Sorry, can everybody hear? Please raise your voice, JP.
Sorry about that.
Yeah.
The question is, in his questionnaire, there was a question there which relates to, is there anything that might cause you embarrassment, the appointment? And his answer was yes, and he will address it here. And I thought maybe it's time we asked him, what is this? And if he could tell us what is this embarrassment he's talking about.
No, thanks, JP. Yes, I did that, and I still feel a bit embarrassed that I actually included that in my application. I don't know how it came about. I have nothing. I will put myself open to the public. I've got nothing to hide, and I don't think there's anything that can be said that would embarrass me. The only explanation of that error is I probably was working on 2 documents, and as you can see, it looks like I copied and pasted, because that sentence that says, I will address you for an hour, it's clearly something that comes from your usual practice note. If you look at practice notes, and as I say, I suspect I may have been working on the application and I may have been working on another judgment, and somehow, but as I say, I would really plead to say my apologies for that. It's quite embarrassing.
Thank you, Judge. I thought that was the case, and that's why I thought before everyone's thinking, what could that be? Let's get rid of that part.
Thank you.
Now, Judge, you spent all your life before you becoming a judge, trying to participate, create rules, or got involved in agencies whose principal aim was to ensure that a dispute is resolved through mediation. That was 20 years of your past life till you became judge, and now for the last 16 years you're a judge, where mediation plays no role at all. It's adjudication. And are there times where you feel that you should get out of here and go back to the field to mediate disputes rather than sit and deal with issues on the level of adjudication?
Not quite, and just to say, in as far as mediation is concerned, the last question I was asked when I applied was to the Labour Court. I'd never forget that question when it is put by one of the commissioners to say, are we not losing you from the mediation, and you've been so centrally involved in some of the big mediation cases? I took a decision to say, I think I wanted to contribute into the adversarial system, unfortunately or fortunately, and I really had a passion of saying, getting into adjudicating dispute, it's a major contribution that I personally could make. But I still subscribe to mediation. I have participated in the FMC where this issue of mediation was discussed, and I think I made the contribution from the experience I had on mediation and design of dispute resolution. Because if you see my CV, you'll see that I was also involved in community dispute resolution. We designed a dispute resolution for the community. And so I still have that passion. Time permitting, I probably would want to get back into it, but at a later stage, not now.
And I raised this in the context of, I don't know if you are aware, but about a few years ago, there was a major dispute in the mining industry. And it was getting so bad that we were getting urgent applications from one side or the other, 2 a week. You know, if the employer wrote one on Monday, by Thursday, the employee would bring another application. And this carried on for a period of 3 weeks. And then Judge Rapkin-Naika thought, this is enough. She told both parties, I'm going to mediate this dispute between the 2 of you. I want to see all of you. I'll come there and we'll resolve. A number of attorneys' firms put up their hands and said, this is not acceptable. What comment, if any, do you have?
Yes. Well, JP was actually still at the labor court at the time, and we had discussions, particularly at tea, as Judge Rapkenaika was telling us what she planned doing, and I was one of those who supported it. And I think if you were to analyze that process, it actually brought a successful resolution, and it reduced the tensions that were going on. If you permit me to deviate a little bit and give you another example similar to that, there was a strike by pub crew, I think, against the correctional services some years back. And what then happened was that pub crew developed a very interesting strategy in terms of litigation. They instituted action almost in every jurisdiction, which really stretched the state, but the state was also digging in terms of what it believed was correct. And I was brought in, and I called the lawyers, and I said, look, going on with this is just not going to help you. Shouldn't we put this into mediation? Agreed to mediate, agreed to go to relationship building by objective exercise. And funny enough, if I may say to you, till today, I still now and again get a call from some correctional service in Bloemfontein the other day saying, we see a document here which you developed. Would you come and do a relationship building exercise for us? That's like 15 years ago. So mediation and other soft dispute resolution processes like negotiation, facilitation, relationship building are key and very critical. I think you will recall that also when I was still at the labor court, I don't know whether that was still done, we had a good relationship with CCMA, where at times we would just approach them and say, look, there's a case coming up, could you please avail a mediator? And they would immediately avail a mediator, and we saw good success in those cases.
I was just about to come to that. Over the last few years, there has been a close relationship that I'm sure you're aware of between the CCMA and the Labour Court. So much so is that where a judge feels that this matter should go on for further mediation, that the director is informed and arrangements are made immediately so that mediation can again take place. And if it's not resolved, that the matter gets priority to be heard. And it's a relationship which is carrying on, and you have been following that, is that not so?
Yes, no, I'd support that.
Then the other issue is, as one of the curses of being in the leadership, if one can call it that, is the admin work overwhelms you, you know. And in the labor court, where, you know, we still haven't reached the, what we'd call the computerization that the Gauteng High Court has, where you come from. We're still far behind. And the good thing is that you were in the team, am I correct, that put in place in the Gauteng High Court a number of processes which helps not only speed matters, but it helps making the court more paperless. Judges can have documents on their computer at home. They can prepare the day before. I think it's called line something.
Case lines.
Case lines, yes, which is very, very helpful. And you've been party to that, is that correct?
Yes, that's correct, JP. In fact, I serve as a convener in the JAIT committee, which is chaired by JP Mlambo, and therefore I am central with all other team members in terms of the implementation of that system. It gave me, participation in that process gave me a good insight, not only in terms of how the system works, but I had found, and JP Mlambo calls me the ambassador of the court in case lines. I had found that my role as a judge not only influences your general staff in terms of buying into the process, but I'm also able to sell to other judges. And also when judges encounter problems in terms of the system, I'm an immediate contact person who can say, this is the problem. So yes, indeed, it's a system that I would ask to be given like yesterday, because one of the challenges that we have in the labor court is people taking files and disappearing with the files, and complaints about the file is missing and all those.
And is it correct that you are now dealing and trying to upgrade the labor court to get these things in line, including computerizations and having our case file, not case lines, but also cases managed so that we can have a good overview of what is happening at this time?
Yes, indeed. I can assure you that I'm still serving on JAIT, and definitely the next JAIT meeting is going to, they've already had a lot from me about why the labor court needs to be prioritized. Because also incidentally, just to indicate, if you look at the way CCMA works, if we were to digitize the labor court system, it would make life much easier, because CCMA now, all their records are already digital. So we just need to create a link between the two systems. And I know that the CCMA system fairly well. It's very pliable and very accommodative of linking into other systems.
Yeah, because one of the issues, and you must be aware of it, is that 80% of the work, not 80%, at least 70% of what the labor court does has got to do with reviews of CCMA awards. And the biggest issue there is getting the record, which is expensive and quite often unaffordable to the ordinary person. And what CCMA with us is trying to do is to make sure that when they have a recording, that the recordings can be automatically transcribed and linked directly to the labor court. Now, you have taken over the process with the CCMA. Are we doing any progress? Knowing that we have so many financial constraints, perhaps you can tell the committee on how far that is, or where are we getting? Are we getting there, in other words?
I'm not sure, JP, in relation to the CCMA helping us, or in relation to case lines?
No, in relation to linking up with the CCMA.
Well, until we have the case line, in fact, I must correct myself.
Yeah.
It should actually be, the system should be court online, because the system is a one solution system. The case line system, it's meant for judges. It's once the case is ripe for hearing, it moves to case line for the judges. But in terms of case recorder, court online is a system that starts in terms of getting your case number. It gets locked into the court online. Now, if we have that system, the court online system, the way I see it is that once a case has progressed to the stage where the record is to be availed by the CCMA, then the CCMA would simply upload the CCMA record electronically onto the court online. Or you could even take it to case lines, and that you will have the case in front of you. The useful aspect of this system, and initially there was resistance even from lawyers, but from my experience in the High Court, they all now want case lines. They're actually now resisting court online. They prefer case lines, the usual problem with the changes. But yes, once we have that system, it would best serve the labor court and the CCMA. I'm not sure whether at this stage you could be able to use well, let me put it this way. The CCMA system, had it been adopted earlier into the court, the labor court, it would have really helped. But I think now, my view is that to avoid duplication and complications, the court online system is tailor-made such that it can accommodate, for example, it has accommodated case lines. So it should be able to accommodate the CCMA case management into itself so that it can receive, you can then deal with the case in that way.
Thank you. I have no further questions, Chief Justice.
Thank you, JP. Minister?
Thank you very much, CJ, and good morning, Judge Mlahle.
Good morning, Minister.
Yeah, just where you you ended with the JP on the interaction between court online, case line, and also the CCMA. And obviously, I've heard that you have also participated earlier on the systems of receiving application. If you are appointed, how do you think you will help enhance this process or even fast track it to enable access and to deal with the backlog that you said you have? And it sounds like the JP shares the same view.
Yes. Well, Minister, as I've already said, that I serve on the JAID, and I take as a member of JAID, I have a direct involvement in that regard, and I would probably make the proposal. We've discussed it with JP, and he's always said we need the electronic case management. So from that point of view, my influence probably would be much higher in terms of persuading JAID and the JP Mulambo in particular to say we should be given the system as soon as it is possible. And yes, talking about how it would help with the backlog on cases and also on judgment writing in particular, the system is amazing. I mean, if you have files, 20 files, you simply take your laptop with you, and because judges work Saturday, Sunday, at funerals, at weddings, they always find a corner. I once saw a judge sitting in a car at a wedding, busy working and reading. So you have that at your disposal. Wherever you are, you can access the file. There's no question of a file is missing. There's no question of, if somebody removes, and that's another problem we have in the CCMA, in the labor court. Often you get complaints that people say, somebody removed a document from my file. You can't remove anything from case lines. You remove, the audit will show. You immediately just go to the audit, you click, it says to you, so-and-so entered the system, so-and-so remove this file. You are late in filing your document, and you think you can be smart and simply load it onto the system. As soon as you load it, whether the judge or the opposite party will click and see that, no, you failed to file your heads on the 5 days we were given by the court. You filed it only 20 days later.
So do you think that will also help to expeditiously dispose of the matters in the labor court, which is one of the biggest challenges facing this court in terms of delays, in terms of expeditiously dealing with matters?
It would, Minister, and in fact, I've had discussions with judges and JP about the use also of a virtual court.
Oh, despite the lack of a limited number of judges that the court needs, that the JP always raises with me.
Look, the shortage of judges is a serious problem. It does really need attention. Even with case lines, you would still need more judges. But however, case line would alleviate the problem, because also as JP or as DJP, you have all those things in front of you. In terms of case lines, it's got what it called the dashboard. You can look at the dashboard and see how are your trials allocated, what's in the motion court, how many files are there. You can work out the number of pages. You can be able to quickly see what is the real issue, because one of the challenges, and I think it applies both to the High Court and to the Labor Court, often you have a big file, and you look at it, you think, this is going to take 5 days. You allocate it for 5 days. It turns out the issue is very short, it's very small. The judge is done by tea time. And then you think,
lastly, CJ, I think on that one, I can't falter you. I can hear that you have really immersed yourself with the processes of re-engineering the court. My worry is that I can see that you are left with only 3 years to serve. Do you think you will be able to complete all this vision that you are telling this commission in this 3 years with with the JP in case you are appointed?
Well, Minister, I would say to you, if you were today to say by the end of this term, the court online system is now rolled out and Labor Court is given the system, I would say to you, I would come back to you by middle of next year and say to you, can you see the work that's been done? So 3 years would, in all probabilities, be able to address the problems.
Thank you, CJ.
Thank you. Commissioner Matolo Tlepu.
Thank you, CJ. Good morning, Judge Mlahle.
Good morning, Commissioner.
One of the you indicated that you have consulted with the profession, especially the attorneys profession. I'm quite pleased about that. But what I wanted to find out is that there's a lot of awards that are being reviewed from the CCMA. Is there any training, because it looks like the CCMA has lost a lot of, senior commissioners. Is there anything can be done to upskill the new commissioners who are there? Because sometimes the awards that they give really sometimes ridiculous.
Yes.
So I just wanted to find out whether is there any work in progress just to train them, to bring them up to speed.
Yes.
And also, secondly, let me just finish the two. The disappearing files, it's the disappearing of files. I'm happy that you have raised it, and because it's a concern to the profession. So I will really plead with you just to attend to that. Thanks.
Thank you. In terms of the awards and the training, there is a very close working relationship between the CCMA and the Labor Court. JP, from what I understand, meets regularly with the CEO of the CCMA. And recently, about 2 weeks ago, I received the report that JP had actually sent 2 of our judges to go and make a presentation at the CCMA. But if I may say from my side, I have actually discussed with judges. We have now agreed that we will have a committee that will deal with training. And I think training should not only be limited to the CCMA, but training that would also involve practitioners. Because my view is sometimes the tension that develops in court, it's because some of the practitioners don't appreciate where a judge would be coming from. When a judge engages in a debate and somebody just gets offended, and also how the whole system works. It's quite an important aspect. If I may indicate that on the 19th or 20th of October, we will have our training team conducting training at the Johannesburg bar. And basically that's what we'll be doing. But in as far as the CCM is concerned, as I say, as I understand, the training is going on, and therefore it's a matter of me having to look at it and see whether we can enhance the training and make more improvement in as far as that is concerned. Then the disappearing files. Yes, we've done a number of things to try and deal with disappearing files. There is a strict recordal system, and every time there is a report of a missing file, I always call staff to say, come, let me see what happened, who was the last person to look at the file. But the practicalities are such that human beings being human beings. I mean, there's an attorney who was found with a file in his bag, walking out of the labor court. Now, that can tell you may have, especially if it's a manual system, forget, you'll do everything in place to address the problem, but you will always encounter it. As I said, with electronic, you would be fully covered in a sense.
Commissioners, we have just gone over an hour with the candidate. I asked very comprehensive questions aimed at making sure that the candidate is able to share with you his attributes, experience, and so on to enable you to make up your mind. The JP also asked him very extensive questions. I say that for the purpose of simply saying, I've got 3 more commissioners on my list who wish to ask questions, but I say this to say, remember to only ask questions if the answer is supposed to help you make up your mind. If you are clear, there might be no need to ask questions, but if there is something that you need to clarify in order to help yourself, that's fine. But also in terms of our time, it's an attempt to try and say, in the morning, we tend to take longer, and then we regret in the afternoon. Let's try and sort and be short now. So those commissioners who have indicated, if you really feel that you would like to ask, I will give you a chance, but I'm just asking you on your own, Meromotu, to decide whether you want that. Okay. You want to speak or you want to? Okay, all right.
Chief Justice, I was a victim of not being added yesterday. So, on 2 occasions.
Yes, you see, those who don't ask most of the time, when they ask, I'm very sympathetic when they want an opportunity. So, colleagues, I've told you what I'm asking of you. Justice Molamela, if you still want to.
Yes, I still want to. Thank you very much, Chief Justice.
Okay. One question, okay?
Good morning, Judge Mlahlei. My question is, I would imagine that you would have had some discussions with the Judge President regarding a succession plan in your court. If you are appointed, do you have any plans of including female judges in the leadership of your court, given the fact that you and the JP will be, both of you will be male judges in the leadership position? So in terms of your succession plan, have you made any plans of involving female judges in the leadership or the management of the court in the meantime? Thank you.
Yes, indeed, President. The issue of women empowerment, it's a critical process. It's a process, as one of the Chief Justice, I can't recall who once said, it's a program that cannot be reversed. We are actually also working very hard, and we've discussed the question not only in terms of the leadership, but in the broader sense of ensuring that women are also attracted to the labor court. In terms of succession, JP is still there, and I think it's also a question of us having to also work with the profession, the professional bodies, and with the cooperation that we get. I think what we would want to do is to ask them to help us, starting to identify people who can come into the labor court as women, and also identify people that can be mentored towards taking the leadership position. But one of the points I would say is that the labor court has, since its establishment, never had a woman at the top. And that must be an indictment on us.
Thank you. I just want to mention that more than 13 years ago, the Labor Appeal Court and Labor Court almost had a deputy judge president who was going to be a woman, but the Constitutional Court snatched her from me. Commissioner Marumohai.
Thank you very much, Chief Justice. Good morning, Judge Mlahlei.
Good morning, Commissioner.
Mine is it's more of a substantive question. And I see that, I think in 2014, you wrote a judgment on restraint of trade. I'm not going to ask you in respect of that judgment, because I can see you don't have electronics and you cannot access that. It's not part of your packet, but I'm going to ask you a general question in respect of that. And this follows from the discussion that you had with the CJ. We see a lot of restraint of trade cases. Sometimes you'll find that the decisions are from the labor court, sometimes you'll find that some decisions are from the high court. And it seems like there is some jurisdictional nightmare in respect of restraints of trade per se. What I want to ask you is, what is the current law on the enforceability of the restraint of trade agreement in the context of unlawful termination of employment agreement? And the resolution thereof, which forum should be the forum for the resolution of these disputes?
Okay. If I may take the end of the question, as I understand, the restraint of trade matters can actually serve before the High Court and the Labor Court. The Labor Court is swamped with restraint of trade. At some point, I think the discussion between the JP Mlambo and JP Workley was that there is a need to also get parties to go to the High Court. Now, if you look at the High Court's approach in terms of urgent application restraint, the general trend there is that judges generally do not entertain restraint of trade as far as agency is concerned. And it seems to me the consequence of that has been for parties then to come, almost all of them, to the Labor Court. And yes, indeed, almost, in fact, every week, our motion court has to deal with the restraint of trade. The question of the law, if I understand it, in as far as the law is concerned, the jurisprudence is that the restraint of trade are enforceable as long as they comply with the basic principles relating to reasonableness and all those considerations. But in general, anybody is entitled to enforce a restraint of trade agreement.
Thank you very much, Judge. Thank you very much, CJ.
Thank you. Commissioner Steinberg.
Good morning, Judge.
Good morning, Commissioner.
Thank you, CJ. Judge, I see that a few of your judgments were set aside in the appeal court on the basis that you had misapplied the review test. I wonder if you could just tell us briefly what the difference between appeal and review is, number one, and number two, what is the two-stage test for a review?
Okay. In as far as the review is concerned, the test is whether the outcome is justifiable or reasonable. In other words, whether the decision made by the arbitrator is one that a reasonable arbitrator would have made. And in that regard, when you look at reviewing a case, you have to take into account the totality of the facts that served before the commissioner. And that means you've got to go into the record and read the record and understand what it all says. As some of the judgment has said, I think LAC, is that you don't, in doing that, pick up piecemeal approach in as far as assessing the reviewability of that award. In as far as appeal is concerned...
Sorry, Judge, could you just clarify what the two stages of the test are in the review?
Excuse me?
Would you mind clarifying what the two stages of the test are in the review?
What the two...
The two stages. The review is a two-stage test.
Yes.
What are the two stages?
I must be honest, Commissioner, it's just skipped my mind now. I'll come back to it. I know the two stages, but do you mind if I deal with the appeal and then come back to that?
Please go ahead.
In as far as appeal is concerned, what you're confronted with is to determine the correctness of the outcome. And that means you need to go into the merits of the matter to be able to determine whether the decision was correct or not. But I must just also indicate that in as far as reviews are concerned, you also have what Sidumo said, that in as far as the provisions of Section 145 is concerned, those provisions are infused into the reasonableness test that you apply in the review. I'm trying to think again about, my mind is just frozen about the two stages.
Well, what might help you is to tell the commissioner how you go about issues when you deal with the review, because maybe as you go along, the stages will be apparent. I don't know if I'm helping.
You are. If the appeal court finds that the commissioner, the arbitrator's decision is not reasonable, what happens then?
Well, if you find that the decision is unreasonable, there are two options available in terms of formulating the relief as a review court. Either you can determine the matter depending on whether the factual metrics before you are sufficient for you to can determine the matter. In other words, if the facts and the record reveals the decision that the commissioner ought to have or reasonably should have reached, you could deal with it in that way. Alternatively, what you may do is to remit the matter back to the CCMA or even the bargaining council for reconsideration of the matter.
With respect, Judge, in the Quest Flexible Staffing Solutions case, that is what you did, and that's what the appeal court said you misapplied. They said stage one is if you find that the commissioner's, the arbitrator's decision was unreasonable. There's still another leg of the test, and that's whether there is a relationship between his reasons and his decision. And if there is, then the review court can't interfere. It seems to me from your answer that you haven't taken that into account, despite this judgment.
No, I'm sure I didn't communicate it properly. My understanding of, and talking general, is that once you come to the conclusion that the decision is unreasonable, yes, indeed, you have to look at the facts and the reasons of the commissioner before you come to the conclusion, could you substitute or could you remit the matter back? If maybe I'm missing the point there.
So when you look at the facts and you look at the unreasonable decision, what is the question you ask yourself?
Is this a matter that should be remitted back to the commissioner? Do I have sufficient information if I decide not to remit to determine the matter? If the facts are insufficient, then I would then take the decision to remit the matter back to the commissioner.
Well, my understanding with respect is not whether the facts are sufficient, it's whether the relationship between the reasons and the decision is adequate.
Yes, that's correct.
Yes, and I think that goes to the distinction between review and appeal.
Yes.
You tell me why you agree with that proposition.
Because as I said, with appeal, you're determining the correctness of the decision. You're trying to determine whether in arriving at the conclusion, that decision is correct and you enter into the merits
Yes.
of the case. Whereas in the arbitration process, you're looking at whether it is reasonable, taking into account the totality of the facts, the material that's before you, whether that decision is reasonable. And as I say, if you come to the conclusion that the decision is unreasonable, the next inquiry you need to conduct is to say, with all this material before me, is this a matter that I need to remit back to the commission or not? If the material are sufficient for you to determine whether the dismissal, let's use that as an example, is unfair, then you may remit. But if you look at the material before you, which includes the reasoning of the commissioner, you can't ignore the award given by the commissioner, because your function there is not to determine whether he was correct or not. Your function there is to determine, was this reasonable? Having regard to the facts and the materials before me, I arrive at the conclusion that this matter is a matter to be remitted, or this is a matter I can determine.
Thank you, Judge.
Thank you.
Thank you. Commissioner Baloi.
Thank you, CJ. Good morning, Judge.
Good morning, Commissioner.
Yes, Judge, I'll ask my question. It's two parts. One is when you were speaking about the issues that the court is dealing with, and you mentioned facilities, you seem to speak only to the Braamfontein complex, and yet there are other branches of the court. Does that mean that you are happy and there are no issues in those other seats of court, Durban, Gqeberha, and Cape Town? That's the one part. You didn't say anything about that. The second part is an issue that we see here relating to acting judges. Is there anything in place? And if there isn't, what is your plan about acting judges as they come in, settling them, and some kind of orientation and a feedback mechanism at the end of acting stints, so that when they come back, they are better candidates or better acting judges? Is there anything in place? And if there isn't, what would you put in place for that?
Okay. Thank you. In terms of the facilities, yes, Braamfontein, the challenge is much more higher than the other courts. In Gqeberha, we operating from the High Court, which makes things much, much better. In Durban, there are a number of challenges, but fairly in terms of how things are running. We are in a building that has serious problems. I wouldn't want to underscore the life risks that we face. You walk into a corridor in Durban at night, you would be scared because you walk through mattresses that has been taken out of a hotel and placed on the corridor. It's very horrific. You have doors that commissioners cut their ropes because some protruding things. But in general, I would say the main focus, the critical focus, has to be Braamfontein, yes. Cape Town, fairly well situated, and there are complaints here and there, and I don't think I would want to go into those specifics, otherwise it will take too long. But what I can assure the committee is that I have done my bit to identify all the problems about the generator in Durban, in Johannesburg, and what are the alternatives. I mean, in Johannesburg, for example, I've now proposed that we look at using the smaller alternative electricity machines, the small ones that you just connect and you can run the ICT machines with them. And we are in the process of getting technicians to come and test whether we would be able to work. Because one of the challenges also is load shedding. When you have load shedding, the ultimate consequence is that it also impacts on your role, how you complete your cases. In terms of orientation of the acting judges, the JP has spoken a number of times at our meetings about some of the orders that comes out, that we need to look at them. And 2 weeks, 3 weeks ago, I discussed with the judges at the T meeting that shouldn't we really look at a more formal, structured process of actually having engagement with all of us, in fact, into some form of a seminar at the beginning of the term, and as and when acting judges come, but generally at the beginning of the term, to then have a discussion and sharing with the acting judges what is expected of them. What I can say to you is that this Monday, most of the acting judges that came in, I sat with them and brief them in terms, or not, to take them through what is expected of them and where the resources are should they need assistance or help.
A feedback mechanism at the end of acting periods. And I ask the question because it has come up at this forum where acting judges are confronted with feedback from when they were acting, and they say, well, I didn't know that was an area of concern. Is there a system in place, and what would you do if there isn't, to ensure that acting judges get feedback about how they have performed in the period that they were acting?
No, I agree with you. I'm not aware of it being there, and JP maybe may know, but yes, I agree with you. It is one of the things I will take on board. And particularly also in relation to having to discuss the issues of reserve judgment. One of the other challenges we have, it's reserve judgments by acting judges. So it may be a very useful process. I know that proposal.
Thank you, CJ.
Thank you, Commissioner. I think we have come to the end of this interview.
Chief Justice.
Yes, Commissioner Malema. You.
We are also here.
I'm sorry, I forgot
Justice.
about you. I apologize. Would you like to ask a question?
No, I just wanted to say to Judge Mlahle, it's not lost. We're here. We've got your back.
Yes, thank you very much. Maybe let me just get who else is on the virtual platform. Commissioner Breitenbach.
I know.
Commissioner Barnett.
I have no question. Thank you, Chief Justice.
Oh, okay. Thank you. Commissioner Barnett.
Morning, Chief Justice. No questions.
Okay, thank you very much.
Chief Justice,
right.
my hand was up before Commissioner Baloy. but if the ruling is that I'm not allowed, I will abide. But I really did want to pursue one point.
Go ahead and ask one question. You'll be the last one.
All right, thank you, Chief Justice. No, Judge Mlahle, it's this issue around, it's almost a footnote in your presentation, cost cutting. Because it worries me that there is a problem of cost cutting. What is actually happening? Are you being told by the Treasury or the Department of Justice to cut costs? What does this mean? What are you not able to acquire? I mean, legal services are public services. We need more judges, we need more staff, but the government seems to be telling you that you must actually be cutting. So I want you to explain what this means exactly and what implications it has for the delivery of the administration of justice.
Yes.
I've got a second question. Maybe you should start with the second question. In your CV, you say that you were once a taxi driver. How are you enforcing discipline as a taxi driver? You can ignore that, but let's answer that.
Okay.
I mean, I don't think you can use mediation as a taxi driver.
I was good at organizing. So I organized the taxi drivers. And you can imagine it's during the 70s. It had to do also with the state, but I'll leave it there. In terms of cost cutting, I must be frank with you that it's a matter that I would have wanted to hear from the JP. I understand there was going to be a heads of court meeting to discuss how we're going to implement it. But in as far as service level is concerned, I would be great.
What are you actually being told to cut? I just want to understand what it means for the.
No, the letter
administration.
I read, the way I understood the letter, it's more a general letter relating to administration. It talks about not filling in posts, not advertising, a whole range of things. But when I looked at it, I understood it relates to administration. The biggest challenge with that for us is when it comes to judges' secretaries. I mean, in this interview, you're going to interview 4 LAC judges. If they are appointed, those judges would need secretaries. So that directive is already directly in conflict with that. But as I understood it, my interpretation, and in a meeting we had with some of the senior officials from the OCJ, was that whenever those critical service needs arises, there would be a need to make a proposal, and the Treasury will then look at it and see what should happen. So I would assume that in as far as the critical functioning of the court is concerned, there would be a consideration to ensure that it's not compromised. But that's as far as I can take it. I don't know whether heads of court have already discussed in as far as, for example, our court, it's a court that's national. Our judges travel around the country, and that directive deals with traveling. I don't think that it's intended to impact on that, because that would create a major problem.
Well,
Thank you, Chief Justice.
yeah, maybe I can just say something about it so that maybe not only you, Commissioner Waitobi, and know about it, but everybody. As you know, there have been media reports that the National Treasury has come up with cost-cutting measures that it wants all government departments, public service to implement. There has been no consultation with the judiciary. The Secretary General of the Office of the Chief Justice has told me about discussions that she has had with National Treasury, and shown me some correspondence between them. But there's been no consultation with the judiciary. I have taken the attitude that when the judiciary is required to cut costs, there should be proper consultation with the judiciary. Nobody has spoken to me to consult me on this. So I have called a meeting of the heads of court to discuss our response to the fact that there are attempts to say the judiciary must cut certain costs, but without any consultation. It's a matter that we take seriously, and I don't know why up to now nobody has consulted the judiciary. So soon the heads of court will be meeting, I think sometime next week, to discuss the matter. Thank you. Minister?
Yeah, thank you, CJ. I can only state that it is a matter that is still under consideration by Cabinet. I can't take it further than that. That is the reason why there's not been any engagement with the judiciary, is because the matter is still being considered. It's not yet at the final stage as per the discussions that are happening. So unfortunately, I'm also constrained. I can't really take it further than that. But I think commissioners will understand what I am trying to say. Thank you.
Well, thank you for that, Minister. It's just a pity that we get a situation which, unfortunately, creates the impression that the left hand doesn't know what the right hand is doing. Because on the one hand, there is correspondence where already, as I understand the position from the Secretary General of the Office of the Chief Justice, there is pressure on them to say certain measures must be implemented. And I already said to her, tell whoever at Treasury that there must be a proper consultation with the judiciary. And my expectation is that when the executive wants the judiciary to come on board on certain cost-cutting measures, which appear to be quite major from what I see, there would be a meeting of the three arms of the state to discuss these matters so that the way forward is a result of proper consultation. But Minister, I hear what you say, and from what you say, I think I can understand certain constraints on your side too, but I think it is helpful to know that Cabinet hasn't made any decision, because the way that the impression one has got is that it was as if everything has been approved, and certainly one was not getting the impression that this is still subject to a decision. So thank you. So I thought I would just clarify that. Thank you very much. I think that was the last question. Thank you very much, Judge Mulahlehi, for availing yourself. You are now excused.
Thank you, Chief Justice.
Um, I talked about the media getting out, but we have changed our minds, so they should just remain. Good morning, Judge Lally.
Good morning, Chief Justice.
How are you?
I'm well, thank you.
I have not seen you in a very long time.
I'm still alive.
Eh?
I'm still alive.
I can see that. Thank you very much for availing yourself for consideration. I am going to ask you questions. Commissioners will ask you questions. The aim is just to see if how you fare when we compare your track record to the selection criteria that we use to select judges. Are you ready for us to start?
Yes, Chief Justice, I'm ready.
Yes. I see that you hold a few degrees, B Juris, LLB, BA honors. Is that correct?
Yes, Chief Justice.
But there is no reference to a BA, but there is a reference to a BA honors.
Because I already had a junior degree and a senior degree, I think, so I qualified for the honors program.
But your junior degree was a B Juris.
Yes, I had a B Juris.
And as far as I know, a B Juris degree only has law courses except languages, isn't it?
I think that I did my honors after I had obtained my LLB. And because it was honors in industrial relations, or in any event, I was advised that I qualified. That's why I got admitted, because I fulfilled the necessary requirement. Yes, I do not have a BA degree.
Oh, so your honors was on what?
Industrial relations.
What other courses did you do for honors?
Gosh, it was a long time ago. A number of modules on labor law and labor relations. What else?
I wasn't aware. I always thought that to get an honors, a BA honors, you must have a BA first. But I probably had a misunderstanding.
From the institution I studied, I got admitted because I fulfilled those requirements.
Yes, was that the University of Natal?
At the University of Port Elizabeth, the now Nelson Mandela.
Yes, and which year were you doing the BA honors?
Let me look at my CV.
I just see
Where will
that.
I find it?
Oh, is it 1993?
Let me look at my CV, Chief Justice. I don't know it.
I'm
by
looking at the
heart.
questionnaire at paginated number
Yes.
4.
If I've indicated that it was in 1993, then it was in 1993.
Yeah. Okay. Okay. And how long did it take you?
I think 2 years.
2 years.
A year or 2 years. Let me look at it.
Okay. I see that you were a candidate attorney from 94 to 1997. Did you, that was about 3 years, is that right?
I think it took 2 years.
Did you do your articles for 3 years?
Why do I think I did them for 2?
Hmm?
I'm of the view that I did them for 2 years. Was it 2
Well,
years?
it's written 1994 to actually it's more than 3 years. 94, depending what month you started, 94, 95, 96, 97, that might be 4 years.
4. That must be an error. I know I was not in that firm for 4 years. You will notice that there is an overlap between the period in which I served my articles and the period in which I studied industrial relations. I studied...
Well, no. You studied industrial relations honors in 1993.
Yes.
Or you said it took you 2 years.
Yes.
So 94, you would have done both articles and your industrial relations.
Yes. The reason I registered for the program is that I could foresee very early in my articles that at the end of the period, of the 2-year period, I would not have gained the necessary experience, to qualify. So I said to myself, at the end of these 2 years, as things go at this firm, I will definitely not have acquired the necessary practical experience. And what will I have to show for the 2 years? And I said to myself, let me take it upon myself to develop myself, to move forward, because I had one of the...
Yeah, no, that's fine. My question was simply the duration of your articles.
2 years.
How long you took it, you did it.
I did my articles for 2 years and I failed the exam. I did my articles for 2 years. I was never admitted because I failed the exam.
So
that's why I studied industrial relations, because
how
I
come
said I need to have something to show for the 2 years. That's my honors.
How come you wrote a period that is double the period that you did, 97, 94 to 97? Actually, in 97, it looks like you were doing articles.
Yes.
You did articles in 97. You also served as a level A full-time commissioner of the CCMA. But articles are a full-time business. How could you have done articles in 97 and be full-time at the CCMA? Or are you saying this 97 for articles is a mistake?
That must be a mistake. I was employed at the CCMA after I had completed my articles.
Yes. But then here is something else that is on page 4.
Page 4.
That is very strange for me. You say in page 4, you were an acting judge of the Labor Court from October 97 to January 2000.
Let me see.
I don't think that's factually correct because I was a judge of the Labor Court at the time.
No, it's factually incorrect, Chief Justice.
But how is it possible?
I made a mistake.
But how is it possible for you to say you were an acting judge from October 97 to January 2000?
That's why I concede that I made a mistake.
Yes, but what I want to find out is how does it happen? How do you make a mistake like that?
All right.
It's not like you say I was doing articles or doing whatever I was doing from February 97 to January 98, and it is found that actually you are 1 month out or something like that. You are saying you were an acting judge for a very long time, so 98, 99 to January 2000. You say you were an acting judge for more than 2 years. So how does such a mistake happen? That's what I want to understand.
All right. When I saw this advertisement, I decided not to apply because I was of the view that I did not.
When you saw what? I'm sorry.
The advertisement for this position.
Yeah.
I saw it, and I was of the view that I did not qualify as a judge of the
For the
Labour
position,
Court.
for which position?
The one I've applied for, the one
The Labour
in
Appeal
Ntavimo.
Court.
Yes.
Yeah.
I was of that view.
What
Then,
view?
That as judges of the Labour Court, we do not qualify to be judges of the Labour Appeal Court. So I had very late, in fact, Edwin asked me whether I had applied. I said, how could I apply when I was told that judges of the Labour Court don't qualify? There's no point for applying for a position I don't qualify for. And he said, in terms of legislation, you may apply. So I completed my application very late at high speed because I truly believed that I didn't qualify to apply, or I did not qualify for the position. And honestly, should I apply for a position I don't qualify for? My answer was no. So when he told me that I was eligible, then I applied at high speed. It was very close to the closing date, so that explains these errors.
Who told you?
My apologies for the errors.
Who told you? Who told you qualify or you are eligible?
The acting Deputy Judge President, Edwin Lahle.
Yes, but from your own assessment, you did not think you qualified.
Because I was of the mistaken view that in terms of legislation, I didn't. I hadn't read it. You know, when you work in an environment and you generally have discussions, I was of that mistaken view. It was my mistake.
Well, are you talking about the fact that there used to be a provision in the Labor Relations Act that said you have to be a judge of the High Court in order to be a judge of the Labor Appeal Court? Is that what you're talking about?
No, I'm talking about the notion, the impression I had at the time. That was my impression.
What I'm asking you is whether when you say you thought that you don't qualify as judges of the Labor Court, you don't qualify to be judges of the Labor Appeal Court, I'm asking whether you were basing that on the fact that there used to be a provision in the Labor Relations Act that said in order to be a judge of the Labor Appeal Court, you must be a judge of the High Court.
Possibly. Possibly, Chief Justice.
Possibly?
Yes.
How? How can you say possibly? You must know why you were of that impression, is it? What was the basis for your impression?
You know, when you work in an environment, you generally have conversations with people you work with. So when you have when it appears to be a known fact, we know that we don't sit at the LAC because as Labor Court judges, we don't qualify. I hadn't read the Labor Relations Act. And after applying, I read it because when I was told that I could apply, I applied at high speed. Then I read it for myself. Then I found the relevant piece of legislation, the relevant section.
And what did it say?
Excuse me?
What did it say, the relevant section?
The relevant section provides that judges of the Labor Appeal Court may be drawn from judges of the High Court and the Labor Court.
Yes. You have been a judge of the Labor Court for a long time, haven't you?
Yes, Chief Justice.
How long?
I have been a full-time judge since 2012.
Since 2012. That's
January.
over 10 years.
Yes.
But that change in the legislation
Yes.
would have been quite topical at the time the change was made. And one would expect that judges of the Labour Court would have followed all the debates, and when the amendment was made, they would have known and they would have celebrated the fact that now, for the first time in the history of the Labour Court, they were eligible to sit in the Labour Appeal Court. So how come you didn't know that major development until somebody else told you when there were these vacancies?
Our major concern, our major concern at the Labour Court, what we talk about most and what concerns us are our judgments. We talk about that a lot.
You mean you don't, prior to this amendment, you are not talking about the fact that you were prevented as judges of the Labour Court to be promoted to the Labour Appeal Court? That was not a concern to judges of the Labour
That discussion
Court?
was never held in my presence. Not in my presence.
It was not your concern to, you were not concerned about it?
No, I'm saying it was not held in my presence.
Yeah, leave out whether there was a discussion with other people.
Yes.
Were you, as a person, as a judge of the Labour Court, not concerned that at that time the law prevented you from being appointed to the Labour Appeal Court and therefore getting promotion?
Did I take time to look at it and see that it had changed?
Okay, all right. Thank you. JP, do you have anything?
Good morning.
Sorry. Thank you, Chief Justice. Good morning, Judge Lally.
Good morning. Good
Judge, I
morning,
think maybe it's the pressure, maybe of being here, and I know it's never comfortable sitting up there, but I think you're mistaken, because I think at every, first day of term,
Yes.
we have a judges meeting. All the judges come to Johannesburg and we have a meeting. And I don't think there's ever been an occasion where we haven't discussed this issue. In fact, if I remember correctly, you were the one who raised this issue about judges of the Labour Court and the Labour Appeal Court. And I remember clearly Judge Van Niekerk telling you, the problem with the legislation is that while we can apply to be judges of the Labour Appeal Court, we can't act, because that clause says only judges of the High Court can come and act. Don't you remember that?
I remember the discussion about judges of the Labour Court becoming judges of the Labour Appeal Court. And I raised it. I was amongst the judges that I raised it. But however, I do not remember it in this context. I acknowledge we have on a number of occasions held that discussion. However, I was not aware of this amendment. I possibly approached it against the background of my misinformation.
Okay. Then you say you prepared this at the last minute, that's why your questionnaire and so on.
Yes.
But if I remember correctly, that was at least 2 weeks before the due date, you had sought advice on this matter, wasn't it? I remember you phoning me and telling me about your intention to apply, and I said you should feel free to do it. That was at least 2 weeks before the closing date.
Was it 2 weeks?
Yes, because I remember you still asked about nominations and so on. And you wanted to know if you needed a certificate of good standing, remember?
I remember discussing it with you.
And I see also the letter of your nomination was a week before you completed your questionnaire. Am I right? If you look at the dates on there. So maybe it's the pressure of they were sitting there. Anyway, let's move on and talk about, firstly, talk about, recently there has been lots of development in our law, in labor law particularly. And, or as always, Lawyers have the amazing ability to raise all new issues, and our law keeps so fluid, keeps on changing, new issues come up. And 2 new issues have come up in the last few years. One is derivative misconduct, and the other one is a long debate and continuous debate for years about lawfulness versus fairness. Now, on derivative misconduct, there has been a Constitutional Court judgment which I think puts it to rest now. Do you have any idea? I mean, can you help us? Tell us what happens in your court on derivative. Because every person nowadays, when it's a strike-related matter, which only the Labor Court has jurisdiction, not CCMA, they talk about derivative misconduct. What can you tell me?
When we talk about derivative misconduct, we refer to misconduct that takes place at the workplace, misconduct that involves a number of employees, that gets discovered that it has happened. However, the actual perpetrators, it may not be easy to identify each and every actual perpetrator, or some employees may refuse to disclose who the actual perpetrators are. So the employees in that environment or involved are then presumed to also have been involved. So their conduct is referred to as derivative misconduct.
Thank you. And you know what the Constitutional Court had to say about that?
I must confess, no.
No, okay.
Please give your answer in such a way that we can hear.
Oh, my apologies. Sorry, I'll raise my voice.
Yeah, your answer was you don't know.
Oh, no, I haven't read that Constitutional Court decision on derivative misconduct.
Thank you. Then the other issue is the latest one about lawfulness versus fairness.
Yes.
I think it seems to be a practice, or not practice, but a new fashion that mostly white-collar workers, and especially within the government service, when they are about to be dismissed or suspended, they don't follow the process of CCMA. They come directly to the Labor Court. They disavow any reliance on the Labor Relations Act, and they come on the basis of unlawfulness. Have you had these matters, and do you know the matter of what the Constitutional Court had to say about this thing in Steenkamp?
Yes.
Please tell us.
All right. The Labor Relations Act does not provide for unlawful dismissal. So if an employee is off the challenges the lawfulness of the dismissal, that employee may not approach may not approach either the CCMA or the Labor Court, because it is unfair. Unfair dismissals may be referred to both the CCMA and the Labor Court. The issue of unlawful dismissal refers to a breach of contract. They are based on contract, so they are referred to the Labor Court in terms of Section 77 of the Basic Conditions of Employment Act, because the employer alleges that the employee alleges that the employer, in effecting the dismissal, has contravened the terms of the contract. So that's the fundamental difference.
What relief do they seek when they say, I've been dismissed unlawfully?
Sometimes they seek, sometimes they
Okay,
do
let me put it differently.
reinstatement.
If they seek reinstatement,
or relief based on contract.
what is the relief based on contract?
Specific performance.
Specific performance. Now, in contract law, is specific performance there to be just granted?
May specific performance be granted? Yes.
If you prove a breach,
When there is a proof, yes, it may.
that's my problem, you see, because I think it's very clear that specific performance is not there, for the asking has to be, or even damages you have to prove. But more importantly, do you know, often what they ask is for reinstatement.
Yes.
Now, do you know what Steenkamp said about when you bring a case in terms of contract law and you ask for relief in terms of the Labor Relations Act?
All right. Reinstatement is provided for in the Labor Relations Act.
In the?
In the Labor Relations Act, Section 193. I think 193, yes. So an employee who challenges or who seeks reinstatement has to refer a dispute in terms of the Labor Relations Act and seek reinstatement, the remedy of reinstatement in terms of the Labor Relations Act.
Is that what the Constitutional Court held in Steenkamp? In Steenkamp, remember, they brought a matter because it was a retrenchment matter.
Yes.
And they brought it on the basis of failure to comply the contractual agreement.
Yes.
And they asked for reinstatement in terms of the LRA. Do you know what the Constitutional Court held? It's a very important judgment, applies every day.
Yes, which I have applied to. Steenkamp provides that the Labor Relations Act does not refer to unlawful dismissal. So employees who allege that their dismissal have been unlawful may not seek relief in terms of the Labor Relations Act.
That's it. Thank you. Thank you, Chief Justice. Thank you.
Thank you. Minister?
Thank you, CJ. Good morning, Judge.
Morning, Minister.
I see you have got a lot of reserved judgment.
Yes, Minister.
So maybe you could enlighten this commission what could be the challenge for you to finalize the matters, and do you think it will be sending a good message for us to elevate you to the appeal court when you have got this huge number of reserved judgments?
Reserved judgments is a consequence. You are seeing results of a number of problems. If you consider the causes of those reserved judgments and ask yourself whether I am to blame for all of them, let's look at the reasons. Why do I have a long list of reserved judgments?
Well, Judge Lolly, please tell us what you want to tell us.
All right.
Don't have these long pauses.
Okay.
We have a lot of other candidates we need to see.
My apologies, Chief Justice. I have a long list of reserved judgments because of the problems that I encounter. Amongst my problems, I need to state the history of these reserved judgments because they have a history. Before my appointment.
Well, I'm sorry, Judge Lally.
Yes.
Maybe pack the history, just in point form says,
Yes.
it's this, if you have been sick, I was sick, or just in point form first, then we can take it from there.
All right. The reason is the manner in which my work is arranged, mainly. That was the result of the investigation that was conducted in Quebec. The manner in which my work is arranged by the registrar who allocates cases makes it impossible for me to reach my targets. That was the result, or that was the outcome of the investigation that was conducted to look into why I have them. So there are internal problems which prevent me from reaching my targets.
Did you raise these issues with the JP?
Yes, I did. Oh, the Chief Justice, oh, this,
Okay. No, thank you, CJ.
Thank you,
the
Minister.
President was raising his hand. I was directing you to his hand.
Thank you, Minister. I will come back to you, JP, but I want to, Commissioner Marumwaha.
Thank you very much, CJ. Good morning, Judge.
Good morning, Commissioner.
Mine is it's more of a substantive question. I see that you wrote a judgment on
Yes.
the extension of collective agreements to 9 parties.
Yes.
I'm not going to take you through the judgment, but I would have loved to do that. But I'm going to ask you more of a general question.
All right.
What should those parties who are party to this collective agreement need to comply with for a collective agreement to be extended to non-parties? But while answering that question, because I see of late, I've seen at least 2 or 3 judgments that have also been written by the High Court, which seems to me that the issue of jurisdiction continues to be a fundamental issue in labor law. The disputes that relate to the bargaining councils that lead to these collective agreements, where should these disputes be adjudicated? Is it the labor court or the High Court? What forum should be the forum for these disputes? Thank you.
In terms of Section 157, the Labor Court does have jurisdiction over those disputes.
No, I'm not disputing that. It does, and one of your judgments shows that it does.
Yes.
That is not the issue.
What's the question?
What I'm asking is, let me put it this way: is it workable for these disputes to be dealt with by both the High Court in some instances and the Labor Court in some other instances? Will that not lead to inconsistent jurisprudence in respect of these issues? That is the basis of my question. But my fundamental question is in relation to how do you go about extending these collective agreements to non-parties? I think that is the core of my question.
All right, and applications are made to the minister to extend collective agreements to non-parties. However, before the minister can extend a collective agreement to non-parties, there are requirements that have to be fulfilled. For example, the bargaining council must act in terms of its constitution, and must take a decision, must conclude a collective agreement, and then make an application to the minister to have it extended. And then the minister will exercise his discretion whether to extend it, will exercise, if the minister is satisfied that the bargaining council has fulfilled all the requirements, then the minister will extend it. In the judgment that I wrote, the reason I reached that decision was that the bargaining council did not act in terms, breached its own constitution. And my decision was that if the collective agreement is not consistent with its constitution, it therefore does not qualify to be a collective agreement of that bargaining council.
Thank you very much, Judge. Thank you, Mr. CJ.
Thank you, Commissioner Singh.
No, thank you very much,
Do
Chief
mind
Justice.
me just making a follow-up on this question, then I forgo my opportunity.
Sorry.
I want to make a follow-up, then I forgo my opportunity.
A follow-up after Commissioner Singh or now?
Now.
Okay, please make a follow-up before
Yes.
I go to Commissioner Singh.
Yes, Justice?
Yes.
The section 157 of the LRA you're referring to
Yes.
speaks to both the exclusive jurisdiction
Yes.
of the labor court
Yes.
and the concurrent jurisdiction of both the labor court and the high court.
Yes.
Which specific matters, and I want you to be straightforward, which specific matters relate to the concurrent jurisdiction between the labor court and the high court, especially those that were settled by the Con Court in the case of Baloyi versus the public protector?
They are cases that in which in section 157(2) states them expressly, states those cases in which the labor court and the high
Just be
court
specific.
have-
Which are they? Just go to those cases without repeating it.
The allegation based on the violation of chapter of the Bill of Rights. It's in chapter 2.
It's okay.
And administrative decisions. They also fall under the jurisdiction of both the labor court and the high court.
Chief CJ, I settled. I'm done.
Okay, all right. Commissioner Singh.
Thank you, Chief Justice, and good morning, Judge.
Morning.
Morning. Yeah, Chief Justice, I'm really not satisfied that we've received answers to these outstanding judgments. You know, over 20 of them, and some of them 2 years. And I think
Yes.
the minister raised the question, but we don't seem to be getting any responses.
Well, we were given a response. What you make of it, of course, is we were given a response that
May I
it's because of how the registrar allocates matters to her. I don't know how I'll give the JP a chance how a registrar allocates matters to judges. I thought the JP would do that. JP?
Thank you, Chief Justice. It's correct. Registrar, there is a system where the judges at the meeting at the first day of every term which we have discuss how many matters to be allocated in motion court, how many matters to be allocated at trial court, and that's why the chief registrar sits in our meeting, and she then communicates, and we check the court roll. Bertha is the only, because it's one judge, and for a while in KZN, Durban also there was one judge. So what we did is made sure that because urgents might come up and they have to deal with it, that their role is it's less than what is in Johannesburg and what is in Cape Town. The registrar has always complied with that. Also, what I want to ask Judge Lally, is it not correct that your outstanding judgments has been a source of many of our discussions?
Yes, it's true.
And is it not correct that I have also given you off weeks during term time so that you could deal with them?
Yes, you have.
Yes. And you have been the only judge who has not bigger role than any other judge.
Excuse me?
You don't have a role which is much greater than any other judge would have. And that was my problem. And I sat with you not once, not twice, on a number of occasions to ask you, how can we deal with this? So it's not something which has been left and you've been left to your own devices. We've tried to deal with this matter. And my concern was, even leave time, I said, look, take your leave, but make sure you deal with some. But is it not correct that from the time you've started, which is the time of Judge Zondo, till today, there has been no change in the number of reserved judgments that you've had?
There has been no change. I think there has.
You still have the
We
same
can't
number.
hear you. We need
I
to
think
hear
that
you.
there has. I need to state this. I wish to acknowledge the assistance that the Judge President has given me. He has, it's true. And it is also true that he has given me time to write outstanding judgments. It is true. However, I think that this history needs to be heard by you so that you can have a full picture. Before my appointment.
But you say it's true that the JP has given you time.
Yes.
And the JP says, despite the fact that he has given you time, there hasn't been much difference made to the list. I just think it's an unacceptable situation. Some of them are close to a year now. When I look at the dates when they were reserved, AMCO on page 9 was reserved in December 2022. Others, SICA, were reserved in November. A number of them were reserved in November 2022. JP, is there no complaint that has been lodged against the candidate for the reserved judgments as yet?
When the complaints come, we sit and we sort that out. We give a time to get the judgment out immediately. But I don't, in the last year or two, I can assure you there's been no complaints.
No, I mean complaint lodged with the Judicial Conduct Committee, not from the...
No complaints.
Not yet.
Guilty, sorry.
Okay, but you will reflect on that. Okay, we'll talk. We'll talk. I don't know if there is really anything, Commissioner Singh, you still want to hear about the reserve judgments?
No, thank you, Chief Justice.
Yes.
No, there's no point in pursuing this.
Commissioner Baloyi, do you still want to?
Thank you, CJ. Good morning, Judge.
Good morning, Commissioner.
Yes, Judge, the various discussions that you've had, first with the CJ about how it came about that you made the mistakes in your application, and you're saying that you were not aware that you could apply to be a judge. The discussion about you not being aware of the judgment of the CC on derivative misconduct, and lastly about the delivery of judgments. On the failure to deliver judgments on time, on the face of it, it seems to suggest a lack of diligent application by you to your work, but also to the law that relates to the work that you do. And that is a matter of concern in the absence of a proper and full explanation, a satisfactory explanation, actually, why you're not aware of legal developments of law in this specialized area where you practice, how you completed your application form and made a mistake in it, and now we've heard that it's not an application that you completed overnight. And then 3, you have these judgments. It is a matter of concern, and you are not dealing with it in any satisfactory way that, if you were to be considered for recommendation, would give peace of mind that these are passing things and they are behind you. Do you want to say anything about that? It is a matter of concern for me.
Commissioner, let me concede that you have reason to be concerned. But I need to say this, and I would like you to hear me on this. When I got appointed, there was no permanent judge in Gqeberha. Gqeberha was serviced by judges mainly from Bramfontein. And I need also to add that I got this information because I was concerned. I could feel that, I could see that I was overwhelmed by work. So I asked them, I approached judges and asked them how they coped because I was overwhelmed. And they told me that when they worked, they worked in Gqeberha, they were willing to do more because they serviced that center, say once or twice a term. So when I walked into a pattern of scheduling cases, scheduling cases that was extraordinary. I did not walk into the ordinary. As a result, when they were too much, when I had a lot of them, one of the judges of the LAC approached me and told me about his concern. And he even said it will take years to clear this. So while I do not shy away from responsibility, I would like you as commissioners to understand that there are factors that are beyond my control. And I wish to invite you to look at statistics. I did read the Chief Justice's report. I have improved. And I looked at the number of judges at other centers. I looked at the number of judges that we have. I looked at our caseload, and I am forced to wonder whether there is a plan and resources to ensure that we fulfill our mandate. And I also invite you to look at the trends, because when you look at the report, a number of the judges of the labor court have long lists of outstanding judgments. And I wish to invite you to look into the problem and find out what the problem is. We are aware that we work in a court where we have to issue our judgments as expeditiously as possible. It is our intention to do so. But I invite you to see if we get sufficient resources to fulfill that mandate.
All right. Thank you, Judge Lali. Thank you, CJ.
Thank you. Commissioners on the virtual platform, is there anybody who wishes to ask any question? Otherwise, I think this interview has come to an end. Commissioners on the...
Thank you, Justice. Thank you. No question.
Thank you. Thank you. I think there is nobody on the virtual platform who wishes to ask any question. Thank you very much. We have come to the end of this interview. Thank you very much, Judge Lali. Thank you for coming. You are now excused.
Thanks.
Good morning, Judge Kotran Kontwana.
Good morning, Chief Justice.
How are you this morning?
I'm reasonably good.
You are very good.
I'm good.
You are good.
Yes.
Okay, all right. I'm happy to see that you don't look nervous at all.
Well, maybe I can hide it better.
Thank you very much for availing yourself for consideration for appointment to one of the positions in the Labor Appeal Court. We appreciate your availing yourself. I'm going to ask you some questions, and commissioners will also ask you questions. The purpose of our questions is just to establish whether or how you fare when we compare your track record and your abilities with the selection criteria that we have adopted for the selection of judges. And we may be robust with you as we ask you questions, but nobody intends to demean you or disrespect you. You hold 2 degrees, is that correct? B.Juris and LLB?
Yes, Chief Justice.
You'll have to speak up because every one of the members of the commission here is very interested in the answers you give.
Yes.
Do you hold 2 degrees, B.Juris and LLB?
Yes, Chief Justice.
And you got your B.Juris at the University of Zululand?
Yes.
And LLB, did you get it at VETS?
No, I said it's the same institution.
Same at the University of Zululand?
Yes.
In 94?
Yes.
Okay, and then you got a certificate in industrial relations. Where did you get that
From VETS Business School.
Sorry?
From VETS Business School.
VETS Business School. Okay. And in 1996, you started working as a full-time commissioner at the CCMA.
Correct, Chief Justice.
Prior to that, you had not done articles or pupillage, is that correct?
Yes, it was fresh from school.
You had not done that?
Yes, I had not done that.
Yes, and that was 1996 to 2000. From 2000 to 2003, you were a labor consultant and part-time commissioner at the CCMA. You were a part-time commissioner at the CCMA?
So I commenced as a full-time I commenced as a full-time in 1996. I left in 2000. Then I became a part-time commissioner. And then whilst I was a part-time commissioner, I was then consulting.
You were also a labor consultant?
Yes.
Yes. And you were admitted as an advocate in 2003?
Yes, I was admitted in 2003.
Yes, and did you then practice up to 2017?
I practiced till 2017 when I was appointed as the judge of the labor court.
Okay. Did you do pupillage before you
Yes, I did.
got admitted?
Yes, I did pupillage.
Okay, in Joburg?
In Johannesburg.
Yes. Okay. Your practice as an advocate, how diversified was your practice in terms of branches of law?
My practice was predominantly labor. However, I did get a lot of briefs, or not a lot, maybe, briefs in constitutional litigation. I did environmental law. I think those are 2 that I can recall now that were significant, I think, in terms of my exposure, because I've appeared at the Concord led, and I also appeared on my own. So I did get a variety, but predominantly it was labor.
Yes. How much exposure have you had since you left varsity to law, other branches of law other than labor law?
As I said, I did branches of law, constitutional litigation. I did environmental law and other commercial matters, and litigating in different courts. I remember most of the cases that I did also were in Northwest, in the High Court in Mabatu.
Did you appear in some constitutional matters in the High Court or in any other court? Did you actually appear?
Yes, I did. I did one matter, I think most people, soon before I was appointed. It was a constitutional matter, but it was done within the context of a trial within trial in a criminal case. And so they were challenging constitutionality of the Criminal Procedure Act. And then I was obviously representing the minister because they were challenging the constitutionality of those provisions. However, yes, we did file papers. I was led by SC in that matter. And the finality of that matter, then I got appointed. So I did. So there were others also in the High Court where the constitutionality of the provision was challenged, and then I was briefed to represent the minister.
But did you actually get to argue them in the High Court, or not really?
Not really in the High Court, but the only one that I moved was in the Con Court.
Yeah.
Yes.
Which one is that?
It was a criminal, obviously there was an issue about the then recently promulgated amendment to, a criminal, the definition, I think, of rape. And so I was there once more representing the minister, because it had created, the interpretation had created a gap in terms of the transition between the old legislation, because it was common law, then it got codified, then there was a gap. So I represented the minister dealing with that case.
Is that the matter where the judgment was written by Justice Nkabinde?
I'm not sure what it was Justice Nkabinde, it could have been. I'm not sure whether it was Justice Nkabinde or it was Jafta. I'm not sure, Chief Justice. I haven't checked that case.
Was it one judgment or?
It was one judgment, yes, it was one judgment.
Or was it the only matter in which you appeared in the Constitutional Court?
Alone, yes, not led. But led also appeared in the Merafong matters. The two Merafong, I did appear, but I was led by SC.
Yeah, I wouldn't forget who wrote the judgment in a matter where I appeared alone in the Constitutional Court.
I didn't think it.
Yes, okay, all right. So you got appointed to the Labor Court as a judge in, is it 2017?
Yes.
Yes. And you are still a judge in the Labor Court?
I'm still a judge in the Labor Court, but I'm currently acting at the High Court. I started this term.
You started this year?
This term.
This term?
Yes, the commencement of this term, which was on Monday.
Yes. And I guess it's too early to ask you how you are finding it, is it?
No, yes, I have been found
yes. Now, if you are appointed to the Labor Appeal Court, you will be sitting in a court which is required to give this country labor law jurisprudence and develop labor law for the country. The Constitutional Court will step in from time to time, but largely the Labor Court and the Labor Appeal Court are supposed to drive that process. Therefore, you need to be alive to issues and debates around a number of issues in the labor law field. Do you agree with that?
I agree, Chief Justice.
Yes. What can you share with the commissioners in terms of what you are aware of in terms of different schools of thought about jurisdiction between the labor court and the high court in regard to certain matters that have got either labor or have got labor elements? That's a debate that has been going on for more than 30 years, even before the labor court was created under the old regime. That debate was there. What can you share with, what are the issues, what are the debates? Those who they take one view, what do they say in support of their school of thought? Those who say something else, what do they say in support of their school of thought?
The labor court is a specialist court, and it finds its jurisdiction in the Labor Relations Act, and it also gives it exclusive jurisdiction in respect to labor matters. And however, the LRA does give the labor court concurrent jurisdiction on constitutional matters that emanate from employment law or labor relations. And then you also have, so you have to then discuss the jurisdiction, because once you say concurrent, it means there's another court that has jurisdiction. I think that's where the debate starts. But also I'm aware also that most of the matters I think that serve in our court is when it relates to the contractual matters. And then the court would exercise its concurrent jurisdiction in terms of basic conditions of employment, Section 77(3), on contractual matters that emanate from employment contract, let me say that. So the tension is, as it was discussed in, I think, the power coming from Chirwa to Gaba. I think when you look at the SCA in Makanya, then the jurisdiction was properly explained. I think those judgments from the Constitutional Court, that the jurisdiction, it talks about power of a court to deal with the matter, and if then that power derives from the legislation, and that legislation defines clearly the court that has to deal with, then the High Court cannot deal with those matters. However, you do get matters that a litigant has two claims that emanating from similar facts, of same facts. So in those instances, then the litigant can forum shop. So the litigant can decide, well, I want to vindicate my right in terms of the Labor Relations Act, then obviously it will go to the labor court. But if he says, I want to vindicate my rights in terms of contract and common law, then he can still go to the High Court or come to our court. Then we will sit as a High Court, because obviously we're exercising our concurrent jurisdiction. So the tension, I think, is because, as Makanya explains, that there is confusion that, you know, sometimes the High Court will shy from exercising its jurisdiction, which is common law because it's contractual, or in some instances it could be jurisdiction that emanates from the Constitution, and because it would come from the employment field, yet they could deal with it because the labor court is exercising a concurrent jurisdiction. And obviously from the labor court's perspective is also when the labor court cannot exercise a jurisdiction because we think we don't have that jurisdiction. So the debate comes from that, but it is clear that a litigant is not barred from forum shop to an extent that that court has jurisdiction to deal with a particular dispute. So to an extent that I think in Makanya,
that dispute had been through the labor relations processes, and however, the litigant chose to vindicate his rights in terms of the contract. And I think that's where the tension was. So I'm saying if a cause of action emanates from, it's one cause of action, and a party must go to a specialist court, to a labor court, then the High Court would not have jurisdiction.
You talk about the concurrent jurisdiction between the High Court and the Labor Court as provided for in Section 77 of the Basic Conditions of Employment Act. Does that act not place a cap of a certain amount which must be determined, I think, by the Minister of Labor, to say those employees who earn above a certain amount, they may not avail the Basic Conditions of Employment Act in relation to their matters? Is there something that says that, or am I mistaken?
Chief Justice, I'm not sure, because 77.3 in capital A, it says it matters that it's contractual matters, even if it's not a term of contract. So, which means then it gives a scope that is wider. So then the issue of threshold would not apply. However, threshold would apply when you are now dealing with the terms that emanates from the Act itself. But 73 says even if it's not a term of a contract, and I think we've dealt with a lot of those issues when a litigant would come to our court challenging unlawfulness of the dismissal. I think there's a new trend that is emanating, that because of Steenkamp, litigants are now aware, the Constitutional Court judgment, that in the Labor Relations Act, there is no unlawful dismissal, for example, or unlawful suspension. So they will then come via the Section 77.3 and then says it is part of their contract that they are vindicating the rights in terms of their contract, which most of the time is read with the policies.
And are you familiar with what a sympathy strike is?
Yes, I am familiar with what is a sympathy strike.
What's the difference between a sympathy strike and a secondary strike?
A sympathy strike is when the strikers are striking in support. They're sympathizing, but it's not because the issues that are demanded impacts upon them. And then a secondary strike, it's a strike that I think is linked to the issues, to the demands.
Mm-hmm. And are you familiar with the grasshopper strike?
Grasshopper.
Mm-hmm.
Trying to think. No, I know remember the definition of strike in Section 20. It's wide. Grasshopper strike. If you can refresh.
Oh, okay. No, it's fine if you are not familiar with it. Are you familiar with the debate about the applicability of the Prescription Act to labor disputes such as unfair dismissals? And if you are, would you mind sharing with the Commission what you understand the different schools of thought to be?
Yes. I think when those debates, I think, were traversed at the Constitutional Court, and Manyataza, I think, comes to mind as I'm sitting here. And I think the debate was, would the Prescription Act apply in labor matters? I think that was the debate. And it was resolved later on in, is it Khawulishi, but it's that like the Concord case, where it said, because of the Labor Relations Act that provides condonation, it does apply firstly, let me say that, and then a party still who is late in referring a matter to the CCMA can apply for condonation, and then once a dispute is referred, it interrupts the prescription. So up until its conclusion, if there is a review and there's appeal, then the prescription is interrupted. But as soon as the litigation process is concluded, and let's say litigant doesn't vindicate its rights in terms of that award or judgment, and then so after that judgment, the finality of the process, then the prescription will commence. So an example would be, if there was an award, there was an award that was rendered, I think that the two debates. So you'll then start saying, why didn't you vindicate your rights within the prescription period, which is 3 years? So, and then you would also, another debate would be then it was an award, a judgment, and if it's made in order of court, then obviously the period of prescription would apply, because we know if it is an order of court, then it's 30 years. If it's it's just a debt that is vindicated, it's 3 years. So in a nutshell, that is the debate.
Okay, if you are appointed to the Labor Appeal Court, you will be sitting in an appeal court dealing with appeals against judgments of the labor court. Are you familiar with the two types of discretion in law that you might have to deal with in appeals that come before you, where judges of the labor court will have exercised some discretion in making their decisions?
Yes, Chief Justice, there are two types of discretion. It's a wide and narrow discretion.
Yes.
And a wide discretion is a discretion that, when exercised, an appellate court cannot interfere with. And an example, it would be, I think in our court, condonation, it would be granting of condonation, it would be postponements. So it's the court, if it wants to interfere with that exercise of discretion, it has to test whether it was judicially exercised. You look at whether there was proper understanding of the law applicable and other factors. When it comes, that is the strict or narrow discretion. When it comes to the loose or wide discretion, it's when then the court, seized with the matter, can also traverse the merits and deal and exercise that discretion, and it doesn't have to look at whether it was judiciously exercised. And I seem to recall there's one case of, I think it's Dr. Kemp, it was an LAC case, and I think Chief Justice said in that case, where it had to deal with compensation, and I think that would be an example where then an appellate court can exercise that discretion and deal with an issue of compensation that emanated from the Labor Relations Act, which is Section 193.
So what's the difference between the two types?
The difference between the two is that the other one, obviously, the appellate court is constrained to intervene because it's a strict and a narrow. If it does, then it must satisfy itself that a discretion was not exercised judicially, or it was exercised capriciously or arbitrarily, or that there are a lot of points. And then with the other side, you don't even have to look at those points, whether it was judiciously exercised. The court that is seized with the matter at the appellate level, it can interfere with that, and then also traverse the facts and exercise that discretion.
Thank you. I'll now give the Judge President of the Labor Appeal Court and Labor Court the opportunity to put questions to you.
Thank you, Chief Justice. Good afternoon. Judge.
Good afternoon, JP.
It's nice. I've missed you this term. Are you enjoying it at the High Court?
I cannot say for now because of these interviews. So I hope once I'm done, and I'll be able to focus there.
All right. I'm looking at the feedback we receive from the law bodies. I notice that you have the support of BLA and the GBC, but not the LSSA, which is the Law Society of South Africa. I looked at the reasons and it just mystifies me. It appears in 6 years you have 3 of your judgments overturned. And they say, my Lord, that's too much. So you should be given some more opportunity. I don't think you need to answer that. All right.
JP, please speak up a bit so we can hear you.
Oh, sorry. Do I need to repeat that?
Please repeat it for me.
Okay. I was saying that I look at the feedback we received from the law bodies, and I noticed that you were supported by the BLA,
Yes.
by the General Bar Council, but not the LSSA, the Law Society of South Africa. And they base it on the number of matters appealed where your judgments were overturned on appeal. And they've come to 3 judgments in 6 years. And on that basis, they do not support you. I find that extraordinary. I don't need you to comment on that. But I do know one of the judgments was on restraint of trade, where you weren't reversed on the decision of the restraint of trade itself. It was only the one part of it, and that was the period of time.
Yes.
I think you upheld the 3-year restraint, and the LAC said 3 years was a bit long, and they reduced it.
Yes.
Is that correct?
Yes, that's correct.
Yeah. I'm just mystified, as I said, why they do not support you based on the 3 judgments which were upset. And then there is an objection from JOSA and Aweshe attorneys,
Yes.
which is an attorney and his client.
Yes.
And they've raised an objection that you refuse to hear them. What I find also surprising is that all attorneys know that if there's a problem with that, come to court and you refuse to hear, you go quickly to the JP or you go to the DJP. One of us is always there, and to lodge the complaint. They never did anything. The registrar gave them a date a week later, which they were happy with. And you did hear the matter, isn't that?
No, if I can just put context, I think I did send some note to the commission about that. I never refused to hear the matter, JP. I said the matter was given to me at 2 to be heard at 2:30 in the afternoon. I said to the registrar, I don't mind hearing the matter. The matter must be heard the next day. The next day, the matter was not heard. I was told by the registrar that the matter was set down for the following week, and that's how it ended.
Sorry, you're absolutely right, yeah. It was the registrar who negotiated and gave them a date next week.
Yes, but I was willing to hear it the next day.
And is it correct that judges actually don't allocate matters?
No, I don't allocate.
Only the registrar does?
Yes.
Thank you. Then the next complaint was Kunene versus the right to care.
Yes.
I think it was a sexual harassment matter.
Yes.
A claim of 3.5 million was sought against the employer for not taking action quick enough.
Yes.
And he found for the employer.
Yes.
And he refused leave to appeal. And I can tell you that the LAC was petitioned, the LAC was petitioned, and they upheld and they refused to grant the petition. So you've been upheld on that.
Yes, but my view on that also was that I think when parties have availed themselves to appeal, it is not for the judge who assists with the matter to comment on the merits. So that was my take. And however, I think in those matters, you look at the body of evidence that is before you when you decide.
Thank you. You're right. Now, you've altogether got 14 years experience in labor law, 6 as a judge and 14 in practice. That's 20 years. Sorry.
20.
Yes. And from your judgments and practice, I see you're quite comfortable in doing what you are doing. Is that correct?
Yes, I am comfortable, and I think when I read the script of my last interview, one promise I made was that when I'm appointed as a full-time judge, I'll be able to render my judgment expeditiously, and I think I kept my promise.
You have kept your promise. I have no reason to ever talk to you about reserve judgments. Thank you so much for that. And I'm not going to ask you about your knowledge and expertise. I think the Chief Justice has done that. That is all, Chief Justice. Thank you very much.
Thank you. Minister, you are covered. Thank you. Commissioner Marumwahai.
Thank you very much, Chief Justice. Good afternoon, Judge.
Good afternoon, Commissioner.
I just want to ask you a more substantive question. I see that one of your judgments, you had an opportunity to write on the intersection between company law, insolvency law, and labor law, business rescue and retrenchments. And I read the judgment. I have no great difficulties with the judgment because I think the approach is right. But like you are saying in the judgment, there have been conflicting decisions in respect of, one, the jurisdiction of the labor court in dealing with those matters. But most importantly, whether one of the affected parties, which is the employees, under those circumstances can actually approach the court on an urgent basis to get the relief that they are looking for when they are faced with retrenchment from a business rescue practitioner, where the moratorium provision is clearly stating that you cannot do that without the consent of the practitioner or leave of the court. What I want to get from you is, when one has regard to labor rights generally, and the right to employment in particular, if there is such, under that understanding of that this is a constitutional right, what is your view in respect of saying perhaps there is a justification for employees to be able to bring these applications, notwithstanding not meeting the required sort of threshold in the provision? In other words, by not having had first obtained consent or even the leave of the court. In other words, as a way of right. What would be your view with respect to that?
Remember that emanates from Companies Act. And the Companies Act, I think I mentioned in that judgment that it created that system of business rescue, that scheme, and that scheme obviously resides within the High Court. But if an employee has an urgent need, as you've just articulated, they must go to the High Court on urgent basis, as long as they can prove urgency for the leave to challenge, to vindicate their rights. Then once they've got that leave to litigate, remember, when it comes to business rescue hopes to rescue a company, not to kill a company. And then the provision is to give the practitioners an opportunity, a breather, as they try to assist this company that is going down. So, but if there are rights that if they are delayed, then they're going to be negatively impacted, the Act has provided a system, a procedure, and that procedure takes you back to a judge of the High Court who can then grant leave, and then a person negatively affected can then vindicate their right.
Thank you very much, Judge. Thank you, CJ.
Thank you. Commissioner Singh.
Thank you very much, Chief Justice. Good day, Advocate. You were advocate when we interviewed you the last time, when you applied for the Electoral Court and the Labour Court, and you decided to stick with the Labour Court and not the Electoral Court. Was that a wise decision in retrospect?
Yes, it was. I don't regret joining the Labour Court.
Thank you. Related to this, you list 2 reserve judgments.
Yes.
And they were quite recent.
I've delivered those judgments.
You've delivered them. maybe for the JSC, I mean, we want to know what's best practice as well. To what do you owe this ability to write your judgments as quickly as you do? And what's the longest you've taken to write a judgment?
Well, I've always, obviously we've got 3 months, I think, in terms of practice to render our judgments. So I've tried to make sure that I keep to that. So I track my judgments and make sure that I do the oldest first so that at least I'm not lagging behind. But I must be honest, it takes a sacrifice. It takes a sacrifice because you have to, you know, your social life gets curtailed. And however, I'm enjoying it and I don't have qualms about it. I think it's a matter of, once you've found a way of dealing with them, you can, but not discounting that there are also personal circumstances that can prevent a judge from dealing with the matters expeditiously. However, the standard and the practice is 3 months, and that's what we are expected to adhere to.
Thank you for making that sacrifice, because they say justice delayed is justice denied, and you are certainly not denying justice. Thank you very much, Chief Justice.
Thank you, Commissioner Singh. The last one on my list before I go and look at the commissioners on the platform is Commissioner Nochesi.
The professor covered me. Thank you.
You're covered. Thank you very much. Commissioners on the virtual platform, I didn't see any hand. I'm told Commissioner Barnett. Commissioner Barnett.
Thank you, Chief Justice.
Go ahead.
My question, good day, Judge. My question is just on the solidarity with stays and the South African Police Services case.
Yes.
On page 23, the award, I'll just give it to you quickly, you don't really have to look. You award one amount in the capital, but you say that 3 respondents must pay that to the claimant. And then you also make a cost award against the 3 respondents. And the wording is done that the respondents are to pay the costs. So it creates a practical problem in practice with enforcement. And my question is just, you don't think it would have been better to follow the practice where you grant cost orders of that nature, and even in this case the capital, to the parties jointly and severally, you know, the one paying the other to be absolved. So it's just a practical question. If you can just comment on that, please.
I note your comment or your question, and I'll look at it. But in this particular instance, because it is government, remember that was litigated against. So most probably I didn't, you know, expound on it because of that.
Thank you, Chief Justice.
Thank you very much. I've not been told of any indication from any other indication from the commissioners on the virtual platform. I assume that was the only one. Commissioner Barnett was the only one. I will allow the JP. JP?
Thank you very much, CJ. Good afternoon, Judge Nkuta Kotwana. Or the other way around, sorry. Okay. You mentioned that you are currently acting in the Gauteng division, and you are the second judge this year from the Labour Court who has come to act in the High Court. Could I ask what motivated you to want to come to the High Court?
I think it's exposure, and you want to be better exposed in terms of your career and growth.
Yes.
But also, I think you're at a stage where you want to decide where you want to, in terms of your career development, what would be your next steps. So I think High Court, it's for me to just get exposed.
Yeah. Well, I think it will
will come in very good stead for you. You'll have a very good taste of what appellate work involves, because as a labor court judge, you don't have appellate work, am I correct?
Yes, we don't have. Yes, we don't have.
Yeah. But the last question, CJ. That issue about you refusing to hear a matter, it worried me a bit that the parties came and they came in the urgent role and they wanted to be heard on that day, and you said, no, I'll hear them tomorrow. And by the time you were ready to hear the matter, as the saying goes, on that side of the table, there was already blood on the floor. And there would have been no value in you hearing the
JP,
matter.
the horse had bolted.
The horse has bolted. What's your philosophy? I mean, you may have not been able to read the papers, but it's not the first time that an urgent matter rocks up in a judge's role that way, where there's demonstration of imminent harm. Now, I want to understand why you refused or you didn't hear the matter on that day.
I didn't say I refused to hear the matter. I don't allocate matters, the registrar. So there was not clear indication that was allocated. But another consideration was that the period, and I thought most probably then it would assist if they come back the next day, because they would have served those papers to the other party. But I must be honest, I didn't refuse to hear that matter. The confusion came from the office of the registrar.
Yeah.
So I cannot take it any further.
Hopefully,
but
when you
I
go
understand.
back to the labor court, you will share the message that registrars are not that powerful in the High Court. They don't allocate work to judges. Thank you, CJ.
Chief Justice, can I just follow up on this?
Thank you.
Exchange.
Yeah.
Judge, the complaint seems to be a narrower one, which is that the disciplinary hearing was scheduled for 4:30 on the 30th of August. The application is brought before you on the same date at 2:30. And that's why they want the hearing. I mean, they had already lost. It sounds to me that they had no prospects anyway. And that if you had the matter, you would have dismissed it. But the problem that they are raising is that we've got a hearing at 4:30. We ask a judge to hear us at 2:30, and the judge says, no, I'm not coming to court. I'll see you tomorrow. That's fine if the disciplinary hearing can be postponed. But what they say is that at 5 o'clock, all of the 70 workers were fired. And they probably would have accepted the dismissal if their application before you had been dismissed or struck, whatever. But what seems to be making them very unhappy is that you just refuse to hear the case. So that's really the harm that is at stake, that maybe you should really explain. Did you know that the disciplinary hearing was at 4:30 that day when you said, I'll hear the case tomorrow at 10?
No, at that stage, I was not aware that there was a disciplinary hearing at 4:30. If I was going to hear the matter. But still, if they came back the next day and said the people that were dismissed, and as a court, if they'd made a case, I think you have a discretion, you have a lot of remedies that you can avail to parties. So I don't think that I was not going to be able to deal with it the next day, and give them an order that was going to assist in that regard.
But I mean, how did you not know that the disciplinary hearing was at 4:30? Was it not in the founding papers or in the notice of motion?
As I explained, you see, what happened is the registrar comes and says, here are people who are coming at 4, at 2:30, they want to be heard, it's 2 o'clock. And then I said, okay, because my understanding is that the registrar didn't allocate that matter. So I said, can we hear this matter the next day? And the registrar then said the matter will be heard the next day. So I'm saying is, it was not properly before me. That's what I'm trying to say at that particular stage. And I seem to recall the discussion that I had with the registrar that there was the 31st or what, that they were going to serve or what. But there was a history to it. I'm not sure why I couldn't pick it up. But I take your question and your concern.
No, I've got no concern. I'm just pointing their concern.
Yes, but I'm saying their concern, yes, and I tried to deal with it. I can't take it any further.
No, I think
I understand where you're coming from, and I think as JP Mlambo has just alluded to, so I understand.
No, the only thing I'm investigating is if you were aware that the matter is at 4:30, then you should hear the case, strike it, dismiss it, whatever, instead of just telling the registrar to go back. That's what I don't understand. I mean, maybe I thought maybe you didn't know. But if you didn't know, why? Because the papers are there in front of you. That's the only thing I'm trying to get my head around, if you know what I mean. Yeah.
No, yes, I understand what you are saying, we are asking. But as I said, that case came before, the registrar approached me, and then the registrar said, there's the case. When the case is on the roll, you go to court, you do a case. When the case is not on the roll, the registrar must tell you why it's on the roll and why it must be enrolled. So in this particular instance, as I said, it would seem as if there was a confusion between myself and the registrar, because my understanding was that the litigants could be heard the next day. And I said the matter will be heard the next day. And I was amazed because I was willing to hear it the next day when they said the matter is set down, not for the next day, but for the following week. And then it baffled me then that. So that's all I can say at this stage.
Thank you, CJ.
CJ, may I do a follow-up just to
sure.
hear something? Good afternoon, Judge.
Good afternoon.
Judge, just so that there is no confusion, when you made the decision that they can be heard the following morning, had you looked at the notice of motion? Because it's not clear from this engagement whether you had the notice of motion in front of you. And I think that's what Commissioner Nkaitobi is trying to establish with you.
When the matter was brought to me, the registrar is having the file. It says, I have this matter. These people are coming here now. They want to be at 2:30. And I said to him, this matter, can it be heard the next day? You understand? So that is the way the discussion said. And the 31st is the next day because it was the 30th. And I said I can hear the matter the next day, which was the 31st.
So you didn't look at the notice of motion?
I hadn't looked at that matter, I must be honest. Okay. Because if I had picked it up that it was that urgent, I was going to hear. I've never refused to hear matters. And it would have been the first time that I refused to hear a matter when it was that urgent.
Thank you, Judge. Thank you, CJ.
Thank you. Were counsel or the lawyers already in the premises of the court when the registrar brought the file to you?
Yes, they were.
Well, shouldn't you have asked him or her to bring you the lawyer so you could ask them why is it so urgent that it couldn't be heard the following day?
I didn't ask for that, JP.
Because it's not the registrar's matter, and the registrar might not be a lawyer. The real people you should find out from are the lawyers representing the parties. Because if you had asked them, they would have told you that what we seek to interdict is going to happen in a few hours' time, so tomorrow will be too late.
Yes, JP, most of us should have, but at that particular time, it wasn't clear that what was happening. I must be honest, because I was with the registrar. Ordinarily, things don't happen like that. Most probably, I was not sure what is the process, because I get a role, I go to court, I'm told this matter is allocated, you go to court. So I think there was something that was not familiar.
Yeah, well, urgent applications come at all kinds of times. They come after hours. And so I think that you'd be well advised next time to say you want to see the lawyers there so that you can hear from them the degree of urgency.
Yes.
Okay. I don't think that there is any.
For interest sake, I'm sorry to come so late, but there was also something that was a objection from the Mate with regards to the issue of the.
You want to put it to her?
I just wanted, maybe she can also explain that.
No, I don't think she has had you talk to her. You want her to explain something?
So I'm sorry, good afternoon, Justice.
Good afternoon, Commissioner.
So there was also the issue of one matter that put an objection of you because of the use of.
Please speak up a bit.
Because of the approval, thank you, ma'am. Because of the approval of the use of a lie detector, there's something, maybe you can explain to us what is the issue there?
Yes, I can
And
explain.
it, maybe I must also, as an elderly, repeat to say that it seems as if you were very impatient in the case of the workers, and sometimes it helped to be a little bit more considerate. Thank you.
We're talking about the use of lie detector. In that matter, the perpetrator had already been dismissed, but the investigation that was conducted leading to that, maybe the context is that it would seem as if the complaint came when there were issues of performance, and then the complaint was registered. But the employer asked the parties through the investigation, and then a lie detector, I think it came because it wasn't clear to the employer at that stage, I think. And then, but as soon as it became clear that the result, the employer decided to follow a disciplinary route. The perpetrator was charged as soon as possible, and the victim participated through the process, and ultimately the perpetrator was dismissed, and the perpetrator challenged that decision, and it was unsuccessful. So here you're looking at the test in terms of Section 60 of the Employment Equity Act, when it says the complaint must be registered as soon as possible, and once the employer knows, and then what procedure they're going to take. So it would seem as if here the employer decided to take a disciplinary procedure, and then that is the context.
I'm really not clear, but I know you don't want us to ask a lot of questions.
Yes.
It's fine.
Thank you. We have reached the end of this interview. Thank you very much once again, Judge Mkuta Kontwana, for availing yourself. You are now excused.
Thank you.
We are at 2 minutes to 1. Should we eat and come back, or should we take another candidate? One more? One more. Okay. Good morning, good afternoon, Judge Savage. Please switch on your mic so I can hear you and everyone can hear you.
Good afternoon, Chief Justice and Commissioners.
How are you this morning?
I'm well, thank you.
Thank you. Thank you for availing yourself for this interview, for consideration for appointment to one of the positions in the Labor Appeal Court. I will ask you questions, and some of the commissioners will also ask you questions. We will do so to try and satisfy ourselves how you fare when we look at your track record and your knowledge and experience against the selection criteria that we have adopted for the selection of judges. We might be robust in our questioning, but we don't mean to humiliate you or anything of that kind. You hold 3 degrees, is that correct?
That is correct, Chief Justice.
BA, LLB, and LLM.
That's correct.
I see that after LLM it says summa cum laude. Is that for all the degrees or
no,
for the LLM?
That's for the LLM.
Oh, that's quite good. And I see that you are enrolled for the PhD in public law at UCT.
That's correct,
Since
Chief.
2020.
That's correct, Chief Justice.
How far are you from finishing your thesis?
Not as far as I would like.
Not as far as you would like?
No.
It's work in progress.
Work in progress.
Okay, all right. And you got your BA and LLB from the University of Cape Town, and your LLM you got at the University of Notre Dame.
Yes, that's correct, Chief Justice.
Is that right? Okay. You practiced as an attorney for some time, is that correct?
Yes, that's correct, Chief Justice.
How long did you practice as an attorney?
So I did my articles in 1992 and 1993. I was admitted in 1994, and I commenced practice then as an admitted attorney in January 1994, and I continued on. I then started my master's degree in August of 1994 and came back to South Africa in December of 1994. And the reason I then broke my master's degree in half, and I came back to work for the ANC and Parliament on the constitutional negotiations. I then completed the master's in 1997. And after I'd worked for the ANC and Parliament, for the Constitutional Commission of the ANC, I then was employed by the Constitutional Litigation Unit of the Legal Resources Centre in Johannesburg. And I worked there until I was then appointed at the CCMA as a commissioner until in 2000. And when at the end of 2000, I then started in practice again. So I've essentially remained working in the legal field all through from my admission as an attorney, and for many years as an attorney in practice.
Yes, but it looks like actual practice, you would go into practice for a short period of time and then go and do something else and then come back. Is that right?
It was really only the period from 1995 that I was working for the ANC, then went into practice again at the Legal Resources Centre, and then worked for the CCMA. But from 2000 then until my appointment as a judge, I was in practice.
Yes. And do you want to share with the Commissioner the nature of the work you did in your practice, how diverse the work was in terms of different branches of law?
Well, when I was employed at the Constitutional Litigation Unit of the Legal Resources Centre, my work was involved only in constitutional litigation and also in the certification of the Constitution. So I was involved in the certification of the Constitution case. And then when I left, and then all other constitutional related matters, I left the LRC and went into practice in 2000. I was then working, doing a lot of labour law, but some civil litigation as well. I did a couple of bail applications. I did some civil litigation, and perhaps a lot of labour law. Yes, I was also an arbitrator and a mediator from 1990, certainly from 1994, if I remember correctly. Might have been slightly earlier.
Was your practice as an attorney largely a labor law practice?
Yes, with some civil litigation, some mainly public sector litigation involving tender reviews or things like that later on. So much, it was civil litigation. It was certainly not criminal.
Yes. Okay. And you acted in the labor court in 2011, is that right?
That's correct, Chief Justice.
That was from some October to December.
Yes, that's right.
And then you acted also in the Western Cape High Court from October 2012 to 31 December 2014.
That's correct.
That was quite a long acting stint.
9 terms, and I applied for appointment and I went through the JSC in 2013. There was one position available in the Western Cape, and I then remained, I didn't get it, and I was remained on as a judge in the Western Cape, as an acting judge in the Western Cape. And I then applied on the next occasion and I was appointed.
Did your acting stint, that long acting stint in the High Court, help to expose you to other branches of law that you might not have had the benefit of getting exposure in your private practice?
Absolutely, in many and varied ways.
Yes. Are you able to share with the Commission what kind of branches of law you got to deal with when you were acting in the High Court? Well, actually, you can go on to tell me also after you had been appointed to the High Court, because you were subsequently appointed.
Yes, I mean, well, throughout my period at the High Court, I've been involved in all branches of law, from criminal trials, criminal appeals, criminal reviews, civil trials, civil appeals, civil reviews, administrative law, insolvency law, the law of contract, numerous and varied areas of law.
Were you appointed to the High Court with effect from 1 January 2015?
That's correct.
Yes. But it looks like you didn't take long after being appointed to the High Court that you got an acting stint in the Labour Appeal Court in 2015, same year.
That's correct, Chief Justice.
Is that right? The questionnaire here reflects that you acted in 21 terms. You acted for 21 terms. Is that true?
That's correct.
21 terms is a long time.
Yes.
That's how many years?
This is the 8th year. This is the 8th year that I've been acting in the court.
Yeah,
so
but your question
says it's 21 terms.
So it says 21, or that's up to 2023.
Yes.
Okay. How come you didn't avail yourself for appointment to the Labour Appeal Court earlier rather than acting for so long?
Because there have been no positions advertised, Chief Justice.
Oh, this is the first opportunity you had?
That is correct.
Okay. How did you find work in the Labour Appeal Court?
I've really loved it, the experience of working in the Labour Appeal Court. I enjoy appeal work immeasurably. I have learned a lot from my colleagues there. It's a very collegial court, and I've found the experience that I've gained there to be invaluable to me, both in that court, but also when I've returned to the High Court in my practice there, in my work there.
Normally, as I understand the position, and the JP will tell me if it has changed, normally if you got appointed to the Labour Appeal Court as a judge of the High Court, the position would be that you would serve in the Labour Appeal Court for some terms and then go back to the High Court and also serve there. You serve in both courts. Is that what has been happening? Is that what will happen, or will something else happen that is different?
I can't say what will happen, but I know that that has been happening to date. I've been on average serving 2 terms a year in the Labour Appeal Court and then 2 terms in the High Court. But going forward, I'm not sure what the arrangements will be.
The arrangement will be between the 2 JPs, but obviously they will hear what you have to say.
That's correct.
But you are happy to serve both courts in the way that it has been happening, if that is what is going to happen.
Yes, I certainly am.
Yes. Okay. Now, what can you tell the commissioners is your understanding of different schools of thought about the debate about the jurisdiction of the Labour Court and of the High Court in regard to certain matters where they have concurrent jurisdiction? Sometimes the Labour Court has exclusive jurisdiction. What are the debates? What are the different views that the various schools of thought have?
Well, the Labour courts have an unfairness jurisdiction, and then in terms of an unfair dismissal dispute jurisdiction, and then also have, in terms of Section 77(3) of the Basic Conditions of Employment Act, have a concurrent jurisdiction with the High Court in relation to contractual matters. So as far as the unfairness jurisdiction is concerned, that is established in terms of the Labour Relations Act, and in terms of the concurrent jurisdiction with the High Court under Section 77, that's established in terms of the Basic Conditions of Employment Act. However, the problem has arisen in relation, and it has risen over some years, in relation to claims that have been brought in the High Court of unfair dismissal in certain circumstances. And that started, and it was probably also before, in cases such as Chirwa, Fredericks, Gaba, and others, where an unfair dismissal claim was brought to the High Court, often by public sector employees arguing that the provisions of PAJA applied and that they were entitled to bring the case in the High Court. And over a period of time, those cases found their way to the Constitutional Court, and it was determined that the Labour Court held the unfair dismissal jurisdiction. Following this trend in cases, in more recent times, Edcon and Steenkamp was a case that emanated again out of the Constitutional Court, which was dealing with the unlawfulness of a claim of unlawfulness in relation to a dismissal, a termination of employment complaint. And what in that matter had occurred was that there was a notice issued in terms of Section 191A, in which the employee claimed that that notice was unlawful. And in the Constitutional Court, it was determined that the Labour Court lacked an unlawfulness jurisdiction, and therefore that there is a distinction when cases are brought on the basis of lawfulness and basis of fairness as to which court one may approach. That of course, has posed some problems because, and I think that it will continue to wend its way through our courts as we try and resolve exactly what the ambit of the difficulties that such a configuration then creates. For instance, in a suspension dispute, there might be an unlawfulness allegation, and does the Labour Court in that circumstance have jurisdiction or not? And there have been different views that have been expressed by judges in respect of these sorts of issues. But certainly as the law stands at the moment, unlawfulness and fairness are dealt with differently in our courts, and in terms of the jurisdiction of the Labour Court, the jurisdiction has been made clear because it is, after all, a creature of the courts established by statute.
Of course, you say that some public sector employees take unfair dismissals to the High Court. They don't take them as unfair dismissals, do they? They take them as alleging that they are administrative action and so on.
That's
or
correct.
That their constitutional rights have been infringed. Is that right?
In some instances, there have been claims of unfair dismissal, but obviously in others, the claim is not an unfair dismissal claim, it's a contractual claim, and one brought under PAJA.
Yes. And what can you share with the commissioners with regard to the different schools of thought on the applicability of the Prescription Act to labor disputes such as unfair dismissals?
It's another area in which we have many judgments of our courts in which there have been different views expressed by different judges, and often not always in a manner which has allowed for the issues to be determined unequivocally and finally. And unfortunately, certain of the judgments of the Constitutional Court bear this out. I mean, I sat in the Labour Appeal Court in the matter of Hendor, and that decision, with two of my colleagues, that decision found its way to the Constitutional Court in respect of prescription. And in the Constitutional Court it was a decision, a 4-4 split in that court, and so but it seemed that the common thread through the case was that the view was that the Labour Appeal Court had been wrong in relation to its treatment of prescription. In more recent times, we've had cases such as Pyman's Pantry and Coca-Cola. And in the Pyman's Pantry case was concerned really with the referral of an unfair dismissal dispute and whether what the relationship between the Prescription Act and the Labour Relations Act was in relation to the referral of an unfair dismissal dispute. So, for instance, could you refer a dispute up to 3 years, which is for purposes of the Prescription Act, you would be able to refer it and then seek condonation. And the decision of the court appears to be that that is so, that the Prescription Act applies and that one may then seek condonation. So that to the extent that if the claim is a debt, you're entitled to then approach, to refer the matter on that basis. In respect of Nyataza and Coca-Cola, well, Coca-Cola concerned the certification of an award and whether the Prescription Act applied to that certification, and it was found in that case that the claim had not prescribed, so the application for certification of the award had not prescribed, and therefore the Prescription Act would apply, and that meant that one had 30 years within which to approach the court. Nyataza is a more difficult case to follow, but essentially seems to be the same in respect of a judgment debt that the Prescription Act does in fact apply.
Well, thank you. What's the difference between a sympathy strike and a secondary strike?
Well, a sympathy strike seems to me to be a case in which different industries go on strike in sympathy with with a primary strike, and a secondary strike, as I recall, is different in the sense that it's a strike in a similar industry where one has a secondary strike in that industry. I may be wrong.
Yes, isn't there something with regard to a secondary strike that you must say about a demand?
Oh, absolutely. In the secondary strike, one has to serve a demand. There has to be a demand in a secondary strike.
Yes. And a grasshopper strike?
A grasshopper strike, as far as I recall, is where one is having different strikes at different plants in the same sector.
Just repeat that answer.
Different strikes in different plants, so that one has, let's say, in a company, one would have different plants on strike at a different, as it would be a grasshopper strike, as far as I recall.
Mm-hmm. If you are appointed to the Labour Appeal Court, you will be hearing appeals against judgments of the Labour Court. And at some stage, you might have to deal with decisions of the Labour Court judges where they exercised some discretion in making a decision. Are you familiar with the two types of discretion? If you are, would you tell us what they are and what the legal significance is of the differences between them?
Yes, there are two types of discretion in our law. One is a true or narrow discretion, and the other is a wide or a loose discretion. And in respect of a true discretion, the judge may take, in exercising that discretion, may take any one of a number of permissible routes. And those routes, the decision to take one or other of those permissible routes, cannot easily be interfered with by a court on appeal, and there can only be a set aside where the decision has not been taken by a judge exercising his or her discretion judicially, or where that judge has been influenced by wrong principle, or where there's been a misdirection of the facts, or where there's not reasonably, on a consideration of all relevant facts, it really falls quite far out of the bounds of the discretion. So capriciousness and so on might also come into it. A wide and a loose discretion, on the other hand, there's no choice between equally permissible options. And an appeal court can therefore interfere really on the basis of correctness. It can take a different view to that taken by the judge.
Yes, thank you. I will now give the JP the opportunity to put questions to you. JP?
Thank you. Thank you, Chief Justice. Good afternoon, Ms. Savage. Tell me,
Good afternoon, Judge Radley.
when you talk about correctness, is there any particular area where correctness would apply on review rather than the narrower discussion or the wider discussion?
In a review situation, for instance, in a constructive dismissal, or
I can't hear you.
In a constructive dismissal case, perhaps, or I'm not sure in what context you're referring to.
What test will apply, the narrow or the?
In respect of a wide, sorry, I'm not.
Where there's
perhaps
a
you could
decision
repeat your
made by the Labour Court.
Yes.
If you talk about a constructive dismissal case, and it applies, the Labour Court exercises the discretion on whether the dismissal was fair or unfair, let's say that. It comes up to the Labour Appeal Court. What do you look at? Would that be, would you now look at correctness of the decision or not? That's one example. Another example would be where the court decided that it had no jurisdiction to entertain that matter. It exercised discretion to say no jurisdiction. That comes on appeal. Would that be what test? Would the correctness test apply or not?
Yes, I mean, it would be a correctness test.
I can't hear you.
It would be a correctness test.
Would be a correctness test. Okay. I've noticed that you've been, you've acted, you've been in the Labour Court, you're permanently in the High Court, you've acted in the Labour Appeal Court for a while, you've acted in the Competition Appeals Court, you've also acted in the Supreme Court of Appeal. Now, with regard to all these acting stints and all the work you did, would you agree that the notion that the Labour Court is a very restrictive field, a limited field, or at least the Labour Court exercises jurisdiction in a very restrictive and limited field? Or would you say, after 8 years at the Labour Appeal Court, that it is in fact a court where all sorts of law is involved, that when you sit in the Labour Appeal Court, you don't just have straitjacket Labour Court, Labour law matters, but you have matters dealing with admin law, contract law, commercial law?
Yes, that's correct. There are a number of issues that come into play in labour law. And those are not only contract, also administrative law, also public sector issues that come to play. And I am firmly committed to the importance of the labour courts and their functioning, because I believe very, very firmly that an efficient and fair functioning of labour relations in this country is important for the development of the labour market, important for economic growth, and important for employment creation and poverty reduction. All of these are really important aspects. The importance of having a functional labour court cannot be understated in this country. That is my view. And it is an area of law in which, given the fairness and equity, the sort of mandate under the Labour Relations Act, it's one of the areas of our law which I find is very much, it's closely related to the way in which I like to approach things in this country. And that is that one needs to seek greater and greater one needs to strive increasingly to seeking fairness and justice across our society in many, many different areas.
One of the issues that I think judges, and all judges, including the High Court, are now facing is because of cost-cutting measures and all the other measures dealing with finance, is the ability to afford law reports. And tutors has become so expensive. Now, I understand that you sit on the board of SACLI. Can you tell us how does that assist us in any way, at least the judges and the courts?
How long do we have?
You've got a minute and a half.
I've been very centrally involved in the creation of SAFLI over the course of about 15 years, from when it was at the Constitutional Court, and then we moved it to the. It was associated with the Library of the Constitutional Court. I was on the Constitutional Court Trust at that time, and we, as a trustee, and we were very involved in setting up SAFLI. I'm very, very passionate about SAFLI as a project, and I put a lot of my free time into SAFLI. I believe that it serves an important purpose, not only in ensuring access to justice by ordinary members of our society, but also it serves a very important role in advancing the rule of law through accessing judgments, but also in judicial accountability issues. I am concerned that our contracts with the commercial law reports have been curtailed in some way. I'm not entirely au fait with where we stand on those issues. I have concerns that they cost the state an enormous amount of money in circumstances in which the state judges are in fact the authors of much of the product. So that there are difficult issues that arise in relation to commercial law reports in terms of what type of money is made available to access those law reports. I am concerned, and I do know that judges all access SAFLI, but I am somewhat concerned that there is increasingly less access available to other law reports, given that we in SAFLI simply do not have the funds to have head notes and to have the sort of add-on products that are available in the commercial law reports. We're also not able, and we don't have the funds, to involve ourselves in noting up judgments, although we're trying very hard to try and see whether we can't do that. The moment what we're trying to do, and our main role is, our main task right at the moment is to ensure that we've got a full set of law reports. And most recently we've added the law reports that date back to the 1890s, right up, and we've got some gaps. We've got a lot of Supreme Court appeal law reports in prior AD, so we've spent a lot of effort in all of those law reports. But there is still a role for commercial publishers and access to commercial reports.
Thank you. I see on page 8 and 9 of your questionnaire, you've listed the full list of your publications, which is quite a comprehensive list. It goes on, I think, right until page 11. Do you still write
No,
articles?
I don't really write. I write judgments now. I have had 3 children, and I haven't had a lot of time to write.
Thank you. And one last thing I want to ask you is, following up from what the Chief Justice asked you, if there is a need or there's a decision or need that labor appeal court judges are required to be full-time in the labor appeal court, would you then decide to go back to the High Court, or would you be happy to stay at the labor appeal court?
I would, on my feet, I'd be happy to stay in the Labour Appeal Court, but I would like the issue to be discussed with me and to understand the precise terms on which I would then depart the High Court, if that was possible.
Thank you. No more questions, Chief Justice.
Thank you, JP. Minister?
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Minister.
I see you have also worked, in addition to your work with the SAFLI, which is commendable. You are also working or worked with the National Community-Based Paralegal Organization that works across the country
Yes.
for access to justice. Why do you think this work on access to justice, firstly with SAFLI and with this paralegal organization, is important for our constitutional democracy and for access to justice by members of society, and in particular the vulnerable in our society?
Excuse me, I missed the last part of your sentence.
In particular, the vulnerable in our society.
We live in a really deeply divided society, and one in which we have the unfortunate label of being one of the most unequal in the world. And for me, that is and the legacy that we come from in terms of our legacy of racial discrimination and our legacy in terms of the kind of poverty, the extent of poverty and and lack of access faced by so many of our people, of South Africans, at all levels, around the country. These are issues that throughout my life have always worried me. I grew up in a family in which these issues were issues of concern for our family, and I continued in my days as an activist at UCT when I was there. In my work as an attorney, I've always been involved in cases that have been centrally interested in human rights and access to justice. I remain still firmly of the view that we need to ensure that people always have access to the law in order to be able to resolve their disputes, in order to be able to understand their rights, in order to be able to exercise their rights, and in able to, in fact, realize those rights to the greatest extent possible. And we have so far to go in all of those areas. And that makes access through paralegals and through lawyers around the country so enormously important for so many people.
Thank you, CJ.
Thank you. I have already got 7, but I've included myself. And so I'll exclude myself and put Commissioner Matolo Zeb. Okay, thank you. Justice Molamela.
Thank you very much. Good afternoon, Justice.
Good afternoon, President.
I note that you acted at the SCA for 1 term.
Yes.
And that you delivered a judgment there. You penned a judgment, Engine Petroleum versus Flow Tank Transport.
Yes, that's correct, President.
I read the judgment. I noted it was marked reportable and that it was handed down within a month of the date of the hearing, which is good.
Thank you.
My question to you is, do you think that acting at the Supreme Court of Appeal gave you exposure? And if it did, what kind of exposure did it give you? And do you think that that exposure will stand you in good stead at the Labour Appeal Court? And if so, how? Thank you.
Thank you. I acted for 1 term. I was in fact asked to act for 2, but I was unable to make the 2nd term given that I had my long leave due to me and I had decided I was going to work on my PhD. So unfortunately I was unavailable for the 2nd term. However, the experience was absolutely invaluable to me. It was really, I brought, I think, my experience in the appeal court that I had as an acting judge for so long in the Labour Appeal Court to the Supreme Court of Appeal, and I found that useful. It certainly gave me some confidence in dealing with appeals. It did take a little time to get used to the different ways and of operation of the SCA, but the range of work was very exciting, and I found it quite very interesting and enjoyed it thoroughly. I certainly think that I gained a lot from it, both in seeing sort of across different areas of the law, how one similar approaches to the work of an appeal court, in fact, they're shared, there are similarities that are shared. Yeah, I think that have I missed a part of the question? I think that might have answered the question. Did I?
Yes, how would that exposure assist you if you were to be appointed to the LAC?
Yes, I think that exposure has definitely assisted me. It's a very rigorous, often, process sitting in the SCA with a lot of debate that is, with judges expressing firm views one way or the other. And that I found very useful and interesting, and I found myself comfortable in that space. And it's certainly something, the Labour Appeal Court is often not as vigorous a debate, and I certainly think that I bring with me back into the Labour Appeal Court that experience and the experience of my colleagues in the court that don't work in labour areas, but from which I learned an invaluable amount. Thank you.
Thank you, Chief Justice.
Thank you. Commissioner Marumohai.
Thank you very much, CJ. Good afternoon, Judge.
Good afternoon.
When I went through your CV, I saw that you wrote one of probably the most important judgments in a panel of 3, the Campbell Scientific Africa versus CIMER.
Yes.
That dealt with probably one of the most sensitive issues in South Africa, which the issues around it are never discussed fully because of the sensitivities around it. I just want to pick a brain with you. Because on the one hand, we find that there are employees, once they are accused of sexual harassment, they resign. And you find that the matter sometimes dies there, despite the importance. And it is not dealt with accordingly as it should. On the other hand, there's a debate that says sometimes you see that sexual harassment is used as a tool to to deal with other employees. Where is the South African law at currently? And is our law striking an appropriate balance to allow us, one, to have frank discussions around the issue with a view to ensure that we find lasting solutions on how to deal with sexual harassment in the workplace?
Of course, in the context of labour law, if somebody resigns, then one in fact doesn't have any further jurisdiction over them in terms of discipline. So that's a difficulty that's somewhat poses some complexity in the sense that one could have serial sexual harassers, a person who's a serial sexual harasser moving from one workplace to the other without ever having been found to have committed sexual harassment. But as far as the sexual harassment is concerned, I know that in respect of that judgment, I was criticized in an academic article for setting the bar so low in sexual harassment that one could not help but trip over it. Well, if that is so, then that bar is already so low for women in the workplace. And what this judgment does is try to set quite clearly that when a 24-year-old woman goes to work in a foreign country for a company with South African colleagues, she is not fair game who can just be preyed upon. And that under any circumstances, and it doesn't matter what is said. We got into a lot of debate in that matter about, well, what was said was all very insignificant and trivial. It's really important, I think, to set quite clear guidelines as courts as to what is acceptable conduct in the workplace. If we're going to change a culture in which women can access work and the workplace properly as equals, then we need to make sure that we really do make that an equal environment. As far as people, of course, there's always a problem of people coming up with bogus complaints. One can't stop people coming up with bogus complaints that have no merit. In different workplaces, humans are complex and varied, and some have different kinds of problems, and they can be men and women and face those problems. So I'm not too sure that the law can necessarily stop that. But of course, what we do in all cases is ensure that when somebody's accused of sexual harassment, one looks carefully and properly at all of the facts that are relevant to the matter and doesn't just jump to conclusions that because I'm female and a judge, I'm going to find everybody guilty of sexual harassment. Quite the contrary.
Thank you very much, Judge. Thank you, CJ.
Thank you. Commissioner Singh.
Thank you very much, Chief Justice, and good afternoon to you, Judge Savage.
Good afternoon, Commissioner.
Mine is just an observation, Chief Justice. And
okay.
Since you come from the labor court environment as well, it would seem that only visionaries and prophets apply in the labor court environment. And I'm saying this from an informed basis because when I look at what Judge Botlare said in 2016, the last thing that he said to this commission when he was questioned on whether he would be lost to the labor court environment, he said, one of my visions at some point is that the judge president in the labor court may invite me to sit in the LAC, and then I can take even the experience that I acquired in the labor matters to deal with them at the labor appeal court level. And that was said 7 years ago. And Ms. Savage then, when you were interviewed in 2013, this is what you said. I am now so comfortable in the High Court that I don't believe I would seek an appointment in the Labor Court. And that does not, of course, in many years to come, necessarily bar me from further involvement in the labor sphere. If it were in my future career possible to serve on the appeal tribunal involving labor matters, I would be prepared to do so. But that is far too far in the distant future for me to say. But that distant future has come for you 10 years later. I just thought I'll make that observation. Thank you.
Thank you, Commissioner Singh.
With grey hair, Commissioner.
Judge President Mlambo.
Thank you very much, CJ. Good afternoon, Judge Savage.
Good afternoon, Judge President.
I believe that me and you will be on a panel In a month to come in the LAC?
Yes, I think so. In Cape Town, if I'm correct.
Yeah. Well, I'm taking advantage of this since we're talking about SAFLI.
Mm-hmm.
You say there's a continuing role for commercial publishers, but isn't it correct that SAFLI publishes everything? Commercial publishers are selective.
That's correct.
Now,
We want to publish everything. Some courts don't send everything, and that's something we're working on.
I see. Are you aware that the CJ has a committee that's looking at judicial law reports in South Africa?
I had heard so, yes.
Would you be interested in bringing to bear or to that committee your expertise and experience at SAFLI to assist the judiciary not to reinvent the wheel and see what can be done to come up with a fully functional judiciary law reporting structure?
I would leap at the opportunity.
I see. Well, you got me into trouble regarding SAFLI in a different matter, which I'll take up with you offline. Thank you, CJ.
Thank you, JP.
Judge President, could I just add one tiny little addition, and that is just to mark, if the issue is SAFLI, that we are sitting with a problem in relation to legislation, and that it might be something that the judiciary is interested in.
Thank you, Commissioner Matolo-Lepu. Subject to those on the platform, she should be the last one.
Thank you, Chief Justice. It's actually a follow-up on the issue of SAFLI. I wanted to know, I remember about 2 years ago, LPC undertook to fund
Yes.
partially SAFLI. And so far, how's the relationship now? Because I haven't read anything about
We
it.
have been enormously lucky because the attorneys' profession, as well as the bar, have come to the aid of SAFLI. And so currently where we stand is that the attorneys' profession gives us some money every year on an amount that is budgeted that they believe is an appropriate amount to give to SAFLI. And then we have developed a somewhat unusual, but a model which has worked really well, which is that across the GCB has agreed that every senior member will contribute 80 Rand per month to SAFLI and junior members 50 Rand per month. And that has kept SAFLI going. So we have been enormously grateful to the legal profession for keeping SAFLI going, and I think into the future it's certainly something. What I would like to see is that if we could, that the Justice Department or even Parliament get involved in assisting with legislation so that we were able to keep legislation updated, both in terms of point-in-time legislation, but as the legislation comes out of Parliament, that we were able to have a person employed to simply put the legislation up and keep it updated so that there was a central resource in respect of legislation that could be accessed not only on SAFLI but on gov.za, as well as across all the ministries in the country, but so essentially across government and the three arms of it. That central database of up-to-date legislation, which I think is a very urgent need at the moment because we rely essentially on commercial production of it.
Thank you, Commissioner. We have come, commissioners on the virtual platform. I didn't see any hand. I assume there is no one who has a question.
No questions, CJ.
Thank you very much. Thank you.
Thank you very much for the opportunity, Chief Justice.
Thank you very much, and you are now excused.
Thank you.
Thank you. We are at 1:45. I think we should take deliberate and then take lunch. Deliberate about the DJP position. You want after?
There's one candidate. There's one candidate.
Oh, there is still one more candidate. Oh, then let's interview the candidate after lunch, and then deliberate. But I think the speed for today is good. But it's because everyone is on board, is cooperating. Let's continue like that. Okay, let's go and have lunch and come back at 2:30. Is that all right? Okay, all right.
Good afternoon, Chief Justice.
How are you this afternoon?
Well, thank you. It's a different experience to be on the other side of the bench. It was,
You have experienced what? On the other side. Well, it's not the first time that you come before this body.
Chief Justice, I was in this chair almost exactly 15 years ago.
A lot has changed since then, eh?
Yes, it has.
Welcome to these interviews, Judge Van Niekerk. I want to thank you for availing yourself to be considered for one of the positions in the LAC. I will ask you some questions, and some of the commissioners will ask you questions, and all the questions will be aimed at establishing how your track record fits into the selection criteria that this body has adopted for the appointment of judges. Now, you and I have known each other since the 80s, I think. Am I right?
Yes.
Yeah, a long time ago. Okay, no, thank you very much. We are going to start. You hold a BA and an LLB from Wits, is that correct?
That's correct, Chief Justice.
And then you also have an LLM from Leicester University, is that correct?
Yes, that's correct.
Do you have an MA as well? I think I saw something.
Yes, from
you have
the
an MA as well.
that was an MA in the Department of Philosophy at the University of the Witwatersrand, yes.
Oh, okay, okay. And you were admitted as an attorney. When were you admitted as an attorney? Was it 84?
Chief Justice, that's correct, 1984.
1984. And you practiced as an attorney continuously until you were appointed as a judge of the Labour Court?
No, Chief Justice. Between 1986 and 1998, I was a corporate legal advisor.
Oh, okay,
And served in that role until I returned to practice in June 1998.
Okay. And you then practiced again from 98 until the time when you were appointed to the Labour Court?
That's correct. That was the 1st of January 2009.
That was 1 January 2009?
That's correct.
Yeah. And that was during my time?
Yes,
yeah.
Chief Justice, you were then the Judge President of the Labour Courts.
Yes. But you have a long history with labour law, is that correct?
Chief Justice, virtually all my professional life, which extends over almost 40 years at this stage, yes.
Yes. I know you wrote a book on unfair dismissal at some stage, is that correct? Or?
That's correct. That was published in 1994, and believe it or not, more than 30 years later, it's still referred to in judgments by the Labour Courts.
Yes. But there's another one that you wrote, I think, much later than 94. I don't know, I think it was meant to be written in simple language to assist non-lawyers to understand, if I'm not mistaken, the one in which I wrote the foreword.
Oh, that's correct, yes. Yes, Chief Justice. There was a series of legal texts which had the title, What You Must Know About.
Yes,
That was what you must know about competition law, what you must know about collective bargaining. I wrote the book on unfair dismissal.
Yeah.
That was published in 2002, to which you kindly contributed the foreword.
Yeah. No, thank you. So during your time in practice as an attorney and at the time that you were a legal advisor in the corporate world, you were basically spending most of your time on either advising companies on labor law issues or when you were an attorney dealing with litigation as well?
Yes, Chief Justice. Although I must say, in the course of my practice, I probably did more work of a consulting nature than litigation.
Yes.
But
yes.
In both practice and in the corporate world, I was engaged full-time with labour law. And
yes. But also you were a member of the ministerial task team that drafted the bill that ultimately became the Labour Relations Act that we know.
Yes.
In 94. Is that right?
Chief Justice, together with you, in August 1994, I was privileged to be appointed by the then Minister of Labour.
Yes.
To what was called a task team.
Yeah.
To prepare a draft bill, which
Yeah.
would serve as the first piece of post-apartheid legislation
Yes.
of significance, and that became the Labour Relations Act as we know it.
Yeah. In terms of books, we've talked about two books that you wrote. Are there others that you have written?
Chief Justice, I've written a total of 5 books.
Yeah.
The one we've
labor law?
mentioned, or the 2 we've mentioned, deal with unfair dismissal. I wrote a book in the same series, which was What You Need to Know About Employing a Domestic Worker.
Yes.
I'm also one of the founders and co-editors of what's the standard text
Yeah.
for LLB and LLM students.
Yes.
Which is entitled Law at Work.
Yeah.
And the new edition of that publication is currently with the editors.
Yes, yes. And apart from books, you have also published numerous articles, is that correct?
Chief Justice, I counted over 60 articles which have been published by various labour legal publications.
Yes, yes.
Some peer-reviewed, some not.
Yeah.
And I have contributed chapters to books on labour law.
Yes. When you were still in private practice, did you also not have some working relationship with the ILO?
Yes.
Or at some stage?
Yes, I did, Chief Justice. I was appointed by the ILO to engage in various projects, some of which were in the broader SADC area.
Yeah.
I did some work in Botswana on the development of a statute to regulate labour relations in the public sector.
Yes.
I did some work in what's now Eswatini on the development of a Basic Conditions of Employment Act.
Yes.
I also participated in training programs in Beijing, in Kuala Lumpur, and in Bangkok. I also, in relation to ILO activity, was the part of the South African delegation to the ILO's conference, which is held in Geneva every June. Mm-hmm. And I attended that first in 1994, when South Africa was readmitted as a member of the International Labour Organization, and broadly through until the end of my period in practice, when during which course I sat on the Committee on the Application of Standards, which in essence is a committee that examines compliance or otherwise by member states with ratified conventions.
And have you counted how many reported judgments you have written as a judge of the Labour Court?
Chief Justice, I tried my best. They're probably at the stage over 220.
Over 220.
Judgments which have been reported since I first started acting in the Labour Court.
Yes.
In 1999.
Yes.
Up until the present.
Yes. Well, you have certainly been familiar with debates that have happened in our modern labor law from the 1980s into the democratic era. So you are familiar with lots of debates that have gone on certain issues relating to labor law. Is that correct?
Chief Justice, that's correct. I just hope that,
Yes.
I hope that I haven't been responsible through my drafting for some of those debates.
And one of those that, one of the issues that have been raging on since the 1980s and continues to rage on in labor law is the question of the jurisdiction of the labor court and the labor appeal and the high court. Of course, prior to, in the 80s, there was no labor court, there was an industrial court, but even then, there were debates about what fell within the jurisdiction of the industrial court and what fell within the jurisdiction of the high court. Some of us hoped that under the post-apartheid legislation on labor law, that debate would be done away with. It wasn't done away with, it continues. Would you like to share with the commissioners your own understanding of the different schools of thought about what should be under the jurisdiction of the labor court and what should be under the jurisdiction of the high court?
Yes. Chief Justice, I think the original intention when the Labour Relations Act was drafted was to establish a labour court or a labour court system, being the Labour Court and the Labour Appeal Court, as discrete specialist courts which would have jurisdiction in respect of all employment-related matters. Regrettably, that's not the way in which the Act was finally adopted. And in terms of Section 1571, the Labour Court has jurisdiction only in respect of matters where jurisdiction is conferred on it, either by the LRA or some other statute. That gave rise immediately to a series of judgments where employees relied, for example, on contractual rights. The SCA at that time certainly held that its jurisdiction hadn't been ousted.
I'm sorry, Judge
Yes.
Van Niekerk, I'm sorry. Can everybody hear him? You are able to hear him? Okay, all right.
Yes. The SCA held
Okay.
that. The SCA held that its contractual jurisdiction hadn't been ousted by the Labour Relations Act. We then had cases where employees, particularly in the public sector, sought to rely on the constitutional right to fair administrative action and advance claims in respect of employment-related decisions by the state in its capacity as employer. It's taken a long time, probably more than 20 years, to get to a point where I think we can now satisfactorily say, after the recent judgment by the Constitutional Court in the Beloy decision, that the Labour Court's jurisdiction is circumscribed, and its jurisdiction is that which is conferred on it by the Labour Relations Act and by any other statute, for example, the Employment Equity Act, the Basic Conditions of Employment Act. So that a litigant coming before the Labour Court must be able to point to the provision on which he or she relies to confer jurisdiction. That has meant that the civil courts obviously retain jurisdiction in relation to contractual disputes where a contract of employment is the subject matter of the dispute. It also means that the High Court retains jurisdiction in respect of most matters which fall outside of the designated purview of the Labour Court's jurisdiction. Whether or not that is satisfactory is something for the legislature perhaps to consider in due course. I'm aware, Chief Justice, of a judgment written by the Labour Appeal Court probably, more than 20 years ago, where the state of affairs was bemoaned and a specific call was made on the legislature to clarify the law and to ensure that all employment-related disputes, however they emanate, form the subject of the Labour Court's jurisdiction. But as we speak, that's not the case.
No, thank you. And can you also share with the commissioners your understanding of the applicability of the Prescription Act to labor disputes, particularly unfair dismissal disputes, and the different schools of thought there too?
Chief Justice, yes, there are two broad schools of thought, and the divide is sharp. The one school of thought is to the effect that the Prescription Act does not apply at all in any form to the Labour Relations Act. The other is that, well, it does, at least in some respects. And we've seen these two schools of thought, opposing as they are, play out in a number of important decisions by the Constitutional Court. There was the Miateza Metro bus dispute, which involved an arbitration award, which the union had sought to make an order of court. The Labour Court and the Labour Appeal Court held that the award had prescribed. Again, we had three judgments in that case, two of them holding that the Prescription Act was entirely incompatible with the Labour Relations Act, a third judgment which sought to reconcile the two statutes. We then had the later case of Pyman's Pantry, where the issue was not an arbitration award, rather than a claim for unfair dismissal. And again, that had been, the Labour Court had held that the claim had prescribed. The Labour Appeal Court, again, writing, there were three judgments given in that case. The first two holding that, again, the Labour Relations Act and the Prescription Act were incompatible. One of those judgments emphasising the package that the LRA formed and the checks and balances that were very carefully included during the course of the drafting of that statute, and finding that had the drafters intended that the Prescription Act apply to claims which are processed under the Labour Relations Act dispute resolution procedure, well, they would have said that. There was a third judgment in the same case which found that a claim for unfair dismissal was a debt for the purposes of the Prescription Act, but that on the facts of that case, the claim had not prescribed, as the Labour Court had held. There was a further decision, I think, in Hendel, where it was made clear that a claim for back pay that attaches to any award of reinstatement after a successful unfair dismissal claim constitutes a judgment debt, and the 30-year period of prescription applied in that case. So to sum up, Chief Justice, we still have one strong school of thought which holds that the Prescription Act does not apply in any way, manner or form. We have another view which suggests that at least in respect of a claim for unfair dismissal, the Prescription Act does apply, but that prescription is interrupted once a claim is referred to the CCMA for conciliation.
Thank you. Would you like to explain to the commissioners the difference between a sympathy strike and a secondary strike? Commissioner,
a secondary strike is defined by the Act. It's a strike in which employees of what we call the secondary employer strike in support of a demand that the secondary employer place pressure on the primary employer to meet the demand made by its employees. And these typically arise in the case of a supplier-client relationship. A secondary strike is a sympathy strike. Sympathy strike is a term that's very often more loosely used to describe any action in support of action taken by employees of another employer But the definition of secondary strike in section 66(1), I think it is, makes clear what a secondary strike is for the purposes of the LRA.
And a grasshopper strike? Grasshopper.
A grasshopper strike. I can't recall that the LRA addresses the issue of a grasshopper strike specifically, or that we've ever had any cases on it. But it's known in industrial relations parlance as a strike where employees across different departments, for example, will strike intermittently, thus disrupting the entire business operation. But to the extent that smaller groups of employees are involved on each occasion.
Okay. If you are appointed to the Labour Appeal Court, you will find yourself dealing with appeals from the Labour Court, judges of the Labour Court, and sometimes you will be called upon to set aside decisions that they have taken in the exercise of one type of discretion or another. Would you like to share with the commissioners what the two types of discretion are that we have in law, and explain the difference between them and why that difference is important for adjudication?
Chief Justice, the distinction is one drawn between a wide and a narrow discretion, and perhaps the best way to explain the difference between the two, and this is the teacher in me, is by way of example. If one looks, for example, at Section 193 of the Labour Relations Act, it concerns remedies that may be granted where a dismissal is found to be unfair. In regard to compensation, the Act requires that employees be reinstated. There's a list of factors which can be taken into account to form the basis of an award of compensation. For example, if the employee doesn't want to be reinstated, if reinstatement is not reasonably practicable, or if a continued employment relationship is intolerable. Here, what the decision maker, be it an arbitrator or the court, needs to do is to have reference to those statutory factors with regard to the evidence that's been led and make a decision. In those circumstances, it's open to an appeal court or even a review court to find that the decision is incorrect and to substitute the decision for that of its own. On the other hand, the very next section, Section 194, deals with the quantum of compensation and fixes limits on compensation, but doesn't otherwise dictate, with reference to any particular factors, how that discretion must be exercised. And there we would talk about a narrow discretion, or sometimes called a true discretion, where the scope for interference is limited. And here an appeal court can only interfere where the discretion is not exercised judicially, or the discretion is exercised capriciously or on the basis of wrong principle, or where it's brought about by a biased judgment. In other words, the court's not entitled to interfere only on the basis of correctness, that it would have awarded a different amount of compensation. So to that extent, there's deference shown to the decision maker, simply because the nature of the discretion is narrow rather than broad, as applies in the determination of unfair dismissal remedies and the award of the remedy of compensation in particular.
Thank you. I think I left out to ask you, because I think you were a professor of law for quite some time at Wits, is that right?
Chief Justice, I've been a professor at the University of South Africa. I've held visiting professorial appointments at both the law school at the University of the Witwatersrand and the University of Johannesburg.
Yes. And in that capacity, were you teaching labor law?
Chief Justice, I was teaching labor law mainly at postgraduate level.
Yes.
at both Wits and UJ.
Yes, thank you. I will now give the opportunity to the Judge President of the Labour Appeal Court to put questions to you.
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon,
Maliki.
JP.
Yes, you've written over, you've got over 200 reported judgments, over 50 published articles, I think you said over 60, where you've dealt with all aspects of labor law. So I'm not going to test you on labor law knowledge. No. But what I want to ask you is this. One of your earlier judgments, which I thought wasn't only a very important and a remarkable judgment, it's a judgment often cited in the Labour Appeal Court, and that's the Avril Elizabeth Holmes.
Yeah.
I thought it's a very important judgment. It deals with disciplinary inquiries, how one does not need to follow strict formalities. But yet, after repeatedly emphasizing that judgment, it still appears that the labor law community continues, especially big business, to hold a disciplinary inquiry as if it's a criminal trial. And what does one do about that? Is there any words of wisdom you can give us on that issue?
Well, Chief Justice, yes. Let me just, as a background to my response, the judgment was written, I think when I was still an acting judge. But what I sought to do was to place emphasis on the code of good practice relevant to unfair dismissal, which is an annexure to the Labour Relations Act. And one of the concerns raised during the discussions between business, labour and government, which took place in 1994, 1995, was the duplication in disciplinary process. Because by that stage, the industrial court had developed guidelines. Employers were holding disciplinary hearings which would make any criminal court proud, as you've mentioned. The difficulty then is that those disputes would then be referred to the industrial court, nowadays the CCMA, where a hearing would be held from scratch. In other words, the entire process would be duplicated, and a decision would then be made. And certainly when we drafted the LRA, we weren't aware of any other country in the world that adopted that model. And what that judgment does is simply draw attention to the code of good practice and remind those engaged in the labour market that primarily justice was to be sought by way of an arbitration in the CCMA, where the employer bore the onus of proof and where it had to prove a case from scratch if it wished to sustain a finding of unfair dismissal. And as you point out, regrettably, parties have held on to the onerous disciplinary codes and procedures that were developed during the 1980s and 1990s and have been unwilling to embrace the conception of especially procedural fairness that is embodied in Schedule 8, the code of good practice. Whether it's just an unwillingness to engage, or whether whether employers especially find it difficult to change and to adopt to a new system, I don't know.
I know, it is very difficult. We have, I think, in different occasions, you have spoken at conferences, I have spoken at conferences about this, but it appears that CCMA commissioners are of the view that if you don't hold a proper inquiry, it's procedurally unfair. And despite a number of discussions and discussing this case, it doesn't appear that anyone is moving from that premise.
Judge President, what's important is that the Code of Good Practice is modelled on the ILO Convention on Security of Employment. So it complies with international practice. The problem we have in this country, frankly, is the degree of duplication. Yeah. So I'm sure we have both, through you, Chief Justice, come across cases where a dispute, a disciplinary hearing is conducted before a senior counsel with legal representation on both sides. That hearing could go on for anything up to 2 weeks or more. a decision is made, and thereafter a dispute is referred to the Bargaining Council or the CCMA in circumstances where that decision simply triggers a referral. It substantively means nothing. And the CCMA or the Bargaining Council arbitrator then initiates a hearing from scratch, a complete rehearing on the merits.
Whole process is repeated.
Which makes one wonder what the value of internal processes are. If one looks at the ILO standards, it's simply to afford an opportunity to state a case before a decision on any dismissal or other disciplinary action is taken. It's not what we find in standard disciplinary codes and procedures in this country. And frankly, I think that's costing this country a lot of money. Some economists have tried to quantify the amounts, but it's vast.
I think perhaps something else needs to be done, because there's a belief, perhaps wrongly, that if you don't hold a full inquiry, you're not having proper procedural process. And I think, despite number of articles and number of conferences where we've discussed this, there is no acceptance that going through not a formal process, but just a process which complies, where everyone can explain, would be sufficient, the wrongdoing. But it's not acceptable, so I don't know, perhaps might require legislation intervention, because right now it's costing both the employer and employee in terms of time and money, and that is a problem. Then coming to one of the things that's happened over the past few years, when I did not have a deputy to assist me, it's correct that I solicited your help quite often to run the labor court.
Yes.
And so you have been assisting in the running of the labor courts, but also in your past life, you were party to drawing of the rules of the labor court, is that correct?
Well,
So the rules that now apply, the old rules,
yeah.
you were party to drafting them.
Chief Justice, through you, I was appointed to the first rules board of the Labour Court in 1996, and together with then Judge Johan Frenneman, we read the rules. Those were superseded by a series of rules that were adopted, if I'm not mistaken, when the Chief Justice was the Judge President of the Labour Court. I drafted those, and as you're aware, JP, there's the new rules board was appointed last month, and a new set of rules will hopefully appear soon. And I've through your kind of
And you are involved in the new rules board, and hopefully you will have a new rules being adopted very soon. Thank you. I have nothing further, Chief Justice. Thank you.
Thank you, Minister.
Thank you, CJ, and good afternoon, Judge.
Good afternoon, Minister.
My question just is one related to what you'll have seen the PLA in their comment saying you are going to serve in that court for 4 years.
Yes.
Do you think you'll be able to implement your vision and be able to dispense justice in that 4 years and help that court?
Again, through you, Chief Justice, Minister, 4 years is a long time. I hope to be able to draw on the skills and experience and expertise that I've developed over the last 40 years to make a contribution to the jurisprudence of the Labour Appeal Court.
Thank you, CJ.
Thank you. Commissioner Marumwaha.
Thank you very much, CJ. Good afternoon, Judge.
Good afternoon.
I'm not sure if you still remember, but I was in your class in 2012.
I recall you, Professor, as one of my students here.
So I'm not going to be dealing with any case with you, because I will basically be wasting my time. But I want to ask you an academic question, which I think will be practically relevant in years to come. When one looks at the pace at which labor law is advancing, and currently when one looks at how trade unions have been impacted in terms of their membership and how the entire collective bargaining seems to be changing with time. I just want to understand, what is your view in respect of what is currently called the fourth industrial revolution and the impact of AI, artificial intelligence, in as far as the future of collective bargaining is concerned in South Africa? Perhaps it's a more academic question, but I think it will be quite important in the future. Thank you.
Yes, thank you, Professor, and through you, Chief Justice. The fourth industrial revolution and the advancement of artificial intelligence pose profound challenges to a concept of labor law which remains embodied in the personal employment relationship that has characterized labor law for decades. One of the difficulties with the LRA in its current form is that it was drafted when times were very different. It was a corporatist society where business was represented by large employer federations. The unions had major federations with high levels of membership and were influential in the social and political environment. That's changed, not only in this country, but all over the world. And what we've seen in the last 30 years is that model simply no longer being capable of sustaining a just regulation of the labor market. We've seen the emergence, for example, of platform workers. We've seen the emergence of all forms of atypical employment. Again, unions find it difficult to organize workers in those sectors. The consequences being, and again worldwide, a decline in union membership levels. Again, on the employer side, if you look at this country, the major employer federations appear to have fragmented, and one is having very different views being presented on the employer side of the table. So the question that arises, and it's a very valid question, is the LRA still fit for purpose? The answer is probably not. What we have seen is a commission of inquiry or the appointment of a task team every 30 years or so, simply to examine labor legislation to determine whether it adequately regulates the labor market so as to give effect to the constitutional values of equality, of dignity, and of the right to fair labor practices by all. Perhaps the time has come to reconsider whether the LRA is, as I've suggested, still fit for purpose, and whether a different form of regulation is required in order to meet the challenges that have been posed to traditional models of employment law, which no longer hold.
Thank you very much, Judge. Thank you, CJ.
Thank you very much. Subject to the commissioners on the virtual platform, I think we have come to the end of this interview. Commissioners on the virtual platform, is there anybody? I didn't see any hand. Is there anybody? I don't think there's anybody.
Nothing, thank you, Chief Justice.
Thank you very much. Thank you. Judge Van der Kerk, we have come to the end of the interview. I must once again thank you on behalf of the commissioners for availing yourself. You are now excused.
Thank you, Chief Justice, and thank you, Commissioners, for the opportunity to participate in this interview.
Good afternoon, Ms. Ellen Yaman.
Good afternoon, Chief Justice.
Did I pronounce your surname correctly? Did I pronounce your surname correctly? I said Alan Yaman. Are you sure? You must tell me if I'm not pronouncing it correctly. I don't like people not pronouncing my surname correctly, so I don't want to pronounce anyone's surname wrongly. Let me welcome you to this interview on behalf of all the commissioners. We appreciate that you have made yourself available for consideration for appointment as a judge in the Labor Court.
Thank you.
I will ask you questions, and other commissioners will also ask you questions. Our questions will be aimed at establishing how your track record fits in with the selection criteria that we have adopted for the selection of judges. We might be robust when we put questions to you, but we don't intend to humiliate you or demean you in any way. It will simply be an attempt to satisfy ourselves whether you meet all the criteria. You understand?
I do, thank you.
Okay, thank you very much. Do you hold 2 degrees, BProc and LLB?
That's correct.
Both of them from the University of South Africa?
That's correct.
And did you get your BProc with distinction?
That's correct.
And that was in 2000, eh?
Yes, if I recall correctly, yes, 2000.
And then you got your LLB in 2001?
That's right.
And then you did articles, is that right?
That's right.
And that was from Feb 2001 to February 2003, is that all right?
Yes, that's right.
And you were admitted as an attorney in April 2003?
Yeah, I haven't looked at the date specifically, but whatever I put in there, that sounds right. It was shortly after I'd completed articles.
Oh, you know, I still remember the day I was admitted as an attorney. I can tell you the date. You don't remember? It was not a big deal.
I think it's just because so much time has passed since then. And
too many other things have happened.
Yeah.
Yes. And then you changed at some stage and you went to the bar, is that correct?
Yes, prior to that, obviously, I worked as a professional assistant as an attorney in a capacity at 2 different firms prior to going to the bar.
Did you practice as an attorney for about 5 years or so?
Let me see, so it was about 3 years at the first firm at which I worked, and then I went overseas. I qualified as a solicitor, although I didn't find any legal work over there. And then thereafter, I worked for another year as an attorney in another firm here in Johannesburg. And then, yes, did my
So how long did you practice as an attorney then?
Yes, it would be about 4.5.
About
4.5 years, I think.
Okay, okay. And what made you change and decide to go to the bar?
A great deal of work that's conducted as an attorney involves a lot of administration work, not necessarily dedicated to the pure practice of law. It's client management to a great deal of one's time is spent on aspects which aren't specifically legally based, and I wished to focus exclusively on the practice of law.
Yes. And in your questionnaire at paginated page 11, you are required to outline your entire career in the law, giving an indication of your principal areas of legal interest and involvement.
Yes.
And you said, having completed my articles of clerkship in a general practice firm, I obtained employment in a firm in Durban Then your practice entail both litigious and non-litigious work relating to employment issues. This type of work was undertaken by me when I relocated to Johannesburg. As an advocate, I elected to maintain my practice in the field of employment law and have since commenced practice regularly representing litigants in the various fora dedicated to the resolution of employment law disputes. That's what you gave.
Yes.
You may have intended to, but you didn't specify, for example, which courts you may have appeared in. Have you been appearing in the labor court? Have you been appearing in the labor appeal court? How often have you gone beyond the labor court? Labor appeal court appeared in the constitutional court, even if it's on labor matters. You didn't give that kind of background.
Sorry, I thought that it was covered under paragraph 6 on the following page where it deals with court practice.
Sorry?
I felt that it was covered under the following page at paragraph 6 where it deals with court practice.
Oh, okay. No, then I think you may be right. But tell me in terms of the courts where you have been appearing as an attorney and as an advocate.
Well, starting as an article clerk, I would go to the magistrates' court fairly often. That was in a general practice firm, so anyone familiar with being what's now a candidate attorney will be well aware of Section 65 inquiries, as well as all those other small interlocutory applications that can be done in the magistrates' court. So that's where I started. Then when I proceeded to working as a professional assistant with Farrell and Associates, that was a dedicated employment law firm. And at that firm, I would be able to go then to the CCMA, bargaining councils, and the Labour Court. I don't believe I attended the Labour Appeal Court at that, no. Traveling then up when I came to Johannesburg, that, if I recall correctly, the nature of the work, because it was an employer-based, employer-focused firm of attorneys, there was less CCMA work for me, so I did on occasion appear in the Labour Court there, but most often in that firm the philosophy generally was to brief counsel, so it was somewhat rarer at that stage. Then having moved to the bar, although my practice has been predominantly labour, which has entailed appearing at the CCMA, bargaining councils, internal disciplinary processes, the Labour Court and the Labour Appeal Court. I have also appeared in the smaller part of my practice, which entails civil litigation in the Magistrates' Court and the High Court from time to time.
Yes. But as an advocate, you have also appeared in the Labour Appeal Court, is that right?
That's correct, yes.
Yes. Actually, at page 14, you have got a list of reported cases in which you have appeared, is that right?
That's right. Correct page. So, Chief Justice, if I may, I was going to bring this up later in due course, just something that's come to my attention on that page as I was going through it.
Yeah.
At the very bottom, I'm not sure how it's made it in there. It is a complete mystery to me. There is a case listed, Nongoma Local Municipality versus Biela and others. I had nothing to do with that matter. It is not one of mine. I've printed it out. I've looked at it. I wondered why its name was not familiar to me, and the reason is because I was not involved in that. I do sincerely apologize.
Yeah.
It was certainly not intentional. There's nothing particularly. It's very similar in principle to the Utugela one, so I don't, which I was in, but if that could please be removed, and I apologize for having included it. It was an error.
Yes, yes. But those are the reported cases.
The others all are, yes.
That how many are there? You didn't mark them.
Beg your pardon, ma'am?
How many are they? The reported cases in which you have appeared?
I didn't actually count.
Yeah, that looks like around 15 or so, maybe 20. I'm not sure. Maybe about 20. Does that sound more or less right?
As long as you've minus the one that I said wasn't.
Yeah. Yeah, well, I'm saying about, not necessarily exactly.
Yeah, it looks about 15 to me.
Yes. So it looks like you started appearing, or starting having reported judgments in around 2015, is that right?
The
No,
earliest,
2013.
I see a 2012 one
2012.
there. The Lovemore Brothers one.
Soon
seems to be
after you
2012.
started practicing as an advocate.
Yes.
Yes. And have you acted in the labor court?
I have Chief Justice for approximately, I think it's 48 weeks now in Durban.
48 weeks. That makes it how many months? In terms of acting stints, you have not been acting.
It's over.
In terms of a term, you have been coming for.
No, it's been a number of terms. The terms are listed there. From 2022, there was a month's period starting
Well,
from.
four terms would be a year. 4 terms.
Yeah, it's just a little short. I'm acting again now till the end of this term. So it was 1 month in the first term of 2022, another month in the third term of 2022, the whole of the fourth term, the first term of 2023, save for the first month because I had other commitments.
Mm-hmm.
And then that carried on through to the end of the second term, the whole of the third term, and now we're starting on the fourth term.
Yes.
So almost this year, almost continuously. Last year was slightly less, but
Yes.
the total is 48.
How have you found acting in the labor court?
I enjoy myself.
You enjoy yourself?
I do.
Okay.
I find it thoroughly challenging, indeed.
Yes. Now, which matters that you would say when they are brought to the labor court before you know this matter must go to the High Court, matters that are employment related? Which
So,
matters
Chief Justice,
would
if you could just,
say-
you mean specifically of ones I've dealt with or generally?
Generally. In other words, if I want you to give me a few matters, maybe 1 or 2 or 3, to say, no, but those, the labor court doesn't have jurisdiction in those employment-related matters.
Well, the starting point is 157, which gives Section 157, which gives the Labour Court and the High Court concurrent jurisdiction. Insofar as the things that the Labour Court cannot deal with would be those things that are exclusively required to be dealt with elsewhere in terms of the Act by other fora. Insofar as employment disputes which are not to be dealt with by the LRA,
Or which
Yeah.
could be dealt with, should go to the CCMA,
Yeah.
but which should not be dealt with by the labor court.
but did you say, I thought, Chief Justice, I thought you said High Court.
I said High Court, I would like that, but I would also like to know which ones you would say, no, those must go to the CCMA or.
Okay, well, let me deal with the
bargaining
CCMA
license.
first. That's probably easier. So,
Yeah.
insofar as the CCMA is concerned, it's any matter which the LRA specifies must be dealt with by way of arbitration proceedings. That would include anything under Section 191(5)(1)(a). Those are all your ordinary unfair dismissal disputes and unfair labour practice disputes. The only matters which are required to be dealt with by the Labour Court as far as dismissals are concerned would be operational requirements terminations on the larger scale, say for singular employees who have an election. If they wish to go to the CCMA, they may. Automatically unfair dismissals, and anything relating to a contract of employment arising out of Section 77(3) of the BCA.
Where should that go?
That can go to the Labour Court.
Yeah, okay.
insofar as, then there's obviously matters of concurrent jurisdiction and circumstances where there is a constitutional violation.
Yeah.
I'm having a very hard time trying to think of a labour matter which ought to go to the High Court, because I have a general view that those types of things ought to just go to the Labour Court if they can.
Yeah, if there are, you say there would be few.
Few and far between, because
Yeah.
something is either going to be a right arising out of the LRA or out of a contract.
Yeah.
Conceivably, sorry?
Then the Labour Court would have concurrent jurisdiction.
Under Section 70, well,
Yes.
concurrent jurisdiction under Section 157, or also concurrent jurisdiction with a multitude of other courts under Section 77(3).
Yes, yes.
And oftentimes, I believe what seems to happen is I've known it that individuals try to go and use the civil courts, the magistrates' courts, or the high courts for claims arising out of their contracts of employment, simply for payments of money. And then the difficulty they face there is that the magistrates in the High Court have this general view that it is not the right forum, and then they themselves find they don't have jurisdiction where they might otherwise have. So it's simply easier for them to come to the Labour Court if they can.
Yes, yes. Now,
If that has answered your question, I'm not sure.
Yes.
I still haven't found a High Court matter.
It might be difficult because the Labour Court has concurrent jurisdiction and exclusive jurisdiction, but the High Court has concurrent jurisdiction, but no
exclusive jurisdiction.
Yes,
Mm-hmm.
yes.
Thank you.
Let's talk about reviews of arbitration awards from CCMA and bargaining councils. What are the grounds on which the LRA says they may be reviewed?
Okay, well, the starting point for an arbitration award would be a review under Section 145(1), which provides that an arbitration award, actually arbitration proceedings, may be reviewed on the basis of any defect. Section 145(2) proceeds to define defect to include misconduct, gross irregularity, or the accession of powers, unless an award has been, can also be reviewed where an award is improperly obtained. Those obviously reflect fairly narrow grounds of review, and the courts were required to consider whether those very simply put grounds could be all that there was to it. And as our case law has evolved, I would say that there are 3 cases which evince the evolution of the test for grounds for review. The starting point would be Sedumo, the details of which are reflected in a 200-page judgment. So my brief summary of the conclusion reached in that is that ultimately, the ultimate test when one is assessing whether or not there's been a gross irregularity is whether or not the award is one which could have been arrived at by a reasonable decision maker. In amplification of that, to the extent that there may have been any ambiguity, the Supreme Court of Appeal subsequently in 2013 considered the matter in a decision that Hadholt, I'm sorry, I can't remember the rest, I only know it as Hadholt, I can't remember the rest of the citation. The question was that when will that be reviewable? And per the court was that for a defect to constitute a gross irregularity, the Commissioner must either have misconceived the nature of the inquiry or have arrived at an unreasonable result. And in the event of one or either of those scenarios would result in effect, a result that no reasonable arbitrator could have arrived at. And then finally, the LAC considered the issue in Goldfields.
Well, no, I didn't want you to go into details. I wanted you to simply say these are the grounds.
Okay. Well, those grounds would be reflected on the 3, the gross irregularity.
Yes, but you have said something that I want to follow up. You said, if I heard you correctly, that to determine whether there's been a gross irregularity, the question would be whether a reasonable person, I'm not sure whether you said would or could have arrived at the
Could.
decision. Did you say that?
Could, I think, is the test.
Could, you said, okay.
I might have said would, but
Yes.
I think it to me amounts to the same thing.
Yes, but are you not talking about two separate grounds of review there? Isn't gross irregularity one of the grounds of review under Section 145 of the LRA?
No, that is precisely it. If I've misunderstood the Sudumo judgment, it was to establish what gross irregularity was, because I understood the reasoning to be that in the performance of a commissioner's duties, the commissioner is required to conduct him or herself in a certain manner. In so doing, that commissioner needs to have consideration to the evidence before him or her, to consider, to afford parties a fair opportunity to present their evidence, to have identified the actual issue. By having conducted a fair hearing, it then gives rise to a result. The question of reasonableness, as I understand it, is read within the gross irregularity, because in the event that a commissioner commits one of those types of errors, wrong word, commits that type of conduct by not having conceived the nature of the inquiry, by not having conceived the evidence, etc., that in itself constitutes a gross irregularity. So it's not a new ground of review, as I understand it. It is just to simply understand the extent to which a gross irregularity may be found present within an arbitration award, thereby leading to an unreasonable result.
Yes, you might wish just to later on go and have a look properly what Sudumo said. Part of what you're saying, yes, but I think you may be mixing it up with other things. But tell me, what are the requirements for an interim, for the granting of an interim interdict?
An interim interdict will be granted in circumstances where the applicant seeking the interim interdict has established a prima facie right, although possibly open to some doubt, will potentially suffer irreparable harm if the interim interdict is not granted. The balance of convenience is in favor of granting it, and there is no alternative remedy available to the applicant.
What are the requirements for a final interdict?
All the same, no, they're not all the same, similar. No need for balance of convenience, a clear right, no alternative remedy, and irreparable harm.
And what's the difference between a secondary strike and a sympathy strike?
I'm not 100% that I'm going to be able to answer. Secondary strike, as I understand, is one that is in concert with a main strike in the same industry in which the secondary strikers participate in the main strike for the purposes of obtaining or achieving the demand, whereas a sympathy strike might be taken up by individuals who are not necessarily within the industry. I am subject to correction on that.
Yes. And you are going to be, if you are appointed, conducting trials in the labor court. When can you draw an inference? What are the requirements for the drawing of an inference in civil matters? Are you familiar with that?
No, I'm afraid I don't know what the test is there.
You don't know what it is? Okay. I'm going to give the opportunity to the Judge President of the Labor Court to put questions to you.
Thank you.
Judge President.
Thank you, Chief Justice. Good afternoon.
Good afternoon, Judge.
Is it correct that you are seeking an appointment in Durban, seat of the Labor Court? Is that correct?
That is correct, Judge President.
I see you've really provided us with lots of paper. Why was the need to give us all your judgments, Renia?
I do apologize. I see that the Law Society took a little bit issue with my wasting the trees. The reason for that was this, is that the work of the Labour Court covers a multitude of different aspects. To select only one or two different things that may conceivably be perceived to have been important wouldn't necessarily give the fullest indication of my understanding of the area of law. And to be fair, I did provide an index which described each of the cases, so I was hoping that rather than forcing everybody to read all of them, that they would simply choose the ones they wish to. So I do apologize if I'd done that.
I see that the person who nominated you, in fact, said that the experience is exclusively for employees. But then as I kept on reading your CV, I saw that you had worked for ENS. I
think
thought
he
that you
meant to
worked for employees when you worked there.
No, I would imagine that was, sorry, I didn't actually see that, but I would imagine that he intended that in my capacity as an advocate.
Now, you know, the last few years been very fashionable for employers to raise the issue of derivative misconduct. Can you tell us about that?
Sorry, I didn't catch the first part of the question.
Derivative misconduct.
Yes.
If you can explain what it means and is it still applies?
Oh, I see. It was a principle which was established or which was applied for some time, in terms of which where the misconduct of employees in the perpetuation of a potentially violent strike would be attributed to others by virtue of a derived complicity. So in circumstances where they were deemed to have, effectively deemed to have participated, even if they'd been in the absence of any evidence that they had in fact done so. The notion of that such a concept of derivative misconduct could exist was came to an end with the decision, and I think it's Dunlop mixing, I think is the case, where the Constitutional Court said no, that is not an appropriate principle.
Okay.
So where one wants to establish proof of misconduct in the course of the strike, you need to be able to identify who did what when.
Do you belong to AFT?
I actually don't know.
No. Because I see you one of the only candidates that I know of who has been supported by the AFT for the position.
Yeah, it's not that it's simply it's not for any active or inactive choices on my part. I mean, the principles are what they are and what I believe in, but it's just simply a question of allocating precious time and resources to what one can and cannot do. So whatever I have done for the bar, I've done for everybody, not necessarily under any particular banner.
That helped me then. They say in paragraph 27, Advocate Alan Yaman actively contributes to transformation at the KZN bar, particularly skills transfers. Help me with that. What do they? Yeah.
Well, no, it's AFT and the GCB and the bar in Natal don't run sort of separate programs or separate anything from one another. So what I did was in the course of last year, I commenced preparing and then did at the beginning of the year, was presented a course for juniors at the bar, because it has always been my view that the practice of labour and the study of labour, particularly at the profession of advocates, is underrated and underappreciated. So anybody who has done pupillage or has done those exams will know that there are no examinations at the end of the pupillage year on labour. And with that in mind, I was aware of the fact that there are very many juniors who come to the bar who are completely unfamiliar with any labour or have had no labour practice or are unfamiliar with the principles. So what I did was, in my own mind, identified what I thought might be the things or the briefs that those juniors might receive in their first few years of practice, and with that in mind, what principles of labor law might be different or unique to labor that they would be unaware of. So I did a 3-day course where I presented the junior advocates, with material which would, I felt, provide them with a solid basis on day one on disciplinary inquiries, how to run them, what to expect, what to deal with, and then potentially dismissals, what they might find at the CCMA or bargaining council, what the onuses are, all the intricacies of dealing with that. The second day I dealt with just general labor court practice, where there are different and unique applications. And then the third day I dealt with reviews. And it was a full 3-day course which was run in January. And then in July, it was I represented that for any juniors who hadn't been able to attend in January. And we were in fact fortunate enough, Judge Witcher from Durban, in fact, she accepted my invitation to come and speak to them on evidence, which she did. And one of my colleagues at the bar, Mr. Paul Schumann, who's also very familiar with labor, he came and spoke to them regarding strikes. So by the end of all of that, the juniors of the bar have a little, I hope, better understanding of where to start. And so that, I believe, is where the comment comes from.
Finally, I keep a record of all outstanding judgments and so on. When I looked at your application, I saw a number of outstanding judgments, but as far as I know, you don't owe any judgments for over 2 months, do you?
No, not now. Judge President, the ones that were listed there had all arisen in the course of the second term. As you would be aware, the Durban court is served by 2 judges. It serves the province with the second highest GDP in South Africa. It is not busy. The 2 judges in that court are required to alternate between trial court and motion court. Motion court starts at 10 in the morning and sometimes doesn't finish at 4. You can roll matters over to the next day. At the end of the day, during the course of term, there is very little time to write judgments unless one's trial collapses and one doesn't then go and help one's colleague with her motion court role. So all I can say is that, yes, at this point in time, I have no judgments which are outstanding for longer than 3 months. Those ones that were listed there at the time were not longer. There is one on the list, though, the very first one, and it's the one that the GCB mentioned from April, which was of concern. I must just draw that to your attention. Pursuant to having reserved the judgment, the applicant party took a further step in the matter by, they took a further step. That necessitated that I issue a directive to the parties as to whether they wish to argue, because the step was taken affected the argument. They both then delivered further submissions. So once that was done, it was it's been re-enrolled. I believe Mr. Vilakazi will enroll us next term. I asked him to do that. So there's the reason why one is not handed down is in fact because it needs to be argued again on the new merits. Judge President, at the end of the day, I have acted for 48 weeks, over a period of 80 weeks. I have handed down 72 judgments in that time. The volume of paper that you have before you indicates that these are not 1 or 2 pages. These are reviews. These are substantive applications. So on average, 1 a week. If there have been times where they have been delayed beyond 3 months, it's certainly not because of any...
But there haven't been, there have been 1 or 2.
There might have been 1 or 2, but certainly not because of any indifference on my part to the requirement that labour be dealt with expeditiously.
Thank you. Nothing more, Chief Justice.
Thank you, Judge President.
Thank you, JP. Minister, you are covered. Commissioner Marumohai.
Thank you very much, CJ. Good afternoon, Judge.
Good afternoon.
Yes. I read your judgment, Hatting and others versus Design Group. I'm not sure if you remember it.
I think it was one of the very first ones. It was in the
Yes.
COVID time, wasn't it?
No, in fairness to you, I'm not going to take you through
I
it.
see.
There is just a
Okay.
question that came out of it that I want you to address, just a general substantive question. We all know that employers take sometimes they just change unilaterally the terms and conditions of employment at times. I just want to understand, what is the common law position with respect to unilateral change of terms and conditions of employment? And do employees under those circumstances have any remedy? If yes, what would then be the remedy for employees under those circumstances? Thank you.
Specifically the common law.
Well, there will be a position under common law that we all know, and perhaps maybe that position may have been changed by some of the statutes that came through, but I'm not debating that. I just want to know what is the original common law position, because it's still applicable. And if employers go ahead and they just unilaterally change terms and conditions, is there any remedy for employees? You deal with that in your judgment, so I just wanted to be fair to you.
I think it was ancillary in the judgment because the arguments of those employees had been that there'd been a change in terms and conditions of their employment, but I found, if I recall correctly, I found they hadn't, because they'd always been required to travel and would have always inherently been required to comply with whatever vaccine requirements other countries had required. Be that as it may, my understanding is that as a matter of common law, once one enters into a contract, one is bound by that contract, and there is no scope for any unilateral change to terms and conditions of employment. The situation that prevails insofar as unilateral changes to terms and conditions of employment are implemented in a broader, insofar as more than one employee is concerned, the employees as a collective can then use the remedies in the LRA to interdict for at least 30 days the implementation of the change and thereafter strike. Individual employees cannot strike and would have to use some type of civil remedy for specific performance.
Thank you very much, Judge. Thank you very much, TJ.
Thank you very much. Commissioner Poswal-Toli.
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon, I think.
Yes.
Not judge yet. Everybody's calling me judge. You've had a long week with many judges.
Well, we've had many judges.
I know.
I guess it's because we've had many judges throughout. Good afternoon, Advocate.
Good afternoon.
Yes, you know, Section 198 of the Labor Relations Act is designed to protect vulnerable employees from labor brokers and those on fixed-term contracts. In your experience, do you think it's working practically? In your experience, looking in particular at sections 198B and D, is it working? Is it effective?
Commissioner, I'm not able presently to tell you which one is A, B, C, or D. I can tell you which are working and which aren't.
Yes.
The automatic permanency of repeated fixed-term contracts of employment is working. There is no doubt that the effect of, or what the historical employee unskilled, usually workers, for extended periods over repeated 1 month fixed term contract seems to be a thing of the past. I think that if people are trying doing that, the employees know the remedy and are able to get that fixed. Insofar as the actual notion of labor broking is concerned, the difficulties inherent with labor broking will remain with employees for so long as it is permitted, but it has not yet reached a point where I think it can be done away with, because there is always going to be a need for labor broking. And on a case-by-case basis, I mean, it's very difficult in abstract to say whether one scenario is fair. you know, whether it is whether it's operating fairly or otherwise, because each case will be dealt with on the basis of the employer's specific needs at the time, whether they are using labor brokers to avoid consequences of permanent employment, or whether they are doing it for a genuine operational need, has to be determined on each basis. I don't know if that answers your question sufficiently, Commissioner.
Yes, to a certain extent. May I just follow that up?
Sure.
But really what I need to know is that in your experience, when the issues come before you, are you applying those provisions to adequately protect the employees?
To be honest, in none of the judgments that I have dealt with so far have I had to deal with any of those particular provisions. None of them have come up in any matter before me as of yet. I have had discussions with my colleagues concerning those matters. There are difficulties with the interplay, as I understand it, in those particular provisions, particularly in light, I think there's a judgment which has indicated, but I think it's gone to the LAC, and I'm not sure whether there's been a decision, as to whether or not the termination of an employee's employment, post fact whatever the event, so in other words, if an employee has acquired permanency of employment and has claimed a right under that but not yet enforced it, whether that can now be negated by virtue of the termination subsequently of the employment. I think there ought to be an LAC decision. Has it been handed down yet? Judge President saying it's not yet handed down. But I was involved in a debate on that, and there are certainly, the way any new provision gets dealt with in the LRA is that it needs to be tested. And until those ones I don't think have been sufficiently fully tested, and hopefully when the LAC hands down its decision, there will be some clarity there. But with all of these, there is always an attempt to find a way around things. But it's a step in the right direction, I would say, at least. And I'm sure that from what I've understood of it, it certainly does provide at least a better remedy than none.
Thank you, Chief Justice. Yes, indeed. Really, the manner in which employers seek to circumvent that provision is by just terminating the employment, and then you cannot invoke Section 98.
I disagree that it can't be done.
Thank you very much.
Thank you, Chief Justice.
Thank you, Commissioner.
Commissioner Totovu.
Thank you, CJ. Good afternoon.
Good afternoon.
Advocate. My question is only one, and it's premised on your judgments around unfair dismissals. As you are aware, dismissals can generally be effected on 3 grounds. That is because of misconduct, operational requirements, and incapacity performance. Now my question is, can an employer dismiss an employee based on these grounds simultaneously? Is it possible?
Depend on what was happening in the business at any one time, I would imagine. I mean, notionally, there would be an employee that misconducted himself in the course of an operational requirements consultation process, which was imminently to lead to the termination of his or her employment on a specific date, and at the same time found himself at the end of a poor performance management inquiry, thereby rendering his dismissal, saying his or her dismissal on a specific date, to have been for any one of those 3 things in the alternative. But I've never seen an employer choose to do it on all 3 bases. They usually pick only one.
I'm asking this because each case has got its own processes prescribed by the LRA. And I remember as a sub-steward, I argued that you can't do it in 3 instances at the same time, and I was successful. Now I wanted to test you because if you
I'd
are
have to
appointed, you'll be a
understand- I mean-
judge, and you'll be confronted by such a situation where an employee is dismissed both on retrenchment, non-performance, and misconduct at the same time.
As my answer indicated, that the probabilities of those three events happening so as to meet, like the Titanic and the iceberg, on one day, with all three, it seems highly improbable. Not saying it's impossible, but just the chances of that are fairly remote, it would seem to me. And I mean, you only need to fairly dismiss somebody for one fair reason. You don't need to have three.
Thank you very much, CJ.
Thank you.
Thank you, Commissioner Singh. And on my list, subject to the commissioners on the virtual platform, you would be the last one.
No, thank you very much, Chief Justice, and good afternoon, Advocate. I'm
Oh,
here.
there you are. Thank you.
Advocate, I note that you've presided over the Nando-Scottville versus CCMA, and this was a very interesting case that highlighted that despite our stringent labor legislation in the country, you find that employers often with deep pockets and a string of lawyers, often take advantage of the employees, particularly after a judgment has been given. Now, what do you think both employers and employees can do post a judgment like the one that was given in this case?
But that one was a little bit different because that one, in fact, had a happy ending. It didn't have the scenario of, oh, well, we've lost, so now we're going to drag this employee all the way to the Constitutional Court on principle. They published, an article was published whereby they said that they accepted the judgment and were welcoming him back to his job and were making the necessary arrangements.
Yeah,
So that particular one didn't have the evildoer employer with deep pockets, I'm afraid.
Yeah, could that not have been an exception rather than the general rule? And what would you suggest needs to happen post the judgment?
Well, every litigant has a right to the fullest processes of the law, and as things currently stand, that includes the right to at least apply for leave to appeal. What could be done to stop that? Potentially cost orders against people, but that can only be done where one is in the labor court very certain that they are acting frivolously or vexatiously. So,
yeah, I also note that you were admitted as a solicitor in England and Wales.
it was purely academic.
Academic. You didn't practice there at all.
I tried. Nobody wanted to give me a job.
Thank you. Thank you, Chief Justice.
Thank you, Commissioner Singh. Commissioners on the virtual platform, I didn't see any indication. I take it there are no questions from that side. Yes, there are
no questions, CJ.
Thank you.
Where am I?
We've come to the end of this interview. Thank you very much. You are now excused.
Thank you very much, Chief Justice. Thank you very much, Commissioners. So before may I just hand something to Judge President Wagley? I know I've given you a lot of paper. Of all the cases that I presented, they were all applications. Fortuitously, between the time of the application and now, I did have an opportunity to write a judgment in a trial matter, which I know is assessed differently, as Lordship asked. And this is in relation to an automatically unfair
I don't
non-appointment.
think you should add to what you have
Is
already
it not?
given
I
us,
just
yeah.
thought I would bring it just in case. All right. Thank you very much.
Please bring in the next candidate. Good afternoon, Mr. Daniels. Please switch on your mic. I just want you to get settled. Are you settled?
I'm settled, Chief Justice.
Okay, all right. Let me welcome you to this interview. Thank you very much for availing yourself for the interview so that you can be considered for appointment as a judge of the labor court. I will ask you some questions, and some of the commissioners will put questions to you as well, and we'll do so in order to see how you satisfy the selection criteria that we have adopted for the selection of judges. Now, I know you from many years ago.
Indeed, Chief Justice.
Were you at Chettle Thompson, or were you with trade unions many years ago when I met you?
Chief Justice, I appeared before you in 1998.
That was a long time ago.
The NUMSA and Transportation Motor Spares matter.
Oh, yes, you were with NUMSA at the time.
Correct, Chief Justice. Until the year 2000.
Yeah, that's quite a long time ago.
It is, Chief Justice.
Yes. But had you already done law at that time, but serving in unions, or you did law afterwards?
Chief Justice, I was a qualified attorney in 1997.
Yes.
And I'd completed my articles by March 1997.
Yes, okay.
So I was a qualified attorney at the time.
Oh, already?
Yeah.
Okay. But you did leave unions at some stage?
I did, Chief Justice. After 3 years, I joined Chettle Thompson in early March 2000.
Oh, okay. And you practiced with them for how long, or are you still there?
I'm still there, Chief Justice.
So
It's
you have
23
been there
years.
for over 20 years?
Yeah, over 23 years, Chief Justice.
Yes, that's quite a long time.
It is, it's a while.
Yes. Yeah, I see that in terms of academic qualifications, you hold a BA degree, an LLB, and an LLM, is that right?
That's correct, Chief Justice.
And your LLM is in international human rights.
That's very correct, yes.
And you got your BA at UCT.
Correct, Chief Justice.
And your LLB at the University of the Western Cape.
Correct, Chief Justice.
And your LLM at the University of Northwestern University, Chicago.
That's correct, Chief Justice.
Yes. And of course, being involved at Chettle Thompson, you would have been exposed to a lot of labor law work.
Chief Justice, I was exposed to almost exclusively labor law work.
Yes.
I did dabble in defamation matters as well.
Yeah.
The odd delictual claim, etc. But
Yeah.
for the most part, it was labor work.
Yes.
But it related both to representation of the unions, but from time to time also dealing with employers.
Yeah.
And of course dealing with the unions as employers.
Yes. Okay. And did you appear and argue cases yourself at the labor court?
Indeed, Chief Justice. From the time I joined NUMSA, I was in and out of court on a regular basis.
Yes.
When I joined Chettle Thompson, I realized at that point that I was in need of some training.
Yeah.
So for the initial 1 or 2 years, I was simply using counsel and learning as much as I could.
Yes.
And thereafter, I began appearing on a regular basis.
So for many of the years that you have been at Chettle Thompson, you have appearing in the labor court, arguing the cases yourself, conducting trials, is that correct?
That's correct, Chief Justice.
And dealing with motion matters as an attorney?
Indeed, opposed matters, trials, etc. Yes. quite a few.
Yes. Have you also appeared in the Labour Appeal Court by any chance?
I did, Chief Justice, on 2 occasions.
Yes.
The first judgment was handed down, and the other one was settled following arguments between the parties.
Yeah. Okay. So, and have you had an opportunity to act in the Labour Court?
Chief Justice, I've acted on 2 occasions for very short periods. So that was in June and December 2012.
Yes. How did you find acting as a judge?
Of course, it's very different in some ways, and in other ways, it's very similar.
Yes.
You know, obviously, as an attorney, you advocate for your client's case, but in presenting legal opinions, etc., it's very akin to drafting of a judgment.
Yes.
Because you would balance the evidence, apply the law to the evidence, and arrive at an objectively, hopefully correct outcome.
Yes. Yes.
But yes, it was. And on my very first matter at the Labour Court, I had a gentleman appear before me who, in most of the time that I've been at Cheadle's, he was on the other side, and I would say is known to be a fairly robust employer representative, and I had to rule in his favor because the facts suggested that he was correct. So yes, it was very interesting, in some ways challenging, but I enjoyed it.
Yes. And I see at paginated page 25, you have listed a number of cases which are reported in the Industrial Law Journal in which you appeared. Is that correct?
That's correct, Chief Justice.
Is that about 12 cases?
Sorry, Chief Justice, I'm just...
paginated page 25.
Okay. Beg your pardon, Chief Justice. Just trying to make my way through the bundles. But I know that I did list attached to my CV.
Yeah.
All the cases.
Does
yes.
12 sound more or less right?
Yes, Chief
12,
Justice.
15 or thereabout?
Chief Justice, we were asked, I think, to make a selection of the matters.
Yeah.
And that's what I did. By no means is that a complete list.
Yes.
Of the judgments.
Yes. Okay. And how did you find dealing with motion court matters as an acting judge?
Chief Justice, I found them, it was fairly straightforward. I don't think there was any difficulty at all.
Yes.
I mean, the one matter in which I did reserve judgment was worthy of further deliberation, and that was over the festive period. Otherwise, it would have been a little bit sooner.
Yes.
But yes, I think for the most part there wasn't any difficulties at all.
Yes. What can you share with this body on challenges that come with Section 157 of the Labor Relations Act in terms of concurrent jurisdiction between the Labor Court and the High Court and exclusive jurisdiction in regard to certain matters on the part of the Labor Court?
Chief Justice, I've heard what has been said in relation to the original intention of the drafters, but of course the Constitution requires certain things, and the LRA has to be interpreted in accordance with the Constitution. I think that at the end of the day, there really wasn't much to debate. as Justice Nugent pointed out ultimately in the Makanya decision. I mean, at the end of the day, it's clear what the Labour Court had jurisdiction in relation to. That's 157.1, and it's clear where the concurrent jurisdiction lies as well. So it was a bit confusing, and as Justice Nugent pointed out, I think what our courts have tended to do is to confuse jurisdiction with the merits of the dispute. But I've always thought 157 was very clear.
So you don't understand why there have been so many conflicting judgments over the years?
Chief Justice, I think that unfortunately clients and lawyers tend to they look for anything to create confusion. And it's one of the reasons that lawyers are not allowed at the CCMA. And they believe they're serving their clients' interests by...
Just tell me some of the cases over which there have been debates whether the High Court does have or doesn't have jurisdiction, or the Labour Court has jurisdiction.
Well, I think, am I permitted to refer to one of my own matters?
If it's a reported judgment or it's a judgment you have done, it's fine.
Okay.
But we would like it more if you tell us about those that we can find in the law reports.
Okay, the judgment, I mean the Makanya judgment, for example, that was a judgment that went as far as the SCA, and Justice Nugent delivered the judgment. And in that matter, if I recall correctly, I may be confusing it. In fact, let me address you on the Samsa and Mackenzie matter. In that matter,
what matter is it called?
It's the South African Maritime and Safety Association.
Is that your matter?
Oh, no. My matter is not reported, but we are planning to appeal.
Oh.
So it will be reported at some point. So in the Mackenzie matter, the individual had been dismissed. He'd referred his unfair dismissal case to the CCMA, and the parties had reached a settlement there. And subsequent to that, he then brought his case in the High Court. And in the High Court, he alleged that there was an implied, alternatively express, further alternatively tacit. I've always understood express and tacit to be the same thing, but I mean implied and tacit to be similar, but he pleaded it in that manner. And he said, well, there's
I'm sorry, he says there was an implied or tacit term.
He said there was an implied, alternatively express, alternatively tacit.
Term that says what?
That says that there can be no dismissal without just cause.
Without just cause.
Exactly.
Oh, okay.
And he then brought that claim in the High Court. And the court found that it retained jurisdiction in the matter. And the court was at a loss to understand why the respondent, I believe, had taken a jurisdictional point to begin with. Because it was pleaded as a contractual matter, and the Constitutional Court, I believe in the Aba decision, says very clearly that you assess jurisdiction based on the pleaded case. And what he had pleaded in the High Court was a contractual case. And obviously the High Court has jurisdiction in relation to breaches of contract in terms of our common law, and therefore there should have been no debate at all about jurisdiction. But what Justice Nugent does do is he points out the pitfalls of where parties have gone wrong previously and so forth. Ultimately, I think the case was dismissed on the basis of there being no merit to the case. I mean, there was one further aspect which Justice Nugent did deal with, which is quite important. And he said that where you have a statutory right and your statutory remedy, and you seek to vindicate that right, and you seek that remedy, then you must, of course, follow the statute and follow the path that the statute has laid out for you. In this case, we're talking about the LRA. And where you're not dealing with that dispute, then you are free to follow, to vindicate your rights in the High Court, for instance. And so the court dealt with it in that way, and I think very clearly resolved the dispute as to, or resolved the debate, I should say, as to jurisdiction.
Yes, so that's one type of cases that you have told me. Is there another type of case that, in respect of which the High Court and the Labour Court would have concurrent jurisdiction?
That would be in relation to constitutional rights, and in relation to employment rights, in relation to an employment dispute, where the applicant essentially is alleging a breach of their constitutional rights.
Mm-hmm.
So there's concurrent jurisdiction as well. So, Chief Justice,
can you share with the Commission what the requirements are for a temporary interdict?
Indeed, Chief Justice. And perhaps before I can do that, I'm just missing Book 2. I've got 1 and 3 of 3, but not Book 2. So the requirements for an interim interdict would be either a prima facie or a final right. And okay.
Okay, just attend to what you need to attend to.
Sorry, Chief Justice. So the second requirement would be a reasonable apprehension of breach of that right or a breach of that right. That would be an ongoing breach of the right, because you can't seek an interdict in relation to a past event.
Mm-hmm.
Then there would be balance of convenience, where the court would have to weigh the prejudice to the parties, the prejudice to the applicant if the interdict is not granted,
mm-hmm.
and the prejudice to the respondent in the event that it is granted at that point in time.
Mm-hmm.
And then the court would assess that. And then, of course, the final requirement is the absence of a satisfactory alternative remedy.
Mm-hmm. Well, I'm not sure whether, when you say final, you are now talking about the requirements for a final interdict, which is what I was still going to ask you about. What are the requirements for a final?
So in the final interdict, you would of course, you'd have to demonstrate your right. You'd have your clear right, and that must be demonstrated on a balance of probabilities. The absence of an alternative remedy, and a breach of that right, a breach of your clear right. So those would be the three requirements. Balance of convenience would be absent.
Now, if you deal with trials in the labor court, you may find a case where you must draw an inference. Are you familiar with the requirements for drawing an inference in civil matters?
I am, Chief Justice.
Yes.
So in the first place, to draw the inference, it would not only have to be a reasonable inference,
mm-hmm.
but it would have to be the most plausible inference.
Mm-hmm.
And the inference would then have to also be consistent with all the evidence that's been presented before that. Obviously, the accepted evidence, not the...
With all the established facts.
Yes, correct.
Yes. I'm going to now give the opportunity to the Judge President of the Labour Appeal Court and Labour Court to put questions to you.
Thank you, Chief Justice.
Thank you, Chief Justice. Good afternoon, Mr. Daniels.
Good afternoon. Good afternoon, Judge President.
Mr. Daniels, I think there's some confusion when the Chief Justice asked you if you had motion court matters. You served for 2 weeks, 2 separate weeks, and that was on a
Correct.
pro bono basis, isn't it?
Correct.
So you just got
Correct.
matters. You didn't sit in motion court and trial court. You were just given a certain number of files.
Correct, Chief
which you
Justice.
dealt with.
Correct, Judge President.
Yeah, and you've also said that you appear regularly now. You know, I have this terrible habit of sitting in most of my LSC matters, but you've never ever appeared in front of me, have you?
I haven't appeared before you.
Have you appeared before?
No, no, I haven't, sorry.
You have, yeah. That's why I wondered. But you said you've only appeared in 2 matters, and there
Correct.
was clearly not one where I was sitting in.
No.
And then you've also indicated that you've sat in trial courts, motion courts, and I spoke to the judges in the labor court. They say that you do appear on urgent matters, but never in trials, never in motion court. Have they got it wrong? I don't know. Look, there's so many people appear before them. They could have got it wrong, but I have difficulty that all of them say that you haven't appeared in front of them, other than in urgent matters.
The vast majority are urgent matters, but I have, and I do appear regularly in relation to reviews and trials as well. In
Okay.
fact, the former candidate was here. I've appeared before her as well.
Okay. I look at, you are seeking appointment in Johannesburg, am I right?
Correct, correct, Judge President.
Tell me, I mean, you shouldn't have difficulty with that, but you know the Steenkamp and Edcon matter. You know the matter.
I do.
Have regard to that matter, but let me give you a set of facts. John,
Please speak up, JP, so we can hear your questions to him.
sorry, thank you,
Yeah.
thank you. Let me give you this scenario. John has just been dismissed. He goes to his attorney, and attorney decides to bring an urgent application to the labor court. And he argues that the dismissal was unlawful because the company did not follow the proper process. And what he seeks is compensation in terms of 194. This is an urgent application brought to the labor court. You are the judge. Tell me what you're going to do.
Well, Judge President, I think in the first instance, the labor court has jurisdiction over unfair dismissals as opposed to unlawful dismissals. And then, of course, if he is challenging procedure, that would have to be processed in the ordinary course. It would have to be referred.
Now, I told you what he's done. He's come to court on an urgent basis.
Yes.
The relief he seeks is compensation in terms of 194. And the grounds, causa is the breach of contract, unlawful termination of his employment. You are, now.
Okay.
What do you do? Yeah.
Okay. Well,
I've given you a background. I told you think about Steenkamp and Edcon.
Well, Steenkamp and Edcon was very clear that in relation to a mass dismissal, you would have to follow Section 189, capital A 13. This is an individual dismissal. And he's challenging the lawfulness of the dismissal based on the breach of contract, which he's entitled to do in terms of the BCA. So, I mean, but obviously on a breach of contract, you wouldn't be looking at a statutory remedy. You'd be looking for damages which have to be proven in the court. So,
now, you know, the principle in that matter, in that case, was that if you bring a contractual claim, you cannot claim in terms of relief in terms of the Labor Relations Act. Court will not entertain it.
That's
that,
my understanding. I agree with
that's not what you said. You said that's why I especially told you seeking compensation in terms of 194, which is LRA. But okay, as long as we understand each other. let's move further. Let's move forward. Derivative misconduct. That's a very fashionable thing nowadays. And Constitutional Court had a thing to say about that. Can you tell us what it was?
Well, derivative misconduct is based on an implied duty of trust and confidence, which in the Dunlop matter was argued on the basis that there's an implied duty that an employee has to have. There's a relationship of trust between the employer and the employee. And if the employee does not share information with the employer as to misconduct which has occurred in the workplace, then the implication is that they have breached that duty. And that's known as derivative misconduct. I think the very first case where that was mentioned was probably the RSA geological matter and NUM. And what was said in the Dunlop matter, NUMSA and Dunlop, was that there can be no derivative misconduct in the sense that it had been applied previously, because there's no such duty in the absence of a reciprocal duty from the employer. Because, of course, if an employee goes to the employer and says, I can tell you who's committing the misconduct, their safety is at risk. And I think it's Justice Froneman who said, there's no such duty in the abstract. That duty must, at the very least, be a reciprocal duty between the employer and the employee. And if the employer is not offering anything, for example, a guarantee of safety, then the employer cannot just say, well, there's a reciprocal duty and you have failed.
Thank you. And the last thing I want to say is I've looked at the comments received from all the professional bodies. And I think all of them are of the view that you are not ready yet to be appointed. Any comment on that?
I believe
they believe that you should be called to come and act, because you acted for 2 weeks, I think it was in 2012, and you should get more experience acting. What is your comment on that?
Judge President, subject to your correction, I believe it was only the Law Society that said that.
It was the Law Society, it was the Bar Council, and I think it was the BLA as well. Yeah. There's only 3 of them who commented, and that's what they have to say.
I thought that the BLA said they leave it in the hands of the JSC.
Let's look there. Daniels. Maybe I'm wrong. BLA said Mr. Daniels has not received enough exposure as a judicial officer. He will benefit from the more exposure in acting positions in the judicial system. That's what it says. Any comment on these comments from these 3 professional bodies?
Judge President, I think in the first instance, I was approached twice to act. I accepted on both occasions. I wasn't approached on any other occasion. And had I been approached, I would have accepted that. But I believe that, as I've mentioned previously, the guarantee of independence and impartiality, as was said in the South African rugby case, the Safu matter. In that case, the Constitutional Court indicated that the best guarantee of independence is legal experience. I do have that legal experience. I have 23 years of it, 25 years if you include the articles, 28 years if you include the time at NUMSA, a lot of time of which was involved in litigation. And I do have that experience, and that experience and knowledge has equipped me to be impartial, so there's no question about that. Furthermore, I'm not a paper pusher. I appear in courts on a regular basis. And that experience of appearing in court, I've seen many, many judges, how they manage the court process, the court procedure, the decorum, etc. I've seen that for 23 years. I've experienced that on 2 occasions. So I believe I'm capable of it. The other difficulty, of course, is that if you ask a senior attorney in any law firm, the head of the employment department, to dedicate a longer time to acting, it's very difficult because, of course, that individual would have to seek the consent of the other directors in the firm. And it creates a problem both for the clients for whom you're no longer there, the development of the firm, and the distribution of work within the department. So it's asking an attorney, I understand the need for it, but it's asking a senior attorney to ignore those obligations. And that's part of the problem. But like I say, I've only been asked twice. I accepted on both occasions.
Thank you.
Thank you.
Thank you, Chief Justice.
Thank you. Minister, you are covered. Thank you. I haven't seen indications. Commissioners on the...
Yes.
Let me go there because I've already called them. I'll come back to you, Commissioner Ngwaitobi. Commissioners on the virtual platform, I didn't see any indications.
Thank you, Chief Justice.
Thank you. Commissioner Ngwaitobi.
Mr. Daniels, I just want to, on this point about experience that has been debated with the Judge President, I've looked at your CV quite closely. I counted, I think, 7 letters of support, and then there were 2 that came last night, which came to 9. Now, what is unique about those letters of support, which I want to give you a chance to comment about, because you didn't say that in response to the JP, is that everyone is someone who has worked with you and is someone who actually knows your practice, who knows your abilities, from Advocate Chris Orr, Advocate Danny Berger, many, many attorneys. What they do is actually extraordinary testament to your talent, your skills, your experience as a labor practitioner. And all of them, without fail, the people who actually know you say you are absolutely suitable for the labor court. And they say that your lack of experience in acting is easily discounted by the practical experience that you have acquired over the years. So I want to give you a chance to balance that criticism. And when you look at what the GCB says, the Law Society and the BLA, what struck me with, because it's one-liners in all of them, is that actually none of them has any actual evidence of you as a practitioner. And they make those general comments. And if you compare that against the 9 that actually know you, everyone attests that you've got the experience, you've got the capabilities. Do you want to say anything about that?
I do. I do. Thank you, Commissioner. I think the point is that so the strongest criticism of me not acting comes through the Law Society, and they say for that reason they will not recommend me. In relation to the BLA, ultimately, in their ultimate conclusion, if I recall, they said they leave it in the hands of the GCB. I mean, in the hands of the JSC. And the GCB does not say they're not going to recommend me. What the Law Society says is they say that acting experience will allow me to demonstrate my legal prowess. I believe I've demonstrated my legal prowess over the years by appearing on a regular basis, a number of victories, very seminal cases, both at the Constitutional Court, at the SCA, in the Labour Appeal Court.
No, that's not you, just carry on.
Thank you. Yes, so I believe I have demonstrated that, and I don't think that the criticism of me is valid. But I think importantly, in relation to the letters, I've received a very strong endorsement from one of the very big commercial firms, and in fact, who I've come up against for the last 20 years. And they reference unflinching professionalism, integrity, competence, a deep understanding of employment law, an ability to apply this understanding, ability to guide the labor courts to a just and equitable outcome, unwavering collegiality, professional demeanor towards colleagues, including the head of the employment department, utmost respect and disciplined decorum in court. And I think, and I'm very proud that I got this letter, because that letter comes from, as I've said, not only the head of the employment law, the employment department of one of the biggest, if not the biggest, corporate law firm in the country, but my most regular opponent in court or in arbitrations, including the Essential Services Committee, various bargaining council disputes, etc. And I believe that if your opponents can say to you, well, we support you, then surely that must be a very strong indicator that they have confidence in your ability, they have confidence in your impartiality and independence, and they have confidence that you will be fair.
Yes, I think just speaking for myself, I actually know very few attorneys of your academic ability, your practical experience, and your moral strength who still do work for trade unions in the day and age in which there is an onslaught against trade unions. I thought I should say that.
Thank you, Commissioner.
Want to respond, you may, but you don't have to.
No,
Thank
no,
you, Chief Justice.
I accept. Thank you, Commissioner.
Thank you. We have come to the end of this interview, Mr. Daniels. Thank you once again for availing yourself. We appreciate your availing yourself. You are now excused.
Thank you very much.
Thank you. Next candidate, please. Good afternoon, Mr. Makura.
Good afternoon, Chief Justice.
How are you this afternoon?
I am doing fine. And how are you, Chief Justice?
No, I'm all right, thank you. all the commissioners are all right too.
Thank you. I was not trying to be discriminatory.
Welcome. I welcome you on behalf of all the commissioners to this interview. Thank you for availing yourself for consideration for appointment to one of the positions in the Labor Court as a judge of the Labor Court. I'm going to ask you some questions. Other commissioners will also ask you questions. We will be asking you questions to satisfy ourselves as to how you satisfy the selection criteria that we have adopted as the commission for the selection of judges.
Thank you, Chief Justice.
In the course of our questioning you, we may be robust, but we will not in any way be intending to humiliate you or demean you in any way. You understand?
I do, and thank you very much, Chief Justice.
All we will be trying to do is just satisfy ourselves
Indeed.
whether you meet the requirements and meet the criteria.
Thank you very much.
Okay. Now, you hold an LLB degree, is that right?
Correct.
That is the 4-year LLB degree.
Indeed.
Okay. You also have an advanced administrative law certificate.
Correct, Chief Justice.
But next to it, you wrote electrical engineering, or is that another one? Another certificate?
It's another certificate that I did just after my matric, Chief Justice.
Oh, okay. And you got your LLB from VETS?
Correct, Chief Justice.
In 2005?
Correct.
Okay. And did you then do articles at Chettle Thompson and Haysom?
Correct, Chief Justice, from 2006.
From 2006?
Correct.
And so you know the previous candidate quite well?
He is my colleague. We interact very often.
Or did you conspire to make yourselves available together?
Not at all, Chief Justice.
Okay, all right.
The city age capture.
Your city age cadres?
We are, as we are commonly known to represent trade unions and employees.
Okay. And when were you admitted as an attorney? Was it in 2010?
2008, 19 May.
Or 2008?
Yes.
Okay. And you then practiced as an attorney, and you continue to practice as an attorney up to now?
Correct, Chief Justice.
Or you are still at CTH?
I am. I'm a very loyal...
So you all want to leave CTH at the same time?
Chief
you
Justice,
all want to leave CTH at the same time?
I will not comment on that. Thank you very much.
No, but you have said you are very loyal, so I take that you. That's what I will stick to. Now, how many years, therefore, have you been in practice as an attorney? Is it about 15?
It's over 15 years now, Chief Justice.
Over 15 years.
Yes.
CTH is well known for labor law work, and I think maybe some constitutional law work, but I think, to my knowledge, the constitutional law work was limited. Most of the practice was about labor law. Is that correct?
We have really diversified our practice over the time, so we do have administrative public procurement matters that we are doing.
Yes.
Yes.
So your own practice, what kind of, how diversified is it?
My own
what kind of branches of law do you get involved in your practice?
My own practice, Chief Justice, is predominantly labor law.
Yeah.
I do, however, advise clients on some contractual issues, service level agreements. I have limited matters currently in the one in the merge court. I think 2 in the merge court and one that I can think of in the High Court, dealing with contractual issues. Otherwise, throughout my career, I've done a number of other matters, like your defamation cases. Chief Justice will know, representing trade unions in the past years, there used to be those defamation cases between the employers against the trade union, or shop stewards, and all of that. So I have done a number of those matters during the time when I was an associate.
Yeah. So your exposure has been to labor law, some delictual matters.
Very
is that
limited.
right?
Very limited delictual.
Very limited.
Yes.
Yeah. So it's mainly, as you
Yes.
said, mainly labor law.
Yes, and I think I also do indicate limited criminal law practice.
Yes.
Doing bail applications for those trade union members who will be arrested or who were arrested
Yes.
previously, yes.
Okay, all right. Have you been doing appearances yourself in the labor court and arguing matters yourself and conducting trials yourself as opposed to briefing counsel?
Yes,
Or
Chief Justice. I have indicated also in my application that I do occasional appearance, and that's the word I chose because I don't think I appear more than 12 times, and I think it's debatable what is regular appearance.
Yes.
But I do appear most of the times. I do my trials. I've got a part-head trial now. I've got a trial coming up in October that I'm running. So I have appeared in motion proceedings.
Yes, but you talked about 12. Is it 12 matters in which you appeared without counsel?
Is that what I indicated, Chief Justice, in my application? If that is so, that will be the number of cases that I've found or that I could get, because I have started appearing way back when I was as an associate. I became an associate in May 2008. Some of the matters, of course, is just an order being issued, extempore judgments and all of that. But if I have mentioned 12 or less, those will be the judgments that I have appeared myself to argue the matter on behalf of clients.
How many acting stints have you had in the labor court?
I have, I always say it's 3, in fact.
And the duration?
The duration is 5 weeks in January, February 2022, and 1 week in June, July. So that's 6 weeks, and 5 weeks that I've done this year in April, May, and 3 additional days, which was a part-head matter that I insisted that it should be had during recess so that we get, we finalize the matter.
Yes. And have you done opposed motion court in the labor court without counsel?
I have, Chief Justice.
Yes.
Many of my matters, in fact, are opposed motion court proceedings.
Yes. Okay. What can you tell the Commission about challenges relating to concurrent jurisdiction between the labor court and the High Court and exclusive jurisdiction of the labor court?
In what context?
What challenge? Are there any challenges that are posed by the fact that the High Court and the Labor Court have concurrent jurisdiction in certain matters, or are there no challenges?
Chief Justice, I think we had those challenges previously. I think more and more as we deal with matters, as litigants come before courts, that issue seems to be, I think, getting resolved. Of course, we know from the from the Section 157 that the Labour Court has exclusive jurisdiction on employment matters. And there are, of course, I mean, the court has concurrent jurisdiction with the High Court on contractual disputes, on constitutional issues. So that I think over the past few years, I've not seen many of the challenges or coming before court, or the court having to pronounce on the jurisdiction of the Labour Court or the High Court.
Mm. Now, if you are appointed to the Labour Court, you will have to, among others, deal with applications for interim interdicts. Would you like to share the requirements for an interim interdict with the commissioners?
Indeed, Chief Justice, those requirements are for an interim interdict. You're looking at a prima facie right, irreparable harm, lack of alternative or satisfactory remedy, and balance of convenience.
And what are the requirements for final relief?
For final
interdict?
Yes, for final relief, litigants obviously, or the applicants have to prove the clear right. They have to prove, secondly, lack of satisfactory alternative remedy and irreparable harm.
Are you familiar with the circumstances under which you may, as a judge dealing with a trial, draw an inference in a civil matter, and what the requirements are?
Chief Justice, I think with regard to inferences, the court has to draw inferences from objectively proven facts. So you look at those facts that have been proven, and then you draw that inference and you reach a conclusion whether a certain, whether those factual objective facts looking objectively can lead to a particular decision.
So what are the requirements?
As the proven facts, that's what I have on top of my mind, Chief Justice.
The proven facts?
Yes.
Okay. I'm now going to allow the Judge President to put questions to you.
Thank you, Chief Justice. Good afternoon, Mr. Mkhoro. Good evening. You have, over the last 2 years, I think, acted 2 terms in the Labour Court. Is that correct?
Good afternoon, Judge President. That is correct.
Yeah. Now, while in the Labour Court, you've done trials?
Indeed.
Motion court matters?
Correct.
Urgent role?
Correct. I've done agent role twice.
I'm sorry?
I've done agent role twice.
Twice, okay.
Yes.
And it's quite a lot of work. And you had no difficulties? Did you have any difficulties?
I've not had difficulties. I mean, there was only a small challenge my first acting stint. If you look at my judgments, there's a judgment that relates to a restraint of trade agreement, which I think I've handed down like over about 6 weeks later, which I felt like, because I haven't really at the time practiced much or dealt much with issues of restraint, I felt like I took a little bit longer than I should have.
6 weeks. I have no problem with that time period. Okay. Thank you. And I note you're a qualified engineer, electrical engineer. Shouldn't you be dealing with load shedding rather than legal issues?
Judge President, I'm not a qualified engineer. I have studied electrical engineering, and it was mainly because I always wanted to go to school. If you look at my CV, there were a couple of breaks in between because of other challenges that made me like not to go to school. But whenever I had an opportunity, I'll go to school. So that's what I always wanted to do.
Okay. Now, we've heard you have been in practice for 15 years.
Correct.
Now, in this 15 years of practice, I know now your office is divided into different units, but have you ever acted for an employer in a labor issue, in a labor matter?
I have, Judge President, as I indicated earlier on, Cheryl Thompson and Hazen's practice has, over the past couple of years, really diversified, not only in terms of other areas of practice, but even on the labor matters that we deal with. I have represented employers, indeed, mainly public sector, employers, yes.
I don't know from how the professional bodies prepare their comment, but I assume they speak to their members, and that's how they come to the comments they make. And I noticed that the three professional bodies who have commented on all the applicants or candidates, in this case the BLA, the GCB, and LSSA, they all support your appointment.
I have seen that.
Which I find quite surprising. Anything you can comment on why, what is your involvement in these bodies? Are you involved, besides being a member of the LSSA?
Thank you, Judge President. I have no involvement in those bodies. I don't know how they go about doing the recommendations. So, but I believe that they have supported my candidature after, if we look at the GCB comments, after extensive research of my judgments, my personality probably, and many other issues, because I do believe that as a director also I have, over the past 15 years, I have carried myself with integrity, respect, and I have, my work I think speaks for itself, determination, efficiency. I've always endeavored to live by those values of respect.
Thank you. Tell me, now that you're in such divergent fields, you're even doing criminal work and so on, what can you tell me about derivative misconduct? Because, you know, that's the fashionable phrase nowadays. And it's such nice words, you know, it makes you look like an intellectual. So perhaps you can tell me what it means.
Thank you, Judge President. I mean, derivative misconduct is really about a situation where employees of a company might, or they know about certain misconduct that have been committed, and having known, they don't disclose that, and the employer, based on the difficulty in terms of, you know, trying to establish who committed the misconduct, decides to charge all the employees. We know from the Dunlop judgment of the Constitutional Court now that in essence, there's no duty to snitch.
I was going to come to that. Thank you. I have nothing further, Chief Justice. Thank you.
Thank you, Judge.
Thank you, Minister. You are covered. Commissioner Mugaitobi.
Good afternoon, Mr. Makura.
Good afternoon, Commissioner Mugaitobi.
Yes, no, thank you. I also know you just like I know your other colleague. And again, I also regard your skills and talents very highly. Can you just comment on an interesting judgment you gave in the Lutsolonyane matter, which was in the newspapers?
Commissioner Ngugaitobi, the last time I checked, there was an intention to appeal that judgment. I'm
But
not
just
sure
tell the
when-
commissioners what it's about. It's, some gentleman was fired because they got the minister stuck in a lift.
It was just the facts, if I'm allowed to. I'm not sure if I'm allowed to.
You can talk about the judgment you have given.
Thank you, Chief Justice. I mean, the facts briefly were about the specific employee who held a DDG position, which I have found that in terms of her contract, the SMS handbook applied to her. That was basically incorporated as part of her terms of contract. And in any event, it was clear from the SMS handbook as to who it applies to. So, and the SMS handbook sets out the process that should be followed when disciplining an employee or when there's an allegation of misconduct against an employee. So the employer in that case failed to comply with those provisions, the procedural provisions really. And what happened was that the employee approached the labor court. I mean, the employer terminated the employee without following that procedure, which is incorporated in the contract. So the employee approached the labor court on an urgent basis, seeking an order that there's been a breach of contract, that is the unlawfulness part of the case, and seeking specific performance as well. So I then found that she has, on a balance of probabilities, proved her case, having considered the requirements of the final interdict, which is what she sought before the court, and I found that the dismissal was unlawful. And I proceeded to consider whether specific performance was appropriate, which is the remedy she sought, and I also granted same.
Now, your application is Joburg, Port Elizabeth, Gqeberha.
Correct.
What's the situation there? Are there two vacancies, or do you have a preference?
Commissioner Ngugaitobi, I think the Office of the Chief Justice knows very well where my services will be best needed at the moment. I have showed my interest for both. These are all labor court seats, and I'm happy to go either way.
Thank you, Chief Justice.
Thank you, Commissioner Nyambi.
Just a follow-up on that one, Chief Justice, if I may.
Follow-up, okay.
Yeah. I see, Mr. Makura, that you are the only applicant for Gqeberha. Are you aware of that?
I have noted that, Commissioner Singh.
Thank you.
Yes.
Thank you.
Thank you, Commissioner Nyambi.
Afternoon, Mr. Makura.
Afternoon, Commissioner Nyambi.
In the letter of support, it specifies that you insist on making sure that you involve juniors in deliberations and decision-making. If you can share with us the benefit of that arrangement.
Thank you for the question, Commissioner Nyambi. That is a letter from my colleague that I work with. We work as a team. Throughout my career as a director, I've been very passionate about development, growth of young lawyers. I think that's one of the things he said there. I spend a lot of time going to the office, sitting with a number of junior professionals, guiding them. I ensure that almost every matter that I deal with, there is a junior professional, and not just as an administrative staff, but someone who basically runs the file. And I always encourage them that they should not come to me to ask what to do. They must come to me with a practical solution, and we take it from there. So I have, over the years, trained many professionals, and that has been my style, and I've been very deliberate about it. And I ensure that from the first-year candidate attorneys, they start drafting pleadings, and I do not mind spending times, many hours trying to settle the first draft, or after reading it, I ask them to go back and revise that, and that is part of training which I'm very passionate about.
Thank you, Mr. Makora. Thank you, CJ.
Thank you very much. Commissioners on the virtual platform, I didn't see any indication. I take it.
Questions. Thank you, Chief Justice.
Thank you very much. We have come to the end. JP?
Sorry, CJ, just one question. I see you answered that you've applied for Eastern Cape, but you've also applied for Johannesburg, isn't that?
Correct.
Is there any preference, anything?
He said he can go to any earlier on. He said it's up to the office of the Chief Justice.
I am based in Johannesburg, but I believe this body has been entrusted to determine where also those who are appointed, where they would be best suited.
Okay, thank you very much. We've come to the end of this interview, Mr. Makora. Thank you once again for availing yourself. You are now excused.
Thank you very much, Chief Justice, and all the commissioner. It's been an honor to be here and to be invited.
Thank you.
Thank you.
Thank you. Next candidate, please. Good afternoon, Ms. Mtalane. Please switch on your mic in front of you.
Good afternoon, CJ.
How are you this afternoon?
I'm well, thank you.
Okay, thank you very much for availing yourself for this interview. We appreciate it. I'm going to ask you questions, and commissioners will ask you questions as well. The whole purpose of our questions is to see how you meet or satisfy the selection criteria that this body has adopted for the selection of judges. We may be robust in our questions, but no one will be intending to humiliate you or demean you in any way. all we'll be doing is just to try and satisfy ourselves how you meet or satisfy the selection criteria. You understand?
I understand.
Yes. You hold an LLB degree, is that correct?
Correct.
It's a 4-year LLB degree.
Correct.
It's the 4-year one. Okay. Which you obtained in 2006, is that right?
Correct.
From Wits. You got it from the University of Witwatersrand?
Correct, CJ.
Yes. You served articles at Mkabela Huntley Attorneys, is that right?
Correct.
You were admitted as an attorney in 2008?
In 2009, January.
2009. Okay. And then you went then to be an associate at Cohen Harper Attorneys from 2009 to 2011. And then you were in Mabaso Attorneys from 2011 to 2013, is that right?
Correct.
And from 2013 to 2017, you were at Solomon Holmes Attorneys, is that right?
Correct.
And in you stopped working for Solomon's Homes in 2020, December, is that right?
Correct.
And then you became a director at Lawton's Africa, is that right?
Correct.
In January 2021. And it went up to 2023. Is that correct?
2022.
2022.
Oh, my apologies, CJ. 2023, February, correct.
Okay. Then at the moment you are not in practice. You are a group ER manager at PepsiCo. Is that right?
Correct, CJ.
What is ER manager?
Employee Relations Manager.
Oh, okay. So you started in 2023.
Correct.
I seem to detect a pattern here. From the time you were at Cohen Harper Attorneys as an associate up to now, you appear to stay only about two or 3 years in a place and leave and go for employment elsewhere. You see, you say here, from July 2009 to December 2011, you were an associate at Cohen Harper Attorneys. And then from January 2011 to February 2013, that's more or less 2 years, you were at Mabaso Attorneys. Then June 2013 to December 2017, that's about, 2.5 years, you were at Solomon Holmes Attorneys as a senior associate. And then from January 2018 to December 2020, you were at Solomon's as a director. So you were at Solomon's from 2013. Oh, no, it wasn't 2 years. It was 2 years in a particular position. From 2013 to December 2020, you were in the same place. Is that right?
Correct.
But the one relating to Cohen Harper, I'm right, from July 2009 to December 2011, that's about, is it about 2 years? You were an associate at Cohen Harper. And then at Mabaso Attorneys, also you were there for about 2 years or a year and a half, I'm not sure. At Solomon Homes, you stayed this from June 2013 to February 2023. not to December 2020. And that's about maybe 7 years, 6 years. And then you went to Lawton's Africa as a director, January 2021, and then you left in February 2023. And then you went to PepsiCo. So at Lawton's, you stayed for also about 1.5 years or 2 years, for about 2 years, January 2021 to February 2023. At PepsiCo, you arrived in March 2023, but you now want to leave to go to the labor court.
Correct.
That doesn't give one the picture of somebody who is stable. That gives the picture of somebody who is always looking for a better deal and will stay for a short time and then move.
I understand, CJ, why and how it appears so. However, there's an explanation for every move. The firms that I've worked for have all represented different interests and different parties. For an example, I will start with Nkabela Hanshi, that represented largely state-owned entities. And I wanted to move and do work for the corporate sector. Hence, I took the offer at Cohen Harper. And at Cohen Harper, I met Mr. Sandile Mbaso. I worked a lot against him. He represented unions, and he recruited me. And at the time, I also wanted to get a feel and experience of working for the employees and working with the unions. And I then moved to Mabaso Attorneys. And then I was recruited by Solomon Holmes, and the reason why I joined Solomon Holmes is because they offered me directorship and partnership. So they offered me a room to grow and to experience practice and running a business. It's also an employment law boutique firm. Therefore, I joined Solomon Holmes for those reasons, and I gained a lot of experience as a director and partner. However, because it's solely practiced in employment law, it was a challenge getting clients. Whereas at Lawton's, what they had, because they practice in different areas of law, I was able to tap into their clients in order to get work. And the reason why I joined PepsiCo is because practice, being an equity partner and a director, it just became challenging for me. And at the time, I was pregnant, and I wanted to be in an environment that was enabling, to enable me to care for my child, at least for those first couple of months until maternity leave.
Well, I didn't think that you would have left without having a reason to leave. Obviously, you would have some reason to leave. But it just seems to me to be too often. I mean, at PepsiCo, you arrived in March.
Correct.
At PepsiCo, you arrived in March this year.
Correct.
So in June, you were filling the form to send here already. They were still greeting you there. They were still greeting you.
I made it clear in my interview, and they are even aware that I am here today. I made it clear that my ambition was always to ascend to the bench. Hence, I stayed and served in practice for a very long time.
But if your ambition is to go to the bench, isn't the best way to remain in practice? Why do you leave practice if your ambition is to go to the bench? It seems to be to want to do one thing but do something that is the opposite.
Not so, CJ. My personal circumstances dictated that I take a break. It was not a permanent thing that I take a break from practice. It is quite challenging to be a partner, a director, a manager, a marketer, a marketing officer all at once in practice.
Do you know the workload in the labor court?
I'm very much aware, CJ.
Can you handle that?
It's not the workload that I'm afraid of.
What are you afraid of?
It's performing different functions at once. And at the time, as I said, I was looking for an environment that was enabling, as I had just given birth and I had a little child who is now 7 months old. Therefore, in practice, as a partner, you're not only just an equity partner, you are a director, you are a marketer, you are a manager, you train. But in the labor court, the work is more structured in the judiciary. If I may put it like that, you have one client, which is the public sector. There's no obligation on you to go out there and hunt for clients. You already have that. And all you need to do is your work. That's not how practice works.
Yeah. I see that in terms of actual practice, have you done any cases on your own, conducted trials?
I do all my motion proceedings, well, 80% of them, on my own. Trials, I would then instruct counsel, but motion proceedings, I do them on my own. I don't really instruct counsel in those matters.
And have you been appearing in the labor court a lot?
Yes, when I was in practice, I used to appear in the labor court quite a lot.
Mm-hmm. For motion courts?
Correct.
I see that at paginated for page 9, where you were asked to give a proportion of your work, what proportion of your litigation work has been in the field of criminal law, you say none.
Correct.
Administrative law, you say none. Consular law, you say none. Labor law, 100%. And it says other areas of civil law, you say none. Is that correct?
Correct, CJ. I've worked since I started my articles, I've always worked in employment law firms.
But it must be a disadvantage to you compared to other candidates if you really, all you know is just labor. You have not done anything else. Because when you sit as a judge there, it might be labor court, but principles that apply in other branches of law sometimes come up. And for example, here, administrative law, you said none. Some administrative law cases are dealt with in the labor court. So how are you going to handle those?
Correct, CJ. Or perhaps what I should have said is that I have done, for an example, constitutional law and administrative law on a limited basis, but insofar as it pertains to employment law matters.
Yeah, well, you were not asked here to give a proportion of various areas of labor law. You were asked
Correct, yes.
to indicate, it said, what proportion of your litigation work has been in the field of, and then they give all those fields. I mean, you must have an idea of how criminal trials get dealt with.
Most definitely.
You must have an idea how civil trials get dealt
Correct.
with. And so on.
Most definitely, CJ. It's not just an idea. I mean, I've done some in practice,
But your
not
questionnaire
much.
doesn't say that. Your questionnaire says none. The whole idea of this question is to give you an opportunity to share with the commissioners the breadth of your knowledge in terms of practice. What experience has your practice given you in the various fields? That's the purpose. That's why they say give a percentage. And your answer is none. And then when it comes to labor law, 100%. Are you saying that's not, it doesn't reflect the true position?
CJ, it doesn't reflect the true position, and I suppose I did not really think about it. Because, I mean, as a lawyer and an experienced lawyer with over 15 years of experience, I have worked on some constitutional matters, some administrative matters, but then again, within the context of employment law.
Yes. Page 12 says, 6.4, list all the reported cases in which you appeared as instructing attorney, and you have listed one. Is that right?
Correct. Whenever, yes.
But also that case, you have not shown that it is reported. The information you put there is information of an unreported case. Can you see that? The question asked you to give a list of reported cases in which you appeared as instructing attorney, and you gave a case, an unreported case.
Yes, I see that, CJ. CJ, as far as I can recall, this case is reported.
Yeah, but it doesn't help for you to not to reflect that in the questionnaire, because the question clearly says list reported cases. You understand? In the questionnaire, you are supposed to give us information that will help us assess whether we should recommend that you be appointed.
Of course.
If it says give us reported cases, and maybe you do have a reported case or reported cases, but you choose not to give us those, you give us something else, that creates difficulty, doesn't it?
It does.
So what would be the explanation for you for having given us information that reflected that the case is unreported, if in fact it is reported?
CJ, I'm looking at paragraph 6.4, right? Which provides list all the reported cases in which you appeared as instructing attorney.
Yes.
And then I go on and I list that case.
Yes, but it says reported cases.
Correct.
And you don't give information that reflects that this case is reported.
But, okay, now I understand. I'm with you. Okay.
Have you acted in the labor court?
Yes, I have.
For how long?
I acted for a week in January 2020, and again for a week in 2021, and I acted for a term in 2023.
Okay. Did you sit in motion court matters?
Yes, I did.
And did you do trials?
Yes, I did.
Okay. Did you give judgments on review matters?
Yes, I did, CJ.
What can you tell the commissioners about challenges relating to Section 157, giving the Labor Court and the High Court concurrent jurisdiction in certain matters?
Previously, the challenges were that litigants would, especially in the public sector, would often avoid the labor court by running to the high court and bringing their matters within, or couching their matters within PAJA. And since the case of Chira, that conduct has, we've seen a deterrence in that conduct. because Chira, in support of Section 157, has said that employment law matters fall within the jurisdiction of the Labour Court. And the Labour Court has concurrent jurisdiction with the High Court in matters that involve a constitutional issue. So those were the challenges before, but we have seen in practice that there has been a deterrent of litigants from approaching the High Court if a matter involves an employment law dispute.
If you are appointed to the Labour Court, you may be called upon to, or you will be called upon to preside in trials. Are you able to share with the commissioners what the requirements are that must be satisfied before you can draw an inference in a civil matter?
Yes, CJ.
Mm-hmm.
So an inference will be drawn on an inference will be drawn on a proven fact. If that is the only inference to be, sorry, let me just correct myself. So an inference will be drawn in circumstances where the only inference to be now I have a mind block.
Mm-hmm.
If there's no other reasonable, it will be drawn from proven facts. And if for those proven facts, there is no other reasonable inference to be drawn, but the inference that is sought to be drawn.
Mm-hmm. Remember, I said in a civil matter.
Yes, CJ, in a civil matter.
Mm-hmm.
There must be.
You know, the requirements are not the same if it's a criminal matter and if it's a civil matter. There's some difference. You appreciate that?
Correct, CJ.
Okay. So that's your answer for a civil matter?
Correct, CJ.
Okay. What are the requirements for a temporary interdict?
The requirements for a temporary interdict is that there must be a clear right. The applicants must be able to demonstrate a clear right, and the applicants must be able to demonstrate a reasonable apprehension of irreparable harm, and the applicants must demonstrate a balance of convenience, and of course they must be able to demonstrate urgency.
Mm-hmm. What are the requirements for a final interdict?
They are the same. It's a clear right, irreparable harm, but for a final interdict, the balance of convenience is not a requirement.
I will now give the opportunity to the Judge President of the Labour Appeal Court, to put questions to you.
Thank you, Chief Justice. Good afternoon. Ms. Matalane, you were informed about this affidavit which I received in a leave to appeal. You've indicated that you feel it might not be appropriate to deal with that, but I think there's nothing wrong in dealing with the important issues that's raised there.
Okay.
Unless you feel that it's not right, then let us know why, and then. But let me raise those things, what's said in that affidavit, because I think it's very important for you to deal with that. And it says in paragraph 5, the application was heard. This is the application you heard.
Correct.
On the 25th of January 2023. And this was the time you were working at Lawton's, but you were acting in the Labour Court.
Correct.
Right? And the judgment was delivered on the 3rd of March. At the time that the application was heard, Matalane was, despite the fact that she was acting as a judge of the above honorable court, employed by Lawton's Africa, who are the current attorneys of record for the respondent, Matalani only left the employer of Lawton's as of February 2023. Is that right?
Correct.
Then they say Matalani, in fact, represented the respondent in several employment-related matters during her employment with Lawton's, and I personally interacted with her on some of the matters she acted on behalf of the respondent. They go on to say, given her association with Lawton's and the fact that she had numerous interactions with the respondent and knew that the respondent was a client of Lawton's, she ought not to have adjudicated the application. It is contended that Matalane should have, in fact, recused herself and not adjudicate the application due to the reasons I have set out above. Now, the issue is, this was a client of Lawton's.
Correct.
You knew he was a client of Lawton's.
Correct.
You were an employee of Lawton's.
Correct.
You had interacted with this person before.
Correct.
Didn't you think it was improper to hear that case in which they were involved?
The applicant in that application it's a state-owned entity with a wide panel of attorneys. And at the time, Lawton's was not involved in that matter. Hence, I did not perceive there to be a conflict of interest in that matter. As Lawton's was not involved, they were not on record, we had not even drafted any opinions or advised the client in that particular matter. Hence, at the time, I did not perceive it to be a conflict of interest. However, in hindsight, I do acknowledge that I should have at least alerted the parties to that fact.
Why in hindsight? Why not at the time? Did you tell the parties that this applicant or respondent is a respondent with whom you've had interaction in other matters?
The particular respondent, the deponent to that affidavit was not involved in that matter as well. Was not at the time.
Maybe not him personally as a person, but the respondent is not an individual, isn't it the municipality?
Correct.
Yeah.
Yes.
So don't you think you had a duty to inform the parties?
Hence, I'm saying that in hindsight, that is what I ought to have done. That would have been the proper thing to do.
I have difficulty with that, but okay, let's move on. When you completed your questionnaire and you submitted your application, so to speak, you included a certificate of good standing.
Correct.
Now, we know that you left practice at the end of February, is that correct?
That's correct.
You started working for PepsiCo at the beginning of March.
Correct.
At that time, you were no longer in practice.
That's correct.
Did you remove your name from the roll of attorneys?
No, I didn't. I was not aware that I'm supposed to remove my name from the roll.
Did you read the certificate of good standing which you submitted with your application?
Yes, I did.
And what does it say in paragraph 2? It says that her name has not been removed from the roll of attorneys. She has not been suspended from practice, but you were not practicing, isn't it?
No, I was not practicing, but I'm still an attorney.
Sorry?
I'm still an attorney, but I'm not practicing. I was not aware that if you are no longer practicing, in fact, it's only been brought to my attention now. I was not aware that if you are no longer practicing, then you're supposed to inform the Law Society so you could be removed from the role of attorneys. It's my first time becoming aware of this.
And you did remove your name later from them?
I haven't because I was not aware.
Sorry?
I haven't yet because I was not aware. I'm only becoming aware of it today.
But did you remove your name from, or not yet?
Not yet. I was not
Then
aware.
why is it that the Law Society says that she is on the role of non-practicing legal practitioners?
I know I didn't remove my name.
Okay. Let's move on. Tell me, what can you tell me about derivative misconduct?
It's another type of misconduct where if an employer is seeking, which an employer can use when in charging employees who have witnessed the primary misconduct, but have failed to disclose or refused to disclose that primary conduct, or that to identify the perpetrators of that primary conduct to the employer.
Sorry, can you repeat that? I didn't hear that properly.
Okay, so derivative, it's a type of misconduct which is committed by employees who have knowledge of what we call or refer to as the primary act of misconduct, but who fail to disclose that to the employer.
Is that derivative?
That is derivative misconduct.
What does the Constitutional Court say about derivative misconduct? Do you know?
Yes, the Constitutional Court in Dunlop has said that, in fact, it has done away with derivative misconduct altogether. It said that there's no duty on the employees to disclose the identity of the perpetrators because the employer does not have the same duty. And furthermore, it said that the employer has recourse in that the employer can charge the employees with primary misconduct, and that the employer then should focus itself on that primary misconduct and not derivative misconduct.
You've read this judgment a long time ago, I assume.
No, not long time ago, probably I don't know, last year.
It says more than that. Eh? It says there's no duty on an employee
To
to
disclose.
report unless
Correct.
the employer gives them protection. And the employer has a reciprocal duty, is that not so?
Correct.
Then, do you remember the case of Edgars and Steenkamp?
Edgars and Steenkamp.
Edgars and Steenkamp, yeah, to do with it's a Constitutional Court judgment dealing with a claim made by the employees when they were retrenched to say the retrenchment was unlawful, and they sought certain relief in terms of the LRA. Do you know what was the...
It was
what
an
the judge-
unfair retrenchment case, and what the employees sought was compensation.
Sorry?
What the employees sought was compensation.
What did the Constitutional Court hold? Do you know?
I don't remember the
What
findings.
was the ratio? You know?
I don't remember the findings of the
You don't
Constitutional
remember
Court.
that. The Constitutional Court says if you bring a case in terms of unlawfulness, you can't claim for relief in terms of the LRA. Do you remember that? Okay. Now, just... I have nothing further. Thank you, Chief Justice.
Thank you. Just a follow-up. Ms. Mtalane, the complaint here is that in January 2023, you had this matter which involved the city of Tshwane, and Tshwane was a client of the law firm in which you were employed at the time.
Correct.
How could you think there was nothing wrong with sitting in a matter involving a client of your employer?
CJ, I had read the file, and at the time, there was no opposition in the file. The matter was unopposed.
Does
And
it
then
matter?
The matter was unopposed, the Rule 11 application at the time of my
Does it
perusal
matter
of-
that it's unopposed for purposes of the question whether you can sit in the matter? You are employed by Lawton Attorneys. This client, this litigant, is a client of your employer.
Correct.
How can you sit in that matter?
I did not perceive that to be a conflict of interest, CJ, because Lawton's Africa was not involved in that matter.
Yes, but this was their client,
Correct.
and you were still employed by them.
Correct.
You didn't even raise the matter with counsel.
Correct, CJ. Hence, I'm saying in hindsight, I should have raised it with counsel.
Minister?
CJ,
I do have a question, but I think I will defer to commissioners in case they ask
Yes.
the question.
Yeah, okay.
If they don't, then I will come back.
Okay, all right.
Thank you.
I haven't seen, Commissioner Dudovu.
Thank you very much, CJ. Good afternoon.
Good afternoon.
I want to traverse with you the matter where you presided. That is of Correctional Services versus Ngale. For me, the allegations about you are very serious. That you refused leave to appeal in chambers without the party's legal representatives being present. Can you speak to that a bit? Can you respond to that particular matter, please?
Commissioner, there may have been a mistake because I was not involved in that matter. I did research and I looked it up, and it wasn't one of my matters.
It means you were not a presiding judge on this particular matter.
Correct.
What the GCB is raising, it is far-fetched. It's not existing.
It's not correct, Commissioner.
Do you understand the repercussions of this in case that it is found that indeed you presided over this particular matter?
I understand, Commissioner. I've done my research, my thorough research, and I can tell you I was not involved in that matter.
Okay, thank you very much. Thank you, CJ.
Thank you. Commissioner Baloyi.
It's not so much, good afternoon. It's not so much a question, but to clear up, to assist clearing up an earlier discussion that you had with the JP. And it's about your being on the roll of attorneys, even after you left practice, that the correct position, in fact, is if you're not in practice, you go on to the non-practicing attorney's role without a requirement that you should remove yourself from the role of attorneys.
Thank you.
That is correct.
Thank you. Commissioners on the virtual platform, I didn't see any indication. I think there is none.
Nothing from my side.
Thank you.
Nothing, thank you, Chief Justice.
Thank you. We have come to the end of this interview, Ms. Mchelane. Thank you very much for availing yourself. You are now excused.
Thank you, Commissioner.
Next candidate. Good afternoon, Mr. Mtombeni.
Good afternoon, Chief Justice.
How are you this afternoon?
I'm fine, thanks, Chief Justice.
Yes. I haven't seen you in a very long time.
Yes, Chief Justice, it's been a while.
Yes. Well, I told the commissioners that you and I served articles in the same law firm in the 80s.
That's correct.
At Channels Alberta, and I see you have included them there on page 4 of your paginated questionnaire. But since then, I think maybe I've bumped into you only once in probably 30 years, more or less, over 25 years.
Yes, Chief Justice, I think we bumped into each other twice. Once it was on a flight.
Yeah.
On the second incident, I think it was a labor law conference in Durban.
Oh, I think you probably have a better memory than me.
Yes.
No, thank you. Let me welcome you on behalf of all the commissioners to this interview. Thank you very much for availing yourself to be considered for appointment as a judge of the labor court. I will ask you some questions, and thereafter I will allow commissioners to also ask you questions. The questions we will ask you will be aimed at satisfying ourselves how you meet the selection criteria that this body has adopted for the selection of judges. In the course of questioning you, we may be robust, but nobody here has any intention of humiliating you or demeaning you in any way. You understand that?
I do, Chief Justice.
Yes. You hold a BProc degree, an LLB degree, and 2 LLMs and a postgraduate diploma in labor law. Is that correct?
That's correct, Chief Justice.
And you got your BProc degree from the University of Zululand. Is that right?
That's correct, Chief Justice.
And then your LLB at the University of Natal.
That's correct.
Is that right?
Yes, that's right.
I'm looking at what you have written here, but
It's correct,
I must
Chief
confess
Justice.
your handwriting is not, it could be better. What I see, it looks like University of Natal, is that correct? But you seem doubtful.
It's correct, Chief Justice. I think I'm in a wrong profession. I should have been a doctor. That's what they would always say if a person has got a bad handwriting.
And then you got your LLM from the University of London.
That's correct, Chief Justice.
The first one, and the second LLM you got from Columbia University, is that right?
That's right, Chief Justice.
And the postgraduate diploma in labor law you got from what used to be called the Rand Afrikaans University. Is that right?
That's right, Chief Justice.
Yes. Did you get admitted as an attorney at some stage?
Yes, I got admitted in 1989.
1989. 1989.
Yes.
And did you practice for quite some time as an attorney?
Yes, I did practice. When I was a lecturer at the university,
Yeah.
I was practicing, we're allowed to practice. I was practicing on a part-time basis.
Yeah.
And when I left university, I joined the CCMA, and during that period...
Can I ask you to speak up so that everybody will hear your answers?
When I left the university, I joined the CCMA, and I was not allowed to practice. After my stint at the CCMA, I went into private practice until I joined the bar.
And how long were you at the CCMA?
I was at the CCMA for 2.5 years.
2.5 years.
Yes.
And were you full-time?
Yes, I was full-time.
What level of a commissioner were you?
Initially, I was appointed as a level 1 commissioner. Thereafter, I was appointed to KwaZulu-Natal as a senior convening commissioner.
Yes.
I was recalled to head office where I was appointed as the national senior commissioner.
Okay. Okay, but you say you were there only for 2 years?
Approximately 2.5, 3 years.
Oh, okay, okay. And did you do arbitrations as a CCMA commissioner?
Yes, I did, Chief Justice.
Yes. And your practice, all in all, how many years would you say you practiced full-time as an attorney?
Approximately, Chief Justice, excluding the years when I was at the CCMA, it would be about 17 or 18 years.
Yes.
Yeah.
And how diverse was your practice in terms of different branches of law?
It was diverse, but the bulk of my practice was on labor law. We had matrimonial matters, criminal law. Yes.
So you did labor law and criminal law?
Yes, and the matrimonial matters.
Yeah.
Yes.
Okay. Were you practicing on your own?
I was the senior partner practicing with other attorneys and candidate attorneys.
Yeah. Okay. And how long did you teach at, you taught at Vista University, is that correct?
That's correct, Chief Justice.
How long did you teach there?
For 6 years.
6 years?
Yes.
What courses did you teach? Did you teach labor law?
I was teaching labor law and commercial law.
Yes. Okay. Now, apart from, or did you appear in the labor court, or do you appear even now in the labor court?
Yes, I appeared and I'm still appearing.
Sorry?
I'm still appearing, Chief
You are
Justice.
still appearing?
Yes.
How regularly do you appear in the labor court?
On average, I would say maybe once after 2 months.
Yeah.
Yes.
Do you conduct trials there and appear in motion court as well?
Yes, I conduct trials. I appear in motion courts for reviews. And I also appear for agent matters.
Yes. I see that at page 9, paginated 9 of the questionnaire, you were asked what proportion of your litigation work has been in the field of criminal law. That looks like 5%, is that correct?
That's correct, Chief Justice.
Administrative law, 15%.
That's correct.
Constitutional law, 0%.
Yes, that's correct.
Labor law, 80%.
That's correct.
And then it says other areas of civil law. Then you said commercial law.
That's correct.
But when you add 80 plus 15 and 5, don't you have 100% already? Can you see that?
It's 95. 95.
Is it 95?
Yes. 15 plus 80.
15 plus 5 is 20, isn't it?
Yes.
And then plus 80.
It's 100%, that's correct.
Is 100.
Yes.
So where do you get commercial law from?
In retrospect, I see that there's no room for commercial law.
Yes.
I accept that, Chief Justice.
Yes. Okay.
Perhaps if commercial law was also included there, I think I would have allocated a percentage to commercial law.
1% or 2%.
I would say 5%.
5%. Okay, all right. You have acted in the labor court, you said. Eh?
Yes, Chief Justice.
How long have you acted in the labor court?
Chief Justice, I cannot give you a figure, but I acted on a pro bono basis, I think 3 times, and it was 2 weeks each.
Please speak up so that we can hear.
Yes, I acted on a pro bono basis. I think it was for 2 weeks.
Yeah.
On each occasion. Thereafter, I was invited to go and act. I acted for a month and a half.
Yeah.
Yes, it was not a full term.
Mm-hmm. Oh, when was that? Which year?
That was in 2016.
2016?
Yes.
Okay. So the one time you were acting pro bono, the other time it was not pro bono?
Yes.
Okay. How did you find it?
Chief Justice, I really enjoyed it.
Yes.
In particular, most of the judges I know, and there was a lot of collegiality.
Mm-hmm.
I was familiar with a lot of them.
Mm-hmm.
Besides that, throughout my legal career, I've been an adjudicator
Mm-hmm.
in arbitrations, disciplinary inquiries, and I really enjoyed being an adjudicator.
Yes.
At the labor court.
Yes.
Yes.
Okay. What can you tell the commissioners about challenges that arise from the fact that the High Court and the Labor Court have concurrent jurisdiction in regard to certain matters?
Yes, Chief Justice. Initially, prior to the judgment of the Constitutional Court, I think that is Baloyi versus the public protector, there was a lot of forum shopping. And as a result, there was uncertainty about which court actually has jurisdiction. But the Labor Relations Act grants exclusive jurisdiction to the labor court. However, that is not unlimited because in Baloyi, the Constitutional Court stated that in respect of rights that are entrenched in the Constitution, in respect of those disputes relating to those rights, the High Court and the Labor Court has got concurrent jurisdiction.
Yes, but I wanted you to tell me, maybe I should say, well, since you are saying after Baloyi there are no longer any problems, what were the problems that were there before Baloyi?
As I said earlier on, Chief Justice, it was forum shopping.
Mm-hmm. What types of cases were the subject of forum shopping? What types of cases were not the subject of forum shopping?
I'll just mention cases where the High Court did not have jurisdiction, like a purely employment matter. And then a party will approach the High Court. And the High Court may rule that, no, it hasn't got jurisdiction. This matter must be heard by the Labor Court. I'm thinking of such cases, Chief Justice, and vice versa.
Okay. What are the requirements for an interim interdict, temporary interdict?
Chief Justice, there must be a prima facie right. There must be a well-grounded apprehension of harm. There must be a balance of convenience, and finally, there should be no other satisfactory remedy.
Is that all?
Yes.
Okay. What are the requirements for a final interdict?
Chief Justice, there must be a clear right. There must be a reasonable apprehension of an injury. And finally, there should be no other satisfactory remedy.
If you get appointed to the labor court, you will deal, among others, with trials. Are you familiar with the requirements which must be met before you can draw an inference in a civil matter?
Yes, Chief Justice, in a civil matter, when as a trial of fact you are required to draw an inference, you've got to look at the totality of the evidence and look at the proven facts. Thereafter, you may find that there are a number of inferences. A duty of the trial of fact is to choose an inference that is most reasonable on the proven facts. That is contrary to norm, where it must be the only inference, which is a standard in the criminal matters.
I will now give the Judge President of the Labour Court and Labour Appeal Court an opportunity to put questions to you.
Thank you, Chief Justice. Good evening, Mr. Mutombeni.
Good evening.
You know, you last acted in 2016, I remember. But what happened to you after that? You haven't appeared very much, either in the Labour Court or Labour Appeal Court. Have you?
That's correct, Judge President. I have made myself available. The judges who are responsible for...
Please draw the mic closer to you so we can hear you.
I have made myself available, and the judges who are responsible for inviting acting judges are aware of that. However, when I was approached, I'll be having matters and I would not be available. And sometimes I'll be available, but at the last moment, I'll be advised that opportunities have been granted to practitioners who have not acted. And recently, the acting deputy judge president approached me for this term. And again, I wasn't available.
Yes, and that's why I'm asking, because since 2016, there have been at least 3 or 4 times that you've been contacted and
That's
asked
correct.
and approached to come and act, but you've never been available. But at the same time, we haven't seen you in court, so you must be busy with other practices.
Yes, like I said, I used to be quite very busy, but recently, like I said, on average, maybe once a month, yes, I've been busy with other matters, Judge President.
You do know that if you get appointed now, if you are recommended, that you will have to be to serve for at least 10 years, till the age of 75, you know that.
Yes, I'm aware, Judge President.
Okay. Tell me, have you been keeping in touch with the development of labor law? Because although you say 80%, my problem is that 80% might not be all court work. But if it's labor work, then you should be up to date with what's happening, because the labor world is so fluid, it's changing every day, every week. So have you been keeping abreast with developments?
Yes, that's correct, Judge President, I have been.
Thank you. Tell me, until recently, derivative misconduct was a big issue. It's still a big issue. Or the Constitutional Court has said how to apply it and not readily to grant such misconduct or agree to such misconduct. Do you know what is derivative misconduct and how it's applied, and what did the Constitutional Court say about that?
Yes, I do, Judge President. It's a concept that was developed by the courts when there were difficulties in identifying wrongdoers in group misconduct. Now, some people, part of the group, could have been in proximity of the wrongdoing. Not everybody may be responsible. Now, what happens is this: if there are some people, some workers, who were aware of the wrongdoing and they refuse to disclose to the employer, then they may be guilty, but they may not be guilty of the primary gross misconduct. They are guilty of a derivative misconduct, which is a breach of their duty, their fiduciary duty to the employer. Now, the Constitutional Court in Dunlop laid down the factors that should be taken into account. Sometime since I've read the judgment, but all in all, is that the people should have been present, and they would have refused to disclose the perpetrators, not because of their innocence, but because of their guilt. And the court also stated that not all the employees have a fiduciary duty to the employer. And those who do not have fiduciary duty to the employer may not be charged for derivative misconduct.
All right.
That's all I can report, Judge President.
That's fine, thank you. Thank you, I have no more questions.
Thank you, Minister. You are covered. Thank you. Commissioner Baloyi.
Good afternoon, Mr. Mtombeni.
Good afternoon, Commissioner.
Yes. Mr. Mtombeni, in your application, if at page 7 in that questionnaire, you were asked about whether any of your writings have been referred to in judgments, and you answer that you say have been cited with approval, and then your answer is insufficient time to do research to locate relevant decisions. Now, I don't understand this answer, because you have a month from the date that the JSC advertises for positions and you submit your application. I don't understand that answer, and I'm raising it with you because there's a particular theme that I think has emerged, and I will talk you through it. You may want to deal with this. How come you don't have time to research this? The question is asked, it's obviously important for the JSC to be aware of it.
Yes, Commissioner. I am not aware of decisions where my research work has been quoted.
You didn't say I'm not aware, you say I haven't had enough time. That's that part that I have a difficulty with.
Yes, Commissioner, if I had been aware I would have answered. But because of time constraint, I did not have some time to do research and find out in which decisions where my research has been referenced.
But you had a month to complete this application. What do you mean you didn't have time? It's that bothers me.
I understand that, Commissioner, but there were also other activities that I was involved in. I also focused, I focused my attention on the application. Yes, because it's very important to me. But there were some constraints, like I didn't have enough time to look at court decisions where my work was referenced.
Okay. In similar vein, a second issue arising from your application, at page 9, under question 6.3, you are asked which cases in which you have appeared would you regard as being the most significant and why? And you refer to the matter of Prasa versus NC Mulepo. And then you say the significance of it is that the court ordered the CEO and his attorney to pay costs, and then judgment cited with approval in subsequent cases. Now, I've looked at that judgment. The cost order, the bonus, is against the attorney, not the CEO. The CEO is not mentioned in that order. And that is the judgment of Moki, AJ. You refer to the, is this a mistake that you refer to the CEO?
Commissioner, I understand the question. However, there could be another judgment, because I recall that the CEO was ordered to do so. Instead, the CEO did not pay, Transnet paid, because this matter, I could have referred to, cited that, but there were also other cases. I could have made a mistake by not citing the correct one, but both the CEO and the instructing attorney were ordered to pay costs. And it was also in the news. It was covered that the CEO was ordered to pay costs. Instead, Transnet paid. The CEO didn't pay.
Yes, you say Prasa versus Mulepo, so one works with what you have given us.
Yes.
And I'm saying to you that the Transnet versus Mulepo matter orders costs, you're correct, because the bonus were ordered against the attorney, but that's as far as it goes. But the other thing that concerns me here is it doesn't appear from this judgment that you were present in the matter. There's absolutely no reference to you here.
Commissioner, I appeared, and I heard the Commissioner referencing the Transnet matter. I did not appear in the Transnet matter. I only appeared in the Prasa matter. And it's correct that Acting Judge Muki was presiding.
So it is the correct matter, the Prasa matter with Muki?
Yes.
So I'm looking at the right judgment?
Yes.
Okay. And then lastly, I heard you agree with the JP that you last acted in 2016.
Yes.
Okay. And again, I mention this because I'm concerned that things that you have put don't seem to suggest that you've really looked at this seriously when you completed this application. I'm looking at your judgment in the matter of Janssen versus Legal Aid, and you've indicated there that that matter was heard in June 2017. Now, when you're completing this form, where you indicate you last acted in 2016, and when you appear and you're sitting there and you agree with the JP that you last acted in 2016, and yet there's a judgment here that you have referred to in your application. It's in fact heard, according to you, in June 2017. That sort of suggests to me that in applying yourself or in completing this application form, you didn't really give it proper attention. Is that not a fair statement?
No, Commissioner, I would disagree. I last acted in 2016, that's correct. However, if there's any reference to 2017, will the Commissioner refer me to that page?
It's your judgment. You have referred to the judgment.
Yes.
You recognize the judgment.
Yes, I do recognize
it's
the
Janssen versus Legal Aid South Africa. You recognize that?
I do.
Now, I've looked at the judgment. You didn't provide us with a copy of the judgment, and I've looked at the judgment, and I have it open here in front of me. And it says the matter was heard on 26 June 2017, and judgment delivered on 16 May 2018, in fact.
Commissioner, I did finish the JSC with a copy. And my answer when I said I last acted in 2016, I was appointed in 2016. The matter was part heard, and then you're correct that it was completed in 2017. That's what the judgment states. But my appointment to act was in September 2016, and the matter was part heard. I sat in that matter, I think, on 3 occasions, and it was finalized in 2017. That's why the judgment states 2017.
Okay, lastly, just to put it to rest, the very copy of the judgment that you've provided us with says the matter was heard on the 26th of June 2017 and judgment was delivered on 16 May 2018. That's a judgment that you've given us.
Yes, I think they're referring to the last day.
Okay. Thank you, CJ.
Well, I'm also seeing this, Mr. Mtombeni. That judgment, and I'm at paginated page 31, when it starts, it doesn't say that this was a trial. It says this is an application. So you were talking about part head. It says this is an application. It doesn't say a trial. And there is no indication, as far as I can see, that it had been had on any other day other than the day that is reflected there, because the normal thing is that if a matter has been had on a number of days, is that all those days would be reflected on the judgment to say these are the days on which it was had, and then the date when judgment was given. Here there is only one day given, 26 June 2017, and delivered 16 May 2018. There is no indication anywhere that it was had on more than one day. And as I say, unless I'm missing something, it doesn't look like it was a trial.
Chief Justice, it does look like it was a trial because the order that is given is an absolution.
Yeah, okay, so maybe it was
I think it's just wrong at the beginning when it says it's an application. It should have been a claim or a
referral.
A referral under the Act.
Yeah, because when you say application, the normal understanding is that you are talking about an application on affidavit,
Yes,
isn't it?
Yes, page 49.
And some matters in the labor court are heard as motion matters, but they are trials. And I'm trying to see here whether there is any part that talks about any oral evidence.
Yes.
It is there.
That's from page 33.
Oh, okay.
I mean, it still doesn't answer the question about when it was heard, but at least we know that it was a trial.
Yeah. Well, there are two issues that I wanted to raise about the same judgment. One is that it seems to, if it is true that it was heard on one day, which is 26 June 2017, and was handed down on 16 May, that means it took you about 11 months to hand it down. On the face of it, it doesn't seem to have been a complicated matter. Is that right? Or was it a complex matter?
Yes, Chief Justice, I was anticipating this question because
Yes.
I think one of the law bodies, I think the GCB, they've commented on it. Upfront, Chief Justice, I accept responsibility. I do not have any defense that I can use. All I can say is that this matter was challenging. It was, in my view, complex. And there were other factors which contributed to the delay. There was a record. This matter was heard in Cape Town, and I'm based in Johannesburg. There was a record. Whenever there's communication or submission of documents, they first submitted to the Labour Court in Johannesburg, and my clerk will inform me that the record has been delivered, and I'll make arrangements that either it's dropped off at my chambers or I collect it. And it took time for the record to come to Johannesburg.
Yes.
Yes. I'm not using that as an excuse.
Yeah.
Perhaps I could done things differently and pressed for the record to be submitted.
Okay.
And another factor is practice.
Yeah.
I'm not using that as an excuse. In retrospect, I would have done things differently. So
Yeah.
this also impacted on my practice. And that is one of the causes of the delay.
Yes.
So I'll say briefly, the communication between Cape Town and Johannesburg regarding the record and other documents
Yes.
was one of the delaying factors. And in my view, the matter was challenging and complex. And, and in addition, my practice also contributed to the delay. But as I said, that upfront, I accept
take responsibility.
Yes. In retrospect, I would have done things differently.
Yeah. Well, the last question arising for me here is, I see the order you made there, apart from dismissing the application for absolution, you declared the dismissal of the applicant to have been automatically unfair, and you declared that the respondent had unfairly discriminated against the applicant in terms of Section 6 of the EEA. Then you ordered the respondent to reinstate the applicant with full retrospective effect. Can you see that?
Yes, Chief Justice.
That would be an order that would mean that the employer mustn't just reinstate the employee or take him or her back. It would also be that from the date that the employee had been dismissed up to the date of reinstatement, the employer must give the employee full back pay and other benefits, isn't it?
That's correct.
But I then see that in number 5 of the order, you order the employer to pay the applicant compensation equivalent to 6 months' salary, calculated at the applicant's rate of remuneration on the date of dismissal. So the employee would get paid twice. Was it competent to make an order for compensation in circumstances where you have ordered a reinstatement with full back pay, or was it not competent?
Chief Justice, there were two claims. That the first one was the automatically unfair dismissal.
Yes.
And I make an order in respect of that claim. And then there was also the unfair discrimination in terms of the Employment Equity Act. And I ordered compensation in respect of the second claim.
Now, what was the basis of the unfair discrimination claim, was it not the same as the basis for the automatically unfair dismissal? Oh, I'm just asking. What was the basis? Was the basis not the same?
No, it was not the same according to the evidence and the pleadings.
Yes. So what was it in regard to the dismissal?
It was automatically unfair because the applicant was dismissed for his mental health, or to put it differently, for mental illness.
Oh, is that one of the grounds in terms of Section 1871 that renders a dismissal automatically unfair?
Chief Justice,
in terms of the LRA?
Chief Justice,
I don't seem to have remembered it, but the law may have been amended, and I might not be aware.
No, that I must just be upfront that I haven't looked at this this judgment closely, quite closely recently.
Mm-hmm.
Like when you put this question to me, I was a bit reluctant to answer it correctly because I just needed to look at it closely and then answer appropriately.
Mm. Well, but of course you know that when you give us judgments that you say support your candidature, you are supposed to familiarize yourself, refresh your memory on them because you may be asked on them. You appreciate that?
I appreciate that, Chief Justice. Could have been an oversight. I appreciate that.
Because when you leave the interview with questions that have not been answered, it can't be something that is positive in favor of your candidature if you are not able to answer certain questions because you didn't prepare on judgments that you gave us. You understand that?
Yes, I do, Chief Justice.
Yes. Okay.
Chief Justice, just want to follow up on this case.
Thank you.
Mr. Mtombeni, what I couldn't work out with this judgment of Janssen is the process that you followed, because it looks like in the same order you dismissed an absolution and then granted relief, which is a very strange, it's a very strange order, you know, because and there's no way in the judgment which shows the case actually being closed, the case of the defendant being closed. So I couldn't work out how you could dismiss absolution and then grant relief.
Commissioner Ngubaitu,
actually, that's important.
Yeah, Commissioner Ngubaitu, like there was a point in limine that was raised, and I had to make a ruling, and it was on owners. After the Labour Appeal Court dismissed or overruled me, then I realized, and there's also a mention that the question of owners was not properly addressed, and I admit that. So when I made a ruling on that point in limine, I said the employer has got owners. And then when the time for the employer to come and testify, the employer said they're applying for absolution. And then I did not grant absolution. And then
That's what I mean. I understand all of that. What I'm saying is that absolution is granted, and then the case must be closed. And there's no way in the judgment where the case is closed. So that's what I couldn't work out. I've never seen a case where absolution is granted and then relief is entered against the defendant.
Just a moment, Commissioner. Like I said in my order on page 49, the application for absolution was dismissed. Yes,
Yes, but what Commissioner Ngwaitobi is raising with you is when an application for absolution is made, when you dismiss it procedurally, what's the next thing that should happen?
Well, the matter is closed.
By who?
Because the absolution has been dismissed.
Yeah, who closes the matter?
Perhaps, Chief Justice, I'll ask Commissioner Ngwaitobi to put the question again to me, because...
No, I think it's fine. I mean, we are spending a lot of valuable time on this, but anyway, thank you.
Okay.
I seem to be mixing a lot of things here.
Thank you very much. I don't know if I've asked the commissioners on the virtual platform. I think I did.
No question.
No question.
Thank you very much, Secretary.
Thank you. We have come to the end of this interview, Mr. Mtombeni. Thank you very much for availing yourself. We appreciate it. You are now excused.
Thank you very much, Chief Justice. I would like to extend my thanks to the Judicial Services Commission for inviting me to this interview.
Thank you.